Give all memos. Ella criminal petition.
My lords,
Give all the data.
report.
Fresh matter. If it has come, it won't come again.
Lords, parties are report.
Huh?
He was not keeping well.
So?
Admitted in hospital. That's what he got from before.
We'll see. Yes.
My lords, parties are reporting for settlement, my
1
lords.
minute. Fresh memos ಎಲ್ಲ ಆಯ್ತಾ? Settlement ಯಾವ ಇದೆ ಎಲ್ಲ ಕೊಡಿ.
My lords.
All settlement memos, please give. All pending memos also give.
My lords, parties are reporting for settlement, my lords.
Not say give memos for reporting settlement. Yes. Pending or fresh, sir? Pending or fresh? Give. Monday or Tuesday it will come, give it. Yes. Kodi, Monday kodi. Monday kodi. Yes. Madam, vacating state the word. Other every Tuesday, Wednesday, Thursday, they'll come 5 matters, give it. Yes. Settlement. Kodi, 2:30, yes. Am I not coming? Wait, sir. Fresh idre kotbidi alla, don't even wait. Give it, sir. It will come, sir, give it. Come, give it. Previous week ಎಲ್ಲ ಕೊಟ್ಟಿರೋದು seniority ಮೇಲೆ ಬರುತ್ತೆ. ಕೊಡಿ fresh matters ಎಲ್ಲ. Give, sir. Sorry? So what? Trial ನಡಿಬೇಕಾದ್ರೆ ನಾನು interfere ಆಗಲ್ಲ. No, sir. Yes. Give it anyway. If it's fresh, give it. Settlement memo kodi, sir. Whenever you want. Defamation. Tomorrow or Monday. Monday. Yes. Settlement kodi, sir. Yes.
I don't think.
If it is not in the cost list, it is not listed. Yes. ಅಲ್ಲಿ ಬರ್ತಾ ಇದೀನಿ ತಾನೆ. Don't you have any discipline? Wait. First time ಬರ್ತಾ ಇರೋದು ಕೋರ್ಟ್ಗೆ. First time ಬರ್ತಾ ಇರೋದು ಈ ಕೋರ್ಟ್ಗೆ. ಮತ್ತೆ wait. Yes. No problem. Monday only. Give it, yes. 2:30 ಯಾಕೆ? So what? So what? Monday. Yes. Tomorrow, why? Why? No problem. Monday, yes. Fresh matter adu. Monday, yes. Give it, yes.
Offense is 307.
Fresh up pending, sir.
96 years. And the complainant is insane. Or is declared insane. Offense is registered. Second complaint on the same cause of action.
Kodi. 96 years old tomorrow. Give it. Yes.
Fresh matter.
2020 ಈ ಕೋರ್ಟ್ಗೆ ಬರಲ್ಲಮ್ಮ, ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು. Yes. Tell me. I don't know what WP is it, fresh or pending? No problem. Give it, yes. No. No, sir. Give it. If there is no interim order, you can't do anything. So what, sir? Is a fresh matter. Notice was issued once. All right. Give it. So what? Give it. Yes. No problem, sir. There are 10 time memos being moved. Give it. Yes. I can't take 500 matters every day. Give it. What to do? We'll see, sir.
Fresh matter is there for framing of charges on Tuesday.
Framing of charges. Till now, what were you doing?
Because we did the.
Monday. Fresh matter. Monday, yes.
My lord, in this matter.
ಯಾಕ ಈಗ ಬಂದ್ರಿ? ಕಡೆ ಬನ್ನಿ. ಎಸ್.
In this matter, my lord, the non-criminal offence FIR is registered, my lord. The petitioner sir suspended. We have approached the case.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆಯಾ?
Charge sheet ಆಗಿಲ್ಲ. FIR.
Monday.
My lordship,
Monday or Tuesday, it will come according to seniority.
it's a fresh matter, my
Lord.
lordship.
Ah.
Respondent have filed a 498
So what, give it, yes,
Please, my lordship. On
Lord.
Monday, my lordship.
we'll see. Yes.
The petition is filed in agreeing by the orders passed under section 91,
Fresh up pending, sir.
fresh matter. The matter
ಕೊಡಿ.
is stayed.
Stayed,
ಆಗಿದೆ,
fresh
but-
ಹೆಂಗಾಗುತ್ತೆ?
ಅಂದ್ರೆ the
Vacating
accused
stay
are-
ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ,
ಮತ್ತೆ?
ನಾನು for the petitioner.
Then what?
Accused with this 498A is not been getting a job. I filed a memo on
ಆಯ್ತು, next week ಕೊಡಿ.
Tuesday.
No, not date, yes. ಹಾ, ಅದ್ ಹೇಳಿ, ಏನ್ ಬೇಕು ಈಗ? ಏನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ? ಏನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ? 482 ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ? 483 ಏನೇನೋ ಮಾತಾಡ್ಬೇಡಿ, ಕೊಡಿ. ಎಸ್, ಮಂಡೇ ಕೊಡಿ.
My lord's fresh matter. My lord's fresh matter. Charges are being praised in the trial court, my lord.
What were you doing till
Matters
now?
are already
Give it. Monday or Tuesday they'll come, give it.
Parted matter, return of document.
ಹಾ, ಕೊಡಿ ಅದು. ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್.
Madam.
Give all the fresh matters, please. Don't make a mention. Tomorrow I am not going to take anything. Give it. Give all the fresh matters.
Fresh matter.
Give all the fresh matters.
My lord, sir.
Give it, sir. Warrant early, early. Give it.
My lord's petitioner is aged about 70
Give
years.
all the fresh matters. Give, sir, fresh matters. Yes.
My lord's petitioner is aged about 70.
ಪರವಾಗಿಲ್ಲ ಸರ್, ಕೊಡಿ ಎಲ್ಲ ಫ್ರೆಶ್ ಮಾಡಿ. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
Stay vacating is from 22 to 138 matter.
ಮೇಡಮ್ ಅದು ತಗೊಳ್ಳಿ, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ.
My lord's petitioner is aged about 70 years and a criminal case is
Matter.
fresh matter. my lord's.
ಕೊಡಿ ಸರ್. Give the fresh matters. Yes, give all the memos. No dates in fresh matters, please give all the memos. Monday or Tuesday, they'll come according to seniority.
My application to assist the prosecution has been dismissed. Trial is continuing without my participation.
No
my
problem,
lords.
give it, yes.
Request the court to direct it for Monday, my lord, kindly.
It will come Monday or Tuesday, it will come.
June and August.
ಅಷ್ಟೇ ಎರಡೇನಾ? ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ ಪರವಾಗಿಲ್ಲ. Yes,
This is a pending matter. Pending matter, your lordship.
wait, Dhanesh.
Detailed for complaint is from further investigation application.
Stay ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ. ಈಗ in respect of 173 surplus 8 ಮಾತ್ರ ಸ್ಟೇ ಆಗಿದೆ. ಅಲ್ಲಿ ಸ್ಟಿಲ್ ಟ್ರಯಲ್ಸ್ ಮುಂದುವರಿತಾ ಇದೆ. ಇನ್ನು ಸ್ವಲ್ಪ ವಿಟ್ನೆಸ್ ಆದ್ರೆ ಕೇಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೋಗ್ಬಿಡುತ್ತೆ.
ತಗೊಳ್ಳಿ ಮೇಡಮ್.
ಸೊ ಕೈಂಡ್ಲಿ
ಯಾವತ್ತು ಬೇಕು?
ಮಂಡೇ
ಮಂಡೇ ಆಗಲ್ಲ. ಮಂಡೇ we'll post it. Tuesday or Wednesday ಹಾಕಿ ಮೇಡಮ್. ಅದಕ್ಕೆ application ಹಾಕಿರೋದು ಕೊಡಿ ವೀಸಾಗೆ. File an application for consideration.
Lordship 24
Don't
matter.
quash the proceedings.
Your Honor, it's a fresh matter, but
Give it.
it's listed.
Lordship, matters of year 2023. There's no interim order in this matter, your lordship.
Give
Lordship,
it, give it. Yes,
the
it will come,
complainant has
give it.
initiated DLSA proceedings.
Wait. If it has come once before me and interim order is not granted, it will
Lordship,
not come.
FIR is registered in 2023 of
No, it
February.
will not come again
Also
for
filed.
consideration of interim prior. It will come in admission.
Matter was supposed to be listed yesterday, my lord. And my last memo ಮಾಡಿದಾಗ ನೆನ್ನೆ date.
Pending matter.
Fresh matter, my lord.
ಕೊಡಿ.
After 3 round of
Monday.
litigation, please.
Covered matter, offences 376 and 475.
ಎಲ್ಲತ್ತು covered sir. Fresh matter.
Fresh matter.
ಕೊಡಿ. Give all the fresh matters. No date, give it, sir. Why?
Petitioner's advocate, my lord, allegation is that
So what?
he sought for NOC. NOC is given.
Monday or Tuesday it will come.
My lord, my lord, one of the petitioner, his senior advocate has undergone heart operation, my lord.
ಆಯ್ತು ಕೊಡಿ.
Despite that, there's two
Tomorrow.
cases registered by two,
Tomorrow.
please.
My lord.
Yes, Dhanesh.
Your lordship had given 14 August.
ನಿಮ್ ಕೇಸ್ಗಳ
Vacating stays.
ಮೇಡಮ್ ಅದು ನಾಳೆ
14/9 ಅಂತ ಆಯ್ತು, 3 weeks passed by.
ಆಯ್ತು, ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್.
My lord, pending case, my lord. Notice is issued. Yesterday it was posted, my lord.
Huh?
Yesterday it was posted. My lord, my lordship not granted this stay, my lord.
Correct.
On the observation that there is 65B, my lord. 65B, my lord, only taking Mahazar. That
No, I have not granted stay. I will not grant stay in that. I have issued notice.
my lord, it is covered by judgment. my lord.
No.
Petition. ಅಲ್ಲಿ ಮಹಾಜರ್ ಮಾಡಿದಕ್ಕೆ ಫೋಟೋ ತಗೊಂಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ 65B ಅಫೆನ್ಸ್ ಇದೆ
yes.
ಅದಕ್ಕೆ ಒಂದು
Yes.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದು
No, sir. Yes.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
Notice ಮಾಡಿದೀನಾ?
ನೋಟಿಸ್ ಆಗಿದೆ ಬಟ್ ಅಲ್ಲಿ
Yes, all the cases.
Fresh matter.
Fresh matters, my lord, I've moved 3 memos, my lord. It's not
ಈಗೇನ್
clear.
ಕೊಟ್ರಲ್ಲ ಒಂದ್ ಮ್ಯಾಟರ್.
This other on Monday,
ತಾನೆ
please.
ಕೊಡಿ. ಎಸ್ ಅಲ್ಲ ತಗೊಳ್ಳಿ, ಡೇಟ್ ಇಲ್ಲ. ಈ 347 ಅದು ಪಾಠ ಹೇಳ ಅದರ ಡೀಲಿಂಗ್ ಮಾಡಿ ಬರೀ 917 ಮಾತ್ರ ಪೋಸ್ಟ್ ಮಾಡ್ಸಿ.
Complaint has been withdrawn. I'll read so many.
The learned counsel, this court on earlier last order on court Madi, this court on so and so had passed the following order on the submissions made by the counsel for the petition, counsel for the respondent. The respondent submits, so the complaint before the concerned court itself is withdrawn. In that light, the petition for that World School,
Yes, your lordship, that's
in
some.
that light,
Your
the
lordship heard the matter.
petition is rendered infructuous and is disposed as having become infructuous. Yes.
Number 2.
Petitioner's counsel.
ಚೆನ್ನೈಗೆ ಹೋಗಿ ಬಂದ್ಬಿಟ್ರಾ?
Lord. Gitu, ನಿನ್ನೆ.
ಹೌದಾ? ಆನ್ಲೈನ್
Posted on 7th. Lord, in this matter, my lord, see, if it is for final disposal, a date may
Fix
be
that.
fixed. Some date may be.
no time.
Lord, only,
Move on. Yes, I'll vacate the
Lord,
interim order otherwise.
Lord, this order was, my lord, this petition was filed long back, my lord, and
Alright.
interim order was operating.
No,
Lord, now, my lord, since there was a threat of arrest, my lord, a bail petition was filed. And my lord, there is an interim bail also, my lord. Now the bail main matter is pending.
no,
Any
I am
observe-
not concerned
No,
about that.
any, my lord,
This is a
observation.
482 petition. I am not going to adjourn. Yesterday I've clearly told you. Yes, go on now.
My lord, only.
Go on, sir.
This is the only issue, my lord.
No
Otherwise,
issue.
my lord, we may permitted to withdraw the petition, my lord, with. Yesterday, my lord, your lordship expressed, my lord, 3 petition can be filed in this matter, my lord.
100%.
3 FIRs.
100.
But that is the only ground,
I
my
will
lord,
just-
available for.
I will sustain that. No problem.
I can understand, my lord. That is why, my lord, I am permitted to withdraw, my lord, with liberty to, my lord, file a fresh petition if need arises, so advice
That
at the later
liberty is
stage.
always there. Yes.
And all contentions may be left open, my lord.
Where?
Lord,
urge
because
where?
otherwise, my lord, it will may affect my bail rate, my lord, that is
Uh,
why.
bail
My lord,
will-
what happened is, my lord, in crime number 1, bail was granted. My lord, after granting of the bail, my lord, till then this crime number 302 was abandoned, my lord. They were not doing anything in this crime. My lord, once the bail was granted, very next day, my lord, they started, my lord, activating this crime. Lord. Now they started investigating. Therefore, there is a threat of arrest, and because of that, my lord, after lapse of 1 year,
bail ಇದೀರಾ ಅಲ್ವಾ?
interim bail ಇದೆ.
Interim bail ಇದ್ರೆ ಆಯ್ತು. ಅದು ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ ಅದು.
That is the reason why, my
Interim
lord,
bail
all-
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಇಲ್ಲ. Bail petition, my lord. But therefore, my lord, all contentions may be left open, my lord.
Learned senior counsel, after arguing the matter at length, would seek leave of this court to withdraw the petition and avail of such remedy as is available in law. And has filed a memo to that effect. The memo reads as follows. In the light of the memo so filed, the petition is disposed as withdrawn, reserving liberty to the petitioner to avail of such remedy as available in law at the appropriate time before the appropriate court at the appropriate stage.
In accordance, with law. All contentions left open.
All contentions urged before this court shall remain open. Yes.
Oblige.
Of both the parties.
Please.
Wapas. Very neatly done, that is. I went through it. Yes.
Number 3.
Steps has taken.
Huh?
Steps has taken, my lord.
Interim order ಇದೆಯಾ?
Interim.
Learned counsel for the petitioner submits needful. ಇವತ್ತು ತಗೊಂಡ್ರಾ? Needful has been done today. The list the matter after 2 weeks in admission, interim order subsisting shall continue till the next date of hearing.
Number 4.
My lords, proxy counsel appearing for the petitioners, my lords.
Huh?
My lords, on the previous date, the honorable court had directed us to take hand summons on the other side, my lords.
You have taken.
We have tried reaching out to the other side. My lords, the mother has recently passed away, so he's out of station, my
Alright.
lords. He'll only be
Alright.
returning by Sunday. 2 weeks time may be given. my
List the
lords.
matter after 2 weeks. Yes.
Obliged.
Next.
5.
ಎಲ್ಲಿ ಇವ್ರು ನೆನ್ನೆಯಿಂದ ಬರ್ತಾನೆ ಇಲ್ಲ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ತಗೊಂಡ್ರು
Entry order ಇಲ್ಲಲ್ಲ.
Since your lordship has expressed openly, you are going to dismiss and it appears there. Because already he has suffered in revision.
All right, the
Charges have been
the
framed.
counsel for the petitioner remains continuously absent. Even today, there is no representation on behalf of the petitioner. The learned HCGP and the counsel for the respondent would in unison submit the charges have been framed before the concerned court and the court, the matter is set at the stage of evidence. In that light, I decline to interfere with the challenge so made by the petitioner, leaving open to the petitioner to urge all the contentions that are urged in the subject petition before the concerned court at the appropriate stage. The aforesaid observation petition stands disposed.
Meet, please.
Yes.
The matter is adjourned for producing the judgment of your honor, this honorable court, my lord.
Sikta, Paritosh,
Yes, small.
why you don't get that?
Number 20,
Whatever, why you don't get that judgment sigalva? Then what, sir? I have followed everything in this.
Yes, my lord.
Which are the serial numbers? And a detailed order in her case I have passed.
Serial number 20.
Serial number?
The present case, my lord.
Wait, let me finish the list. In the sense, the preliminary fresh matters. At the end of fresh matters, I will dictate this.
Yes,
Yes.
much obliged.
Seven.
Therefore, to dismiss the petition, they said they want to bring this.
Please. Withdraw ಮಾಡ್ತೀರಾ? ಅಲ್ಲ, ಏನಕ್ಕೆ ಅಡ್ಜನ್ ಆಗಿದ್ದು?
My colleague argued not on the other day. Second round, they didn't appear.
Yes, sir.
But the offences are written on 420, 467, 468, etc. But the facts of the case are that the complainant was not in real estate business. He came in contact with the present petitioner who is accused number 1. But it seems there was some MOU agreements between the parties with regard to getting the properties belonging to HAL on lease. But in fact, the part payments were made and subsequently some checks were also given as security. Those checks bounced, but cases came to be registered against the petitioner, and ultimately those cases also came to be dismissed against the complainant. Complainant as well as the petitioner are accused, but in the very police station with regard to these properties. The contention is that matter is of civil nature. Cases and counter cases are pending between the parties. But civil case is given failure of criminal cases and consequently maybe case.
ಅಷ್ಟೇನಾ? ಅಲ್ಲ, discussion, argument. Yes, sir.
Your Lordship may kindly permit withdrawal.
Discretion, best part of valor. Yes. After arguing the matter at length, the learned senior counsel would seek to withdraw the petition and avail of such remedy as is available in law. Appropriate. ಗೊತ್ತಾಯ್ತಾ madam? At the appropriate stage, appropriate for appropriate sounds. The aforesaid observations, keeping all contentions open, keeping all contentions of both the parties open, petition stands disposed.
Please.
The protection act. One incident, 2 FIR, but different jurisdictions. Same day was filed the FIR, both sides. One is my lord.
Both under the wildlife, both FOCs?
One side is the Bandipura division, my lord, he was in filed the Wildlife Protection Act.
ಇನ್ನೊಂದು ಫಾರೆಸ್ಟ್ offences.
ಇಲ್ಲ ಇದು ಆರ್ಮ್ಸ್ ಆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
Arms Act.
ಆರ್ಮ್ಸ್ ಆಕ್ಟ್.
The two are different.
ಅದೇನಾಗಿದೆ ಅಂತಂದ್ರೆ ಇಲ್ಲಿ spotted, killed is spotted.
Hmm.
They remove the two legs, only Bandipura division. After that, he was shifted to the deer in the Sultan Bateri. The credible information of the Sultan Bateri forest officer. He was arrested the petitioners matter. ಅದರಲ್ಲಿ ಇದಕ್ಕೆ ಮಾಂಸ ಮತ್ತೆ ಮಿಕ್ಕಿದ್ದೆಲ್ಲಾನು ಇದು ಮಾಡ್ತಾರೆ along with ಗನ್ ಅನ್ಲೈಸೆನ್ಸ್ ಗನ್ ಮತ್ತೆ ಕಾರು ಮತ್ತೆ ಚಾಕು ಎಲ್ಲ ಇನ್ನು along with meat of the deer.
ಬೇರೆ ಮಾಂಸ ತಿನ್ಬೋದಿತ್ತಲ್ಲ, ಇದೇ ಹಾಕ್ಬೇಕಾಗಿ. ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
Both sides was investigation is concluded. Both
You
sides
should have had something else. Why did you need venison?
both
Yes.
sides was in by the charge sheet also. Same part. Entire recovery of the person in the Sultan Bateri. ಇಲ್ಲಿ ಏನು ರಿಕವರಿ ಆಗಿಲ್ಲ.
But where did you shoot the or kill the deer?
As per the investigations,
Bandipur, right?
Bandipur.
ಎಲ್ಲಿ ಬಂಡೀಪುರ is in ಗುಂಡ್ಲುಪೇಟೆ ತಾಲೂಕ್.
Please.
Yes. ಆಮೇಲೆ
ಡಬಲ್ ಜೀವಪಾಡೆ.
ಡಬಲ್ ಜಿಯೋಪಾರ್ಡಿ. ಎಸ್ ಸರ್.
ಅಲ್ಲ ಇಲ್ಲಿ ಜಿಂಕೆನ ಸಾಯಿಸಿರೋದು. They recovers the ಅಲ್ಲಿ ಕಾಲುಗಳೆಲ್ಲ ಇಲ್ಲೇ ಬಿಟ್ಟು ಹೋಗ್ತಾರೆ.
Only for 2 legs ಅಷ್ಟೇ. Entire
2 legs.
ಹೌದು.
Sir, animal, what are you talking so casually that you just chopped off 2 legs?
For the investigation.
Yes.
Entire body and others.
A body and others in Sultan Bateri. All right.
Same day was registered. FIR was registered.
So you
Inquiry
killed the animal, chopped off 2 legs here
but is
and
unknown
took
person.
it to Sultan Bateri. So crimes are registered at 2 places.
2 places.
Correct. Casually talking about an animal. That ಏನ್ ಅಲ್ಲಿ 2 ಕಾಲ್ ಮಾತ್ರ ತೆಗೆದ್ವಿ. ಏನ್ ಮಾಡಿದ್ರಿ ಆಮೇಲೆ? Consumed it?
ಇಲ್ಲ ಇಲ್ಲ.
ಮತ್ತೆ?
ಇಲ್ಲ ಅದನ್ನ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರಲ್ಲ ಕೇರಳದಲ್ಲಿ ಅದನ್ನ ಇಟ್ಕೊಂಡ್ರು. ಅವಾಗ್ಲೇ ಸಿಕ್ಕಿರೋದು. Then they were arrested. They brought and they book here also upon their instruction they took us to the place where incident happened. There the legs of the deer was recovered.
But unknown
is
persons
instant.
you have paid the complaint to the 24 division.
Yes. Anything else? Well, ಈಗ FIR stage ಅಲ್ಲಿ ಇದೆಯಾ?
Complaint
Straight away complaint stage.
complaint has been
Straight
filed now,
away.
the evidence before charge.
ಅಲ್ಲ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ ಬಟ್ he was not in class of the witness.
2008 offense ಆಯ್ತು.
ಹೌದಾ?
ಇವಾಗ ಏನ್ ಮಾಡ್ತಿದ್ರಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ? 8 offense ಅಲ್ಲಿ 2024 ಪೆಟಿಷನ್ ಹಾಕಿ. Yes, sir. What stage is the?
No, evidence before charge has happened
ಇಲ್ಲ ಇಲ್ಲ ಅಲ್ಲಿ
Why such a long time?
because he was not
16 ವರ್ಷ ಯಾಕೆ ತಗೊಂಡಿದ್ದೀರಾ?
he was not appearing. Each time he has taken time.
Will direct the court to conclude it in 1 month. If you don't appear, it will pass an order. Correct. Proclamation you appear ಆಗಿದ್ರೆ ಬರೋದು. And why do you take 16 years to conclude a forest offense like that? Is why with pride all the accused walk around. Looking at the delay in these proceedings. If you have to bring someone to books, bring them to books fast. 16 ವರ್ಷ ಒಂದು ಕೇಸ್ ನಡೆಸ್ತಾ ಕೂತ್ಕೊಂಡ್ರೆ ಹೆಂಗಾಗುತ್ತೆ?
The problem with the forest department also my lord that
It is not correct. If you book under the Forest Act for killing a deer in 2008 and it is still being tried in 2024, what is?
he has not appeared.
That's all right. He is not appeared. Andre, how long will you wait? And he has appeared here.
He's
Yakan proclamation is. Yes, sir. Anything else, sir? Consider what, sir? The petitioner.
Liberty to appear before this court. Same day was.
Petitioners accused 1, 2, and 3 are before this court, calling in question proceedings in CC 320 of 2004, which arose out of a complaint so made in the year 2008-2009 by the Karnataka Forest Department as for offences punishable under prayer lidament. The facts in brief are the facts in brief are that the petitioners on 30/11/2008 in the precincts of the Bandipur forest is said to have killed a deer, chopped off its 2 legs, and took it to Sultan Batheri, which comes within the jurisdiction of the Kerala state. The offense is registered in Karnataka for the reason that the petitioners have killed the deer within the jurisdiction of the state of Karnataka and took it to the state of Kerala, in the border, i.e. into Sultan Batheri. What was seized was 35 kilos of red meat and skin of the spotted deer. The proceedings then go on. There were certain other items also seized, which were unlicensed gun and cartridges for the use of the gun. Therefore, the offense under the Forest Wildlife Protection Act springs in the state of Karnataka, and the offense under the Arms Act springs in the state of Kerala within the jurisdictional and is pending before the jurisdictional magistrate in the court at Sultan Batheri. The learned counsel for the petitioner seeks to project that it amounts to double jeopardy. I decline to accept the same, as the killing of the deer has taken place within the state of Karnataka, and therefore the Wildlife Protection Act has sprung against these petitioners for having killed the deer. It is carried into the state of Kerala, where the meat is cut and 35 kilos of red meat is recovered with the skin of the spotted deer in the state of Kerala. So therefore, all weapons used are in the state of Kerala. Therefore, the petitioners are being tried in the state of Kerala exclusively for offences under the Arms Act. Be those facts as they may. The issue is of the year 2008. We are in 2024, and the matter is being still tried by the concerned court in this concerned court. Therefore, the matter is still pending on the score that the petitioners have not appeared before the court, and by proclamation is made against them. The learned counsel for the petitioner has appeared before this court while not appearing before the concerned court, contending that he be granted some protection to appear before the concerned court, as proclamation is hanging on the head of the petitioner. In the light of the aforesaid facts and the manner in which the petitioner has been dodging the trial, I deem it appropriate not to grant any protection to the petitioner, and at the same time direct the concerned court to conclude the proceedings within 8 weeks,
3 months.
within 12 weeks from the date of receipt of the copy of the order, if not earlier, ordered accordingly.
Get to cooperation.
The petition stands for the aforesaid reasons, the following order on the Madi. The petition stands rejected. The petitioner is directed to cooperate with the trial for its conclusion. The concerned court shall conclude the trial within 3 months from the date of receipt of the copy of the order, if not earlier. Yes.
File an application for.
It is open to the petitioner to file any application before the concerned court, which the concerned court would answer, which should clearly not impede the conclusion of the trial as is observed herein above. Yes.
9.
Please, my lord, there are 4 petitioners, please, my lord. They are charged under 306 of the IP. The 4th petitioner is the wife of the deceased person.
Who is the deceased?
Deceased is the husband of petitioner number 4. He was a municipal worker, please, my lord.
1 minute. Sir.
Complainant is the father of the deceased, please, my lord. Complaint is at page number 21, wide annexure B, please, my lord.
What is the date of commission of suicide?
It was on the intervening night of 11th and 12th of April 2022.
Is filed?
Yes, please, my lord. Charge sheet has been filed, please, my lord. A1 to 3 are the relatives of accused number 4, please, my lord.
A4 is the husband.
A4 is the wife.
A4 is the wife. Of,
Wife of deceased.
Deceased is the husband.
Deceased, yes, please, my lord. Deceased has
Husband commits suicide.
committed suicide, please, my lord, by hanging, please, my lord.
Why?
Yes, please, my lord. And for the last
ಡೆತ್ ನೋಟ್ ಇದೆಯಾ?
There is no death note, please, my lord.
Why?
On the previous day, please, my lord, on 11th April 2022, as per the case of the prosecution,
Yes.
A1 and A2 have allegedly quarreled with the deceased person, please, my lord. My lord, on the next day, please, my lord, a neighboring house person, please, my lord, he had noticed that the body is hanging. Then immediately informed the father, please, my lord, father is residing at Koratigere. Incident has taken place at Ramnagara, please, my lord. Kindly come to complaint, page number 21. 2 lines are very important, please, my lord.
Page ಓದಿ.
Yes, please, my lord. ಇತ್ತೀಚಿನ ಸ್ವಲ್ಪ ದಿನದಿಂದ ನನ್ನ ಮಗ ಮತ್ತು ಸೊಸೆ ನಡುವೆ ಹಲವಾರು ಕಾರಣದಿಂದ ಜಗಳ ನಡೆದಿತ್ತು. 1/4/2022 ನನ್ನ ಸೊಸೆ ಮನೆ ಬಿಟ್ಟು ಮಕ್ಕಳನ್ನು ಕರೆದುಕೊಂಡು ಹೊರಟು ಹೋಗಿದ್ದು. ಹೇಮಲತಾರವರ ದೊಡ್ಡಪ್ಪನಾದ ಸ್ವಾತಿ ಕೃಷ್ಣಪ್ಪ ಮತ್ತು ಸೋನ್ಸೋರ್ ಅವರಿಗೆ ನಾನು ದೂರವಾಣಿ ಕರೆ ಮಾಡಿ ಕೇಳಿದಾಗ 4/4/22 ತನಕ ಸುಮ್ಮನಿರಿ, ನಾನು ಹುಡುಕಿಸಿ ಕೊಡುತ್ತೇನೆಂದು ಹೇಳಿದರು. ಈ ವಿಷಯವನ್ನು ಹೇಮಲತಾರವರ ಇನ್ನೊಬ್ಬ ಅಣ್ಣಮ್ಮ, ದಟ್ ಈಸ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, ಇವರಿಗೂ ಕೇಳಿದಾಗ ಅವರು ಸಹ 4/4/22 ನಿಮ್ಮ ಸೊಸೆ ಹೇಮಲತಾರವರನ್ನು ಕರೆದುಕೊಂಡು ಬರುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದರು. ಇದಾದ ನಂತರ ಅಣ್ಣಮ್ಮ ಮತ್ತು ಹೇಮಲತಾರವರ ಅತ್ತೆ ಲಕ್ಷ್ಮಮ್ಮ A2 ಇಬ್ಬರೂ ನನಗೆ ಫೋನ್ ಮಾಡಿ ಮಾತುಕತೆ ನಡೆಸೋಣ, ರಾಮನಗರಕ್ಕೆ ಬನ್ನಿ ಎಂದು ಕರೆದಾಗ ನಾನು ನನಗೆ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲ, 1 ವಾರ ಬಿಟ್ಟು ಬರುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದೇನೆ. ಅದೇ ದಿನ ನನಗೆ ಬರಲು ಸಾಧ್ಯವಾಗದ್ದರಿಂದ 11 ಏಪ್ರಿಲ್ 2022
ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ನೋ ಎಂಟ್ರಿ ಮಾಡರ್, ಪ್ಲೀಸ್, my lord.
Will await his appearance. The second respondent is served on 8/4/2024 and is not represented till date. Therefore, I deem it appropriate to grant one more chance for such representation of the respondent. The issue in the list concerns the commission of suicide of the husband of the fourth petitioner.
Yes, please.
The petitioners 1, 2, and 3 are said to be the relatives. The complaint or the summary of the charge sheet as obtaining in column number 17 would indicate that a family discord or a squabble between the husband and the wife has resulted in the commission of suicide of the husband. Therefore, the offense under section 306 is laid against all these petitioners. In the light of the offense being the one punishable under 306-abetment to suicide, the ingredients found in section 107 of the IPC is necessarily to be present in a charge so made. The ಯಾರ ಮೇಲಿದೆ?
Allegation against all the petitioners.
Omnibus allegation.
Early wife will not till the appearance.
She was not there, please, my lord.
Huh?
She was not in the scene of occurrence on the previous day also. For the 12 days,
Is
she
not
disappeared.
But the
necessary.
other witnesses says, my lord, she was the one who was
One minute,
continuously
yes, so
harassing
and
the.
so. In the light of the commission of suicide prima facie on the marital discord, the permitting further trial against the petitioners 1, 2, and 3 for the present would become an abuse of the process of the law and fall foul of the judgment of the apex court in the case of Kanchan Sharma versus State of so and so 2021, SSC online, SC page 737. Insofar as the fourth petitioner is concerned, the same would be considered on the appearance of the respondent, and in the event of non-representation, the state would be heard and then considered, and then the order, any protective order would be passed qua the fourth petitioner. To list the matter on 20th October,
Grateful, please.
21st October, yes.
Obliged.
My
Yes.
submission is fourfold.
Mhm.
Lord, the parties petitioners and petitioners 1 to 3 and the respondent number 2 are blood relatives. They have been exchanging civil litigation between themselves in respect of various items of the property for over a period of 30 years, and still they are before the court. And it would clearly mean that they want to harbor grudge against each other. That is number 1. Secondly, my lord, the second respondent filed a suit for a declaration in respect of a 42/1 and 43/2 to declare that I am the absolute owner of the property. The multiple relief second being is, my lord, is that the document under which my client, first respondent, has purchased is a fraudulent document. Very well. My lord, in the beginning of soon after the presentation of the plight, there was an interim order the interim order reads, what type of an interim order that was granted was
In which, in what?
in the suit,
Yes.
not to alienate the 42/1 till the disposal of the suit. I mean, for the time being. Later we concede for it. I don't alienate. Let the trial go on and adjudicate finally. So ultimately that interim order came to be confirmed about few months thereafter. Now, this second respondent, who is a blood relative, goes before the complaint to say that on a particular day, by violating the interim order of injunction not to alienate, I'm removing the plantation crop, namely eucalyptus plantation, from 43/1. And the type of injunction that was granted was not to alienate, not an injunction that he should not, that I should not.
All right, I'm not hearing the appeal against the civil suit now. Idik come to this.
No, in this matter, my lord, kindly read paragraph 39, page 39. This is the background which I wanted to cite. My lord, paragraph 39, I mean, page 39, the last part of the complaint. Did my lords got it?
Last
39.
part of the charge sheet.
And the overleaf.
Summary of the charge sheet.
Yes.
Yes.
Mukhya Nyayalaya, did my lords got it? Page 39, ink page 39.
All right, yes.
ಈ ರೀತಿ ಆದೇಶ ಮಾಡಿದ್ದಾಗೂ 8/2/20 ಸರ್ವೆ ನಂಬರ್ 42/2 ಸತ್ತಿನಲ್ಲಿ ಬೆಳೆದಿದ್ದ ನೀಲಗಿರಿ ಮರವನ್ನು.
Yes, I have seen that.
Please, my lord.
I have seen.
Lord, the allegation against the police is that I am interfering with the possession of his property, and so interfered with, I removed and cut and harvested the eucalyptus plantation one. Now, the very second respondent, who is the plaintiff in the trial court, has made an IA application for disobedience of an order of injunction under 39 Rule 2A, together with an IA that I should deposit 22 lakhs being the cost of the value of the crop that I harvested it.
All right.
And there is no allegation
Who is
as
in possession and in whose favor?
I am in possession
In
of the
whose favor injunction is granted?
injunction is granted in favor of the plaintiff not to alienate.
That is the respondent.
And they mislead the court, mislead the police to say here that injunction type of injunction that was granted was one that of an injuncting all these petitioners from interfering with the property.
We'll see. Yes. Now, who is in possession of the property?
Possession as on today, I am in possession of the property.
He is in possession?
It's a,
Mike.
My lords, the eucalyptus plantations were there, injunctions was granted and not to remove the eucalyptus trees. And
Where
this
is the
is the
order of
suit of
injunction?
years.
No, I have the order sheet with
1
me.
minute. Where is the order of
Suit is
injunction?
of the year.
The order of the trial court is dated, in fact, to
Page-
save the
page-
time of the court, on 10/3/2008.
Which page do I get that?
Please, my lord.
Which page do I
And,
get that?
No, I have not produced the certificate copy. I have with me.
It's not produced.
I have with me the entire order sheet.
Directed to maintain status quo without,
Yes, status quo.
uh,
And the application is filed, my lords, temporary injunction
uh,
to restrain from removing the standing eucalyptus trees.
that is.
So he was very well aware, my lord, still the disposal of the suit.
24/9 proceedings may be looked into of the trial court. 24/9/2008.
Allegation is that he has barged into the.
Trespassed into the property, removed all the eucalyptus trees. And my lords, it is, video footage has been committing of the offense and the photographs, and as per section 65B, everything is produced before the magistrate. And this, after the charge sheet is filed on 28/10/21, my lords, the petition is filed in January 24.
All right. What's the stage of the proceeding?
My lords, they filed a discharge application, which they have been seeking time from January.
Discharge application is pending?
Yes.
My lord, I mean, in fact, insofar as these petitioners 1 to 3 who are the blood relatives of second respondent. No,
What has happened?
no, discharge application has not been presented before the court.
Please present it. Time to present.
Yet what I am trying to submit for my lord's consideration is, look at the origin of the proceedings on the
I will
side.
answer. If you want me to answer, I will answer. The origin, the subsistence and the travel, all that. will answer.
If they had supported with an order of injunction,
Ah.
and if I commit this act, I understand it quite well. Fairly enough, I would have said that, yes. But
Yes.
here is a case where they are supported with an order of injunction of the type that I should not alienate.
No, that's not, unfortunately, that's not the order. It is status quo.
Kindly read the next sentences, my lord, not to alienate the order sheet that,
It is after status quo.
please, my lord.
It is after status quo to be maintained by the parties shall not alienate, and there is a direct order not to the eucalyptus trees.
No, there is no such order.
What if?
Status quo, man. That's what-
There is no such order. There is no such order.
It's all right. Even then, what do you mean by status quo?
Please, my lord.
What do you mean by status quo?
Status quo, it should infer the word not to alienate.
The applications
That
filed
inference
itself
I
is-
cannot, yes.
Applications filed was itself for the injunction, so status quo was ordered,
On IA2, status quo was ordered.
not to remove. Status quo with regarding to IAs both.
That not resulted out in the criminal complaint against him. The main complaint is that an order has been passed on the basis of an
That
injunction.
contempt is initiated or whatever he wants to file, let him file. But you trespassing into the property would amount to 447, and removing eucalyptus would amount to 427 mischief. And there is an allegation of assault, so 323.
No, there is absolutely no allegation of assault
That's all
here.
right. That is why 323 has sprung.
Only exchange of verbal abuse, that is
That's
what
it.
the complaint says.
323 has sprung.
Please,
504 and 506 for your verbal abuse. Anything else, sir?
my lord, that the discharge application,
Is better, I think.
my lord, in the present circumstances of the case.
Yes. Correct, I guess. You should present it immediately. Or I'll pass an order if you want me to pass an order.
My lord, with that noting, my lord, with that note,
Hmm.
judicial note,
Hmm.
I feel it, my lord, it better the proceedings get disposed of. With that note, that I am entitled to file a discharge application. And if he so files, if they so files, matter may be rather heard on that application and the order may be.
No, let him file. You file discharge. We'll see later.
And that note, judicial note is necessary in the order, my lord.
Yeah, I will. Yes. The petitioners accused 1 to 8 have knocked at the doors of this court, calling in question proceedings in CC 888 of 2022, registered for offences punishable under so and so. The learned counsel appearing for the petitioner, Shri Devanand, though would vehemently contend with regard to the merit of the matter, would ultimately submit that he would avail the remedy of filing a discharge before the concerned court. Therefore, the petition stands disposed, reserving the petitioner such liberty to avail the remedy of discharge, filing a discharge before the concerned court. In the event the same is filed, it is needless to observe that the concerned court would consider the matter in accordance with law and pass necessary orders, ordered accordingly.
Grateful to the court.
Yes.
See, here is a case where I am not pulling my rabbit out of my hat. Everything is in fact borne out from the order sheet of the trial court and the nature of the complaint presented. That's all I
That's the
just.
reason I did not want to pass an order at the drop of the hat.
We appear for the petitioner, my lord, in this case. Lord, the allegations are, my lord, of impersonation. The first, my lord, criminal petition is filed for quashing the second FIR. The second petition, my lord, which is WP, writ petition, is challenging the B report in the first FIR. B report, my lord. The accused are challenging, reason being, my lord, the first FIR, which we said is the FIR that should be investigated, on the instance of the complainant, this B report is filed, enabling the second FIR to be investigated. That is what the complainant wants, my lord.
One more. First FIR, yavudu, sir?
My lord, first FIR is before the, my lord, is seeing the criminal petition, my lord.
Criminal petition.
First FIR, my lord, is before the KR Puram police station, which is at page
11460,
164, my lord.
164.
Page number 25, my lord, of
Which criminal petitions?
2745, my lord.
That concerns the first FIR.
No, that is challenging the second FIR before the CCB.
What is challenge in 1146?
1146 is the B report, my lord, filed in the first FIR.
All right. Why are you challenging the B report?
Lord, reason, my lord, the second FIR, my lord, was challenged by me on 3 grounds.
All right.
First ground, my lord, that it is the second FIR. Second ground, my lord, was that CCB is not a police station, therefore could not have registered an FIR. The third ground, my lord, was that I cannot expect a free and fair investigation before the CCB. Reason being, the complainant is related to the DCP of the CCP. Therefore, my lord, on these 3 grounds, I filed the first criminal petition, my lord, challenging the second FIR. The second one, my lord, I am saying let the KR Puram police station.
No, let one crime continue.
Please, ma'am. KR Puram crime may continue because that is the first FIR, my lord. That
KR Puram is by CCB.
no, my
my
lord.
lord, it is
KR
by-
Puram is KR Puram police station.
Jurisdictional. police.
Jurisdictional police.
All right. So crime in 2 of 2024 will go
Please, my lord,
and crime in 164 of 2024 will remain.
remain.
No, my
Yeah.
lord, crime in 164 Karepuram FIR has been filed, B report has been filed in that crime.
You have not filed a protest petition?
No, actually what has happened, my lord, once the second FIR is filed before the
Why
CCB.
did you file a second FIR?
No, no, actually, so on very same day, I have given a complaint before. First, I have been before the Commissioner of Police. It was directed to go and file a complaint before the Karepuram Police because it is a jurisdiction.
All right.
So I have filed, I have
Do you
given a
want both
complaint.
the FIRs to remain?
No, 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 my
Then?
lord, I am not. One FIR itself, my lord.
Yes.
See, on, in Karepuram Police Station, they did not register the FIR.
All right.
There afterwards, I came before the Commissioner of Police, I pleaded my difficulty over the police station.
Hmm.
Then, without intimating me, keeping that complaint in the hands of the police station, they have registered the FIR crime.
All right.
Subsequently, after a lapse of 15 days, here in CCB also it was registered crime. Then I have given, after
So
coming,
let the crime before the KR Puram police station continue.
no issue, my lord, we don't have.
Solve.
an issue.
Yes, sir.
Please, madam.
ಯಾಕೆ edit ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ ಅದು ಅವ್ರ ನಾಲೆಡ್ಜ್ ನಾವು ಆಕ್ಚುಲಿ ನಾವು ಹೋಗ್ಬಿಟ್ಟು
ಈಗ
ಇದಾದ್ಮೇಲೆ ನಾವು
crime,
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ
crime 164 of 2024 ಅಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆಯಾ?
ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಸರ್.
File a protest petition to that and continue the proceedings.
ಅಲ್ಲ ಇವಾಗ ಇಲ್ಲ ಅಂದ್ರೆ ಇದು ಕ್ಲೋಸ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಪ್ರೊಟೆಸ್ಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ
ಯಾವ್ದು close ಆಗುತ್ತೆ?
ಅಕ್ಸೆಪ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ ಇಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಆನ್ ದಿ
Accept
ಗ್ರೌಂಡ್
close ಆಗಿದೆಯಾ?
ಕ್ಲೋಸ್ ಆಗಿ ಆನ್ ದಿ ಗ್ರೌಂಡ್
ಹಾ.
ನಾನು ಐ ಹ್ಯಾವ್ ಗಿವನ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬಿಫೋರ್ ದಿ Commissioner of Police that stating that I don't have belief before the because the investing officer of before the Karepuram police station, he has been trapped in the
All
local.
right, now crime is registered in crime number 2 of 24. We will permit that to continue
Please, please.
because this B report is accepted.
Please,
But
please.
there you are caught in contradiction. CCB is not a police station.
No, my lord, there is a this thing notification has been issued, my lord. I have filed in my statement of objection.
ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದೀನಿ.
Subsequent to passing of this honorable court, my lord, that CCB is not a
412.
police station.
ಯಾವ that
The Justice B.A. Patil judgment.
ಮಂಜುನಾಥ್ ಹೆಬ್ಬಾರ್ ಕೇಸಲ್ಲಿ. ಅದಕ್ಕೆ ಮುಂಚೆ ಬಿ ಎ ಪಾಟೀಲ್ ಅವ್ರ
Para CID, my lord, the CCB is
Oh,
Justice
CCB.
B.A. Patil.
Now see notification is issued.
Please, my lord, notification.
Then let it continue.
Matter,
Only,
my lord,
but my apprehension from the beginning was, my lord, I will narrate the sequence of events, which will show up to my lord, that the CCB deliberately is harassing me instead of investigating the matter.
They will now investigate and not harass.
My lord, I have already obtained an anticipatory bail in the first
That will
FIR,
not,
my lord.
that will continue. What's the problem with that?
My lord, may I just narrate the events, my lord?
Yes.
My lord, what happens, my lord? In 2014, an agreement of sale comes to be executed between the second respondent and the petitioners, my lord.
Agreement of sale.
Agreement of sale, my
Yes,
lord.
sir.
The sale consideration is 98 lakhs, my lord. 5 lakhs is received as advance. My
By
lord,
you.
this, sorry, ma'am.
By you.
Yes, my lord. I am the
Yes.
owner of the property. I have executed an agreement of
All
sale.
right.
Lord, my submission is that the agreement was actually between one Mr. Kiran and the petitioners. The second respondent was only the Benami of Kiran. Then, my lord, for 6 years, 7 years, they don't come forward to complete the sale transaction. My lord, at that point, 2 agents come to me and say that we will get the sale agreement cancelled and we will also purchase the property. Now here, my lord, impersonation is done. So my submission, my lord, I am not even aware of this impersonation. The people who were agents, they instead of bringing the Ramesh, they bought someone else with an Aadhaar card.
As Ramesh.
As Ramesh. And they've registered the cancellation, purchased the property from me on the same date. My lord, on 1/2/2024, 2 complaints, my lord, one before the CCB and one before the KR Puram police station. 2 complaints are given. Both these complaints don't come to be registered, my lord.
Hmm.
Now the CCB calls me to the police station regularly, every day. Instead of investigating the matter, though they found the impersonator, the person who has come and registered, they don't take any action against him. They compel me to settle with the complainants.
Hmm.
Now, my lord, after 1 month, because I was being harassed, I approached the district and sessions court, my lord, for anticipatory bail.
Hmm.
Now, after I filed the anticipatory bail on 28/2, immediately the KR police station, my lord, registers this complaint. In fact, my lord, will see the manipulations in the date also in the complaint which is given to the KR police station, my lord, which is at page 25.
Hmm.
Then, my lord, as an afterthought, pursuant to this notification, the CCB also registers a complaint. Immediately, they come to my house, my lord, to arrest. I show them a copy of this anticipatory bail and also the stay in criminal petition, my lord. With that, they left me. Now, my apprehension, my lord, is that Kiran, who has entered into an agreement with me, his brother-in-law is the DCP of CCP. Instead of investigating all that is being done, my lord, is an harassment to settle the matter. In fact, I am willing to even say that whatever you say something reasonable, I'll pay that money also.
Yes, sir.
5 lakhs is paid to me.
No, my lord, it is a false submission. my lord.
You change the investigating agency.
No issue, my lord. We don't have any issue.
Yes, government.
Changing.
Yes, ma'am.
Let somebody else investigate.
My lord, in crime number 164 of 2000.
Anyway, he will influence from outside. Let him not be inside.
My lord, page number 18 of my statement of objection, my lord.
What did you do for 7 years?
ಸ್ವಾಮಿ ಅಲ್ಲಿ ಪಿ ನಂಬರ್ ಇತ್ತು ಸ್ವಾಮಿ ಅದು. ಅದನ್ನೆಲ್ಲ ಸೆಟಲ್ ಮಾಡಿ ದೇ ಟೋಲ್ಡ್ ದಟ್ ಆಫ್ಟರ್ ಸೆಟ್ಲಿಂಗ್ ಆಲ್ ದೋಸ್ ಇಶ್ಯೂಸ್ ಚೈಲ್ಡ್ ಡೀಡ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತ. ಸೊ ಇದೆಲ್ಲ ಆಗಿದೆ ಏನ್ ಮಾಡ್ತಾರೆ, ಸೊ ದೇ ಟೆಲ್ ದಟ್ ಯಾರೋ ಏಜೆಂಟ್ಸ್ ಕರ್ಕೊಂಡ್ಬಂದ್ಬಿಟ್ಟು ಇಂಪರ್ಸನೇಟ್ ಮಾಡ್ಬಿಟ್ರು ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ದೇ ನೋ ದಿ ಅಗ್ರಿಮೆಂಟ್ ಪರ್ಚೇಸರ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಕ್ಲಿಯರ್ಲಿ, ಬಟ್ ದೇ ಫಾಲ್ಸ್ಲಿ ಸಬ್ಮಿಟ್ ಬಿಫೋರ್ ದಿ ಸನ್ ಕೋರ್ಟ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ವಿ ಡೋಂಟ್ ನೋ ದಟ್ ಸಮ್ ಏಜೆಂಟ್ಸ್ ಹ್ಯಾವ್ ಬ್ರಾಟ್ ದೇ ಹ್ಯಾವ್ ರಿಜಿಸ್ಟರ್ಡ್ ದಿಸ್ ಥಿಂಗ್. ಅದಾದ್ಮೇಲೆ ನಾವು ವಿ ಆರ್ ರಿಕ್ವೆಸ್ಟಿಂಗ್ ದೆಮ್ ಟು.
No, these are maze of facts which cannot be decided. And
Sir,
explained.
investigation, I'm not asking
Investigation
for, please,
should
my lord,
go
not
on,
go on, my
but
lord, please.
let it be a fair investigation.
Please, my lord.
If that is the fact, let there be a change of the investigating officer.
Baseless allegation, my lord, against the investigation.
Whatever it is, why should you face even apprehension of bias?
They
If it is not even apparent bias.
They say in the petition that
Brother-in-law DCP na?
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
Ilva?
ಅವರೆಲ್ಲ ಹೇಳ್ತಾರೆ ಕಿರಣ್ ಕುಮಾರ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಕಿರಣ್ ಕುಮಾರ್ ಇಸ್ ನೋ ವೇ ಕನೆಕ್ಟೆಡ್ ಟು ದಿಸ್ ಕೇಸ್. ಅವರೇ ಹೇಳ್ತಾರೆ ಪಿಟಿಷನ್ ಇಸ್ ಎ ಪೊಲಿಟಿಷಿಯನ್ ಅಂತ. ಪೊಲಿಟಿಷಿಯನ್ ಅಂತ ಹೋದ್ರೆ ನಾನು ಹೋಗ್ತೀನಿ, ಇನ್ನೊಬ್ರು ಹೋಗ್ತಾರೆ ಸ್ವಾಮಿ ಅವ್ರ ಹತ್ರ, ಅಣ್ಣ ನಮ್ಗೆ ಹಿಂಗಾಗಿದೆ ಅಂತ ಹೇಳೋದಕ್ಕೆ. ಅದನ್ನ ಅವ್ರು
ಏನಂತ ಹೇಳ್ತಾರೆ?
ಅಲ್ಲ ನಮ್ಗೆ ಹಿಂಗ್ ತೊಂದರೆ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬೋದು, ಬಟ್ ಐ ಪೊಲಿಟಿಷಿಯನ್ಸ್ ಅಂತ ಅಂದ್ಮೇಲೆ ಸ್ವಾಮಿ ದೇರ್ ಇಸ್ ನೋ ದಿಸ್ ಥಿಂಗ್. ಡೈರೆಕ್ಟ್ ಕಿರಣ್ ಕುಮಾರ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಏನೂ ಇದಿಲ್ಲ ಸ್ವಾಮಿ ಇಲ್ಲಿ. ಇಟ್ ಈಸ್ ಕೆ ರಮೇಶ್ ಹೂ ಇಸ್ ದಿ ಪರ್ಚೇಸರ್ ಇನ್ ದಿ ಆಫ್ ದಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ my lord in the agreement of sale.
I will close this, we'll change the investigating officer.
Please, my lord, no.
Yes. The petitioner, which is the first one?
This first one is criminal petition 274.
We report the other, sir.
B report is the
164 of
WP
24.
writ petition, my lord, WP 144.
We'll close that because B report accept a close agide.
Please,
But after
B
investigation,
report is not yet
filed.
accepted, my lord.
Huh?
B report is not yet accepted, my lord.
Then file a protest petition
My
in
lord,
that.
that would be appropriate, my lord, because once the B report is filed, that is after
No, if B
investigation.
report is
this B
accepted and closed,
Not yet.
then it's a different thing. If B report is pending consideration before the concerned court, you agitate that, not the second one.
ಅಲ್ಲ
That CCB problem also will go away.
Is, ma'am.
Investigation ಆಗಿ B report ಆಗಿರೋದು.
ಅಲ್ಲ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ, ಅದು ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದೆ ಅಂತ.
B report is filed at the instance, the complainant gives a letter to the Kerampuram police station that I will pursue my complaint before the CCB police.
ಅಷ್ಟಕ್ಕೆ
Please close
ಮಾತ್ರ
it.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆಯಾ?
Yeah, that's it, that's all is that.
Where is that?
My lord, that is at page number,
Page, petition,
WP 11460, my lord, page number 49 is the affidavit that he files.
page 49,
Page 49, annexure G,
affidavit.
affidavit.
DCBಯಲ್ಲಿ ದಾಖಲೆ ಪ್ರಕರಣವನ್ನು ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗುತ್ತೇನೆ. ಆದ್ದರಿಂದ KR ಪುರಂ ಪೊಲೀಸ್ ದಾಖಲೆಗಳನ್ನು ಪ್ರಕರಣ ಮುಕ್ತಾಯಗೊಳಿಸಬೇಕೆಂದು ಕೋರುತ್ತಾರೆ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನಾಗಿಲ್ಲ, ಅಲ್ಲೇ ಮುಕ್ತಾಯಗೊಳಿಸಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ. It's not after investigation, Tejesh.
Please, my lord.
Why did you say that?
Sorry, my lord, stand corrected.
The petitioner,
Based on my representation to the
it's all
commissioner
right.
of police.
Now we will permit this CCB thing to continue. ಎರಡೆರಡು FIR ಆಗಲ್ಲ. One we will continue,
Please.
permit to continue, and by a different investigating officer. The petitioners in both these cases are common. So is the complainant. A brief facts that led the petitioner to this court in these petitions are that on 16/6/2014, it is the case of the petitioners that they execute an agreement, an agreement of sale in favor of one K. Ramesh in respect of a property bearing so and so, synopsis 1 7 years passed by and the said K. Ramesh, in whose favor the agreement of sale was executed, did not come forward for registration of the sale. On 27/20/21, the petitioner avers that two agents approached the petitioner on the request of cancellation of sale, and they would bring K. Ramesh, who was the agreement holder, to the office of the sub-registrar. It transpires that the sale was cancelled on 27/20/21 in the presence of the agreement holder K. Ramesh. Here begins the problem, as the allegation is K. Ramesh, who was bought before the sub-registrar's office, was an impersonator and not K. Ramesh, who had executed a sale, in whose favor an agreement of sale was executed on 16/6/2024. What happens in the aftermath of the cancellation is again alarming. The petitioners then sell the property in favor of one Moniraju M. and Alfonso L.A. in terms of two sale deeds dated 28/1/22 and 16/2/22, all registered before the sub-registrar K.R. The petitioners then file OS 915 of 2023 against K. Ramesh for cancellation of the agreement of sale deed dated 16/6/2020, which is that 16/6/23? 16/6/2014.
Sorry.
As the petitioners were informed by the subsequent purchasers that the photo of K. Ramesh in the agreement to sale and the cancellation were entirely different. You are the complainant, K. Ramesh. Huh?
I am the complainant.
The complainant, K. Ramesh, who was the beneficiary of the agreement of sale and also who had been allegedly hoodwinked by two of the impersonators of K. R. Ramesh, seeks to register a crime initially before the K. R. Puram police station in crime number 2 of 2024.
164.
164, huh?
164. KR Puram.
164 of 2024. After the registration of the crime, the complainant again seeks to register a complaint before which police station is that?
Second is CCB, my lord, 2 of 24.
Before the CCB, the city crime branch, in crime number 2 of 2024, again for the same offences.
No, on the very same day, I have given the complaint before Commissioner of Police.
I'll add
Please.
notes. For the same offences. The petitioner then knocks at the doors of this court in these petitions, contending that there are two crimes registered on the same cause of action and for the same offences for the same transaction, and it is hit by the doctrine of sameness. This court protected the petitioner qua one of the crimes, i.e. crime number 2 of 2024 registered before the CCB, and permitted investigation to be continued in crime number 164 of 2024 registered before the K. R. Puram police station. The result of the investigation before the during the investigation before the K. R. Puram police station, the respondent complainant gives an affidavit that he would not pursue crime number 164 of 2024 in the light of the fact that he has registered another crime in crime number 2 of 2024 before the CCB. In that light, the interim order was granted. In that light, the police file a B report in crime number 164 of 2024. The B report is pending acceptance before the concerned court. The learned counsel appearing for the petitioner submits that two crimes cannot be permitted to be continued against on the same cause of action between the same parties and in the same set of facts. The learned counsel appearing for the respondent complainant submits that he had registered a complaint before the K. R. Puram police station on 1/3/2024.
No, my
ಅಲ್ಲ
lord, that
ಯಾವತ್ತು
was a-
ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದು?
ಅಲ್ಲ, ನಾನು 1/2/2024 ಕಮಿಷನರ್ ಮುಂದೆನೂ ಕೊಡ್ತೀನಿ,
the-
KR ಅಲ್ಲೂ ಕೊಡ್ತೀನಿ, ಅವರೇ ಕರೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
All right. The learned counsel appearing for the respondent complainant submits that he registers complaints both before the jurisdictional police, i.e. before the KR police station, and the other before the commissioner of police. These two crimes result in these two complaints results in registration of two crimes. One in 164 of 2024 and the other in crime number 2 of 2024. Since it was presented before the commissioner referred the matter to the CCB and it became a crime in crime number 2 of 2024. The learned counsel would further submit that he had no faith in the investigation conducted by the CCB in crime number 2. CCB na Kerpurama? CCB in the light of the submission. The learned, it's your submission or his?
Their submission.
The learned counsel for the petitioner submits that he has no faith in the investigation conducted by the CCB in crime number 2 of 2024 for the reason that the deputy commissioner of police who heads the CCB is the brother-in-law of the complainant K. Ramesh.
No, my lord, he is not brother-in-law, he is nowhere connected to.
Then why are you?
ಅವ್ರು ಯಾರ್ಯಾರನೋ ತಗೊಂಬಂದ್ ಸಂಬಂಧ ಹುಡುಕ್ಬಿಟ್ಟು politician ಅವ್ರದ್ದು ಸಂಬಂಧ ಅಂತ
Oh, no, politician, correct, yes. So he is related to the complainant. In that light, he seeks change of the investigating officer. The submission, aforenarrated facts are not in dispute. They are not in dispute. Two crimes admittedly have emerged in the case at hand on a solitary action of the petitioner and others. The crimes are for identical offences and on the same cause of action. Therefore, I deem it appropriate to obliterate one crime, that is in crime number 164 of 2020.
Request two of 2024, my lord, because I've already obtained anticipatory bail in 164, my lord, so it will continue. So two may.
ಯಾವ್ದಾರ ಒಂದು ಹೋಗ್ಲಿ.
164.
164 ಕಂಟಿನ್ಯೂ ಆಗಲ್ಲ, ಬಟ್ ಅಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದಾರಲ್ಲ.
That they can challenge, my lord.
No, that I will not permit.
Or I've challenged the B report, my lord, that may be allowed by writ petition.
He has given an affidavit, so B report is
But
filed.
in WP, my lord, I have
I will
challenged,
direct further investigation to be continued in 164.
please, my lord, I have challenged the B report, my lord, so my petition
No,
allows.
not challenging the B report. I will myself direct
Please, my lord,
investigation to be continued in 164.
164, yes.
Yes. The aforenarrated facts are not in dispute. On hearing the respective counsel appearing for the petition parties, what would emerge is, the unmistakable inference would be that obliteration of one crime so registered as it hit by doctrine of sameness. On the same day, two complaints are registered by the complainant, one before the commissioner of police and the other before the jurisdictional police, i.e. the KR police station. On the score that he had registered two complaints and it had resulted in two FIRs being registered against the petitioner. The complainant gives an affidavit, files an affidavit that he would not pursue crime number 164 of 2024 registered before the jurisdictional police. This results in filing of the B report. In the interregnum, the crime in 2 of 2024 has progressed.
No, my lord, there's no.
Has progressed further, but the submission of the learned counsel for the petitioner is that the complainant's relative is one who heads the CCB, and therefore the investigation will not be fair and proper. Will not be fair, free and fair, will not be free and fair. In that light, while obliterating one crime, that is the crime registered before the CCB in 2 of 2024, I deem it appropriate to direct the jurisdictional police in crime number 164 of 2024 to continue the investigation as investigation has not been conducted in the light of an affidavit filed by the respondent complainant that he would not pursue 164 of 24 in the teeth of the pendency of the crime in 2 of 2024 registered before the CCB. The investigation shall complete as 3 months.
Investigation done in two, maybe transferred all the documents.
The investigation till date that is conducted by the CCB in crime number 2 of 2024 shall all be transferred to the investigating officer or who is investigating crime in crime number 164 of 2024 and 24. And for the aforesaid reasons, the following order. The crime in crime number 2 of 2024 stands obliterated. The CCB, which has conducted investigation till date, shall transfer the papers of investigation to the investigating officer in crime number 164 of 2024. Crime number 164 of 2024 shall be investigated into and a final report be filed before the concerned court. The B report so filed by the jurisdictional police in crime number 164 of 2024 is, we have to quash that also, is quashed as a consequence of the aforesaid directions. The investigation shall complete within 3 months. The investigation shall complete within 6 months from the date of receipt of the copy of this order, and the same shall be placed before the concerned court for further orders. The court shall regulate its procedure accordingly.
Correct. The respondent number 2 affidavit before the Commissioner of Police is that I have no trust on the care from police.
You have no trust.
I have also filed this thing representation.
Any police station. is
Alala,
okay.
ಆಮೇಲೆ ಏನಾಗುತ್ತೆ, the investigation officer who was conducted there, he has been trapped in the Lokayukta and he has been suspended, my lord. I have no issue now, my lord.
Allah, by the hands of a different investigating officer. KR Puram alli, if he is suspended, how can you hold him?
That point of time, my lord. That point of time, my lord.
Anyway, at the hands of a different investigating officer in KR Puram police station. Adondu add ಮಾಡ್ತೀನಿ. Yes. Next.
Therefore, petitioner's counsel.
Circulation.
Yes, my lord. My lord, the allegation is that, my lord, he held a press conference, my lord, near the deputy commissioner's office, for which, my lord, 353 has been invoked. Lord, absolutely, there is no assault or, my lord, use of criminal force, nothing. Lord,
Yes,
he
sir. You are in custody, is it?
No, not in custody. My lord,
You were in custody.
no, that is in earlier case.
Not in this
Not
case.
in this case, my lord. Only, my lord, it is
True ಹೇಳ್ಬೇಡಿ ತಾಳಿ. ನಿಮ್ ಕೊಲಿಗ್ ಗೊತ್ತು, ಅದಕ್ಕೆ don't be
squarely covered by Manik Taneja. Manik Taneja. my lord.
2015 ಕೊಡಿ.
The latest one.
ಅದು ಕೊಡಿ.
The fact that he's gone to the extent of DC office, my lord, and
ಏನು?
then
Press conference.
Allah, went to our chamber and then threatened her.
Chamber threatened.
Yes, my lord.
ಇಲ್ಲ.
The DC office.
That is not the allegation.
That is the complaint.
Wait.
That is the complaint.
Complaint is at page 42, my lord.
ಯಾವ್ದು CL7 ಲೈಸೆನ್ಸ್ ಏನೋ ಇದೆ ಇದು?
My lord, sir, there was a dispute regarding CL7, my lord. Somebody has, my lord, committing illegality. He objected it. Not on his representation, the license was supposed to be cancelled. DC has not cancelled it. Instead of that, my lord, DC tried to impose some penalty and regularize it.
Who are you?
But I'm an advocate, my lord.
It's all right.
My lord, as I
ಅಲ್ಲ,
said,
how are you agreed?
I am a complainant, my lord. In respect of that excise
All right.
license, my lord.
Hmm.
Then, my lord, I questioned this, my lord, only saying that, my lord, this is the direction given by the higher officers.
Hmm.
You should have implemented it properly. You have just, my lord.
Were you the complainant there?
Yeah, I am the complainant.
Pursuant to your complaint, the DC had given directions?
Yes, my lord, complainant.
Where is the complaint?
Annexure A is the complaint. Page 17, my lord. Abakari Ayuktaru, Abakari Ilake.
Page 17, na?
17, my lord, yes. This was inquired into and, my lord, the directions were given to deputy commissioner.
Where is that?
Annexure
Page.
C, my lord, at page 28.
There are so many directions. Which is yours?
My lord, all these, my lord.
All these?
Yes, my lord, all these
Complaint
7.
was against all these?
How though? One person has got 7 license, my lord. This was the issue. And there was a gross violation of the excise rules.
Hmm.
But this is undisputed fact. Then, my lord,
Where is the complaint?
annexure complaint is annexure A, my lord, given to excise commissioner.
ಅಲ್ಲ ಇವ್ರ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
Annexure F,
ಮೇಲ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
number F, my lord. Page 42. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದ ಅನ್ವಯ ಜಿ ದೇವರಾಜಗೌಡ ವಕೀಲರು ಹೊಳೆನರಸೀಪುರ ಇವರು ದಿನಾಂಕ 14/3/2023 ಗುರುವಾರ ಸಂಜೆ 7 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಯಾವುದೇ ಅನುಮತಿ ಪಡೆಯದೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆವರಣದಲ್ಲಿ ಪತ್ರಿಕಾಗೋಷ್ಠಿ ನೀಡಿರುತ್ತಾರೆ ಮತ್ತು ನನಗೆ ನಿಂದಿಸಿ ಸರ್ಕಾರದ ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಕರ್ತವ್ಯಕ್ಕೆ ಅಡಚಣೆ ಮಾಡಿರುತ್ತಾರೆ.
ಎಲ್ಲಿ ಕಮಿಷನರ್ ಚೇಂಬರ್ಗೆ ಹೋಗಿದ್ದಾರೆ ಅಂತ
It is in their chamber only, my lord.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಚೇಂಬರ್
Page 43, my lord.
ಹಾ
ಅದರಲ್ಲೂ ಇಲ್ಲ.
ಹಾ
7 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಅನಗತ್ಯವಾಗಿ ನಿಂದಿಸಿ ಸಾರ್ವಜನಿಕ ಕರ್ತವ್ಯಕ್ಕೆ ಅಡಚಣೆ ಮಾಡಿರುತ್ತಾರೆ.
ಎಲ್ಲಿದೆ?
ಚೇಂಬರ್ ಒಳಗೋಗಿದ್ದಾರಂತಿಲ್ಲ. ನನ್ನ ವಿರುದ್ಧ ಯಾವುದೇ ಪೂರಕ ದಾಖಲೆಗಳನ್ನು ಹೊಂದದೆ ಸುದ್ದಿಗೋಷ್ಠಿ ನಡೆಸುತ್ತಾರೆ. ಆದರೆ ನನಗೆ ಸರ್ಕಾರ ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಕರ್ತವ್ಯಕ್ಕೆ ಹಿನ್ನಡೆ ಉಂಟಾಗಿದ್ದು ಜಿಲ್ಲೆಯ ಸಾರ್ವಜನಿಕರು ಮತ್ತು ಸರ್ಕಾರದ ಮಟ್ಟದಲ್ಲಿ ನನ್ನ ಮೇಲೆ ಇಟ್ಟಿದ್ದ ಗೌರವಕ್ಕೆ ಧಕ್ಕೆ ಉಂಟಾಗಿದೆ. ಡೆಫಮೇಷನ್
Statements of the witnesses.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬರ್ಬೇಕಲ್ಲ ಸರ್ ಅದು. ಆಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯು ಗ್ಯಾದರ್.
The Mazar also
ಕಂಪ್ಲೇಂಟ್
recorded.
ಬೈ ದ ಡೆಪ್ಯೂಟಿ
Where
ಕಮಿಷನರ್.
is the complaint? Who is the complainant?
Complaint is the deputy.
It's not a passerby, sir. It's the deputy commissioner is the
Yes.
complainant.
ರೆಸ್ಪಾನ್ಸ್
You should have told that he has entered the chamber and he has created ruckus. If you want 353 to be roped in.
Incident
Where is,
happened.
that's all right. Where is one word with regard to him entering the chamber and stopping you from performing your duty by usage of criminal force? What is necessary under 353?
Word is missing.
Word is missing. Case missing. ಏನ್ word is missing?
No, the Mazar, spot Mazar is recorded, my lord.
ಅದೆಲ್ಲ ಆಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ you are a deputy commissioner of police excise who is registering the complaint. You forgot about that he came into the chamber and created problems.
Incident happened in the chamber, but
But ಪಾಪ ಅದೇ ಮರ್ತು ಬಿಟ್ಟಿದ್ದಾರೆ.
no, your lordship may see the FIR, my lord, the place of incident.
Complaint, sir. Complaint is resulted in the FIR.
That's correct.
Basic necessity is some averment in the complaint that he entered the chamber and did not allow performance of a duty of a public servant by usage of criminal force.
That is what is
That
also
is
threatened.
353.
He also threatened her that ನಿಮ್ಮನ್ನ ಎತ್ತಂಗಡಿ ಮಾಡ್ತೀನಿ ಇಲ್ಲಿಂದ ಹಂಗೆ.
ಏಳು ಲೈಸೆನ್ಸ್
ಒಂದು ವರ್ಷ ಆದ್ರೆ ಅಂಗಡಿ ಆಗಿದೆ.
ಅಲ್ಲ, that is the excise DC. I am not
That is
excise
true.
DC.
ನೀವು ಯಾವ DC?
Deputy commissioner, district deputy.
ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್.
No, I have also directed.
ಇದೆಲ್ಲ ಅದಾದ್ಮೇಲೆ ಆಗಿರೋದು, ಮುಂಚೆ ಇದು.
ಮುಂಚೆ
ಹಾ. You appear to be a trouble monger, sir.
But ultimately, my lord, this is a matter where, my lord,
No, I will
Yes,
answer in law,
yes.
it's a different thing. Yes, sir. When illegality is asked, these things happen.
No, that's, he is, if there is any illegality, my lord, there's a means and process. He can do that. There is no
Correct.
problem. We are not
He-
saying that he cannot,
He will do
cannot-
that.
but not entering in, not abusing, entering and abusing and troubling the, if you start doing that to deputy commissioner, my lord, then
Where is it, sir? Press conference ಮಾಡಿದ್ದಾರೆ ಅಂತಿದೆ ಅಷ್ಟೇ.
chamber,
ಅಬ್ಯೂಸಿಂಗು, ಟ್ರಬಲಿಂಗು ಎಲ್ಲ ಆಮೇಲೆ ಸ್ಪ್ರಿಂಗ್ ಆಗಿರೋದು.
chamber ಅಲ್ಲೇ ಆಗಿರುತ್ತೆ.
ಎಲ್ಲಿ ಹೇಳ್ಬೇಕಲ್ಲ ಅದನ್ನ, ನನ್ನ ಚೇಂಬರ್ ಒಳಗೆ ನುಗ್ಗಿದ್ರು ಅಂತ. If the deputy commissioner doesn't know what has happened in his chamber and you want to collect it by way of statements later. Anything else, sir?
Place those materials.
Offense only 353?
only 350. If it is allowed to continue, they may add, my lord.
ಅಲ್ಲ ಈಗ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಗ್ಯಾದರ್ ಮಾಡ್ಕೊಂಡಿದಾರಲ್ಲ, ಆಮೇಲೆ
Yeah,
offences ಗ್ಯಾದರ್ ಆಗುತ್ತೆ.
That is what.
ನೋಡಿ ರೆಡಿ ಇದಾರೆ ಆಗ್ಲೇ ಎಲ್ಲ ಕೊಡಿ.
Statements are also right.
DC ಗೊತ್ತಿಲ್ಲದೆ, DC ಗೆ ಅವ್ರ ಚೇಂಬರ್ ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲದೆ ಇರೋದು ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಔಟ್ಸೈಡರ್ಸ್ ಹೇಳ್ತಾರೆ.
ಆಗಿರೋದು ಇನ್ಸಿಡೆಂಟ್, alleged incident. 19th, my lord, the FIR was, complaint was given. In between, my lord, a showcase notice was given.
5 days ಯಾಕೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
The statements also recorded.
No, I am not on that. Statements may have been there. The DC should first say everything happened in my chamber. That's why for 353. ಅಲ್ಲಿ one word ಇದೆಯಾ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು.
Complaint ಅಲ್ಲಿ it says, my lord, that ಆವರಣದಲ್ಲಿ ಅಂತಿದೆ.
ಆವರಣದಲ್ಲಿ ಪ್ರೆಸ್ ಕಾನ್ಫರೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
That may be, my lord.
ನಿಮ್ಗೆ ಯಾಕೆ ಬೇರೆ ಕಡೆ ಹೋಗಕ್ಕಾಗ್ಲಿಲ್ಲ?
My lord, when he visited, my lord, the press people, my lord,
Over
took his
there
interview.
waiting for you.
Obviously, my lord, in the public offices, this
Public
media,
office ಅಲ್ಲಿ
media,
press
media
ಇದ್ದೇ
people
ಇರ್ತಾರ?
will be there, my lord, they will be waiting and they will take a reaction, my lord, since there is some allegation and some complaint and my lord, some orders are there.
ಓ, ನೀವು ಒಂದು ಬೈಟ್ ಕೊಟ್ರ
Stay.
So it has bit you now.
Let the investigation go on, my lord.
Why, sir?
It's violation of Article 19.
No offense is there, not there, my lord, we'll file a.
You will file a B report, statements ಎಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಕ್ಕೆ.
ಅಲ್ಲ,
B report ಅಲ್ಲಿ.
In extra additional section ಹಾಕ್ಬೋದು ಅಂತ ನಾವು apprehend ಮಾಡ್ತೀವಿ.
And you link it to that.
ಅಲ್ಲ, ಇವರ background rest.
Not the way.
No, because he took a claim saying that because he's a lawyer has been prosecuted, not as a lawyer. It has not been prosecuted because he's a lawyer. He's troubling many people.
No, raising some my lord, objection to the illegality which is continued in the society, my lord, cannot be.
Anything else? Complaint ಅಲ್ಲಿ ಇರ್ಬೇಕು sir. What is this? The petitioner, the sole accused, is before this court calling in question registration of a crime in crime number 32 of 2024 registered for offences punishable under section 353 of the IPC. Heard the learned senior counsel Shri Arun Sham appearing for the petitioner and the learned additional SPP B.N. Jagdish representing the state. An incident that happens on 27/9/2023. It is the case of the complainant, the case of the petitioner, that he has registered a complaint before the Commissioner of Excise against one J. Deepak Gowda and his mother in respect of Adias Bar and Restaurant, as they had obtained 8 CL-7 excise licenses, which was contrary to law. After the registration of the complaint by the petitioner before the Commissioner of Excise, the second respondent had issued, second respondent, Excise Commissioner.
ಅಲ್ಲ, Deputy Commissioner.
Deputy Commissioner.
The Deputy Commissioner issues notice to the petitioner to produce documents in support of the claim that he has made on 27/9/2023. The petitioner is said to have replied to the said notice that the documents are already placed before the necessary authorities. Then the petitioner is said to have submitted a representation to the returning officer. Why returning officer? Election notify ಆಗಿತ್ತು. So to take action against the ಇದೆಲ್ಲ ಯಾಕೆ ಬೇಕು? This is your problem. ಅದು ಬೇಡ, set of representation ಬೇಡ. The Deputy Commissioner then on 19/3/2024 registers a complaint against the petitioner, which becomes a crime in crime number 32 of 2024 for offense punishable under section 353 of the IPC. It is the registration of the crime that has driven the petitioner to this court in the subject petition. The learned senior counsel would submit that the allegation against the petitioner is that he had visited the office of the Deputy Commissioner. When he was coming out of the office of the Deputy Commissioner, the press was waiting for a bite from him. Therefore, he stood and gave a bite to the press with regard to what has transpired in the office of the Deputy Commissioner. The bite becomes a crime. The learned senior counsel would further submit that nowhere in the complaint it is alleged by the Deputy Commissioner that the petitioner had stopped the Deputy Commissioner from functioning, which would become an offense under section 353 of the IPC. He would seek quashment of the entire proceedings for it being an abuse of the process of the law. The learned additional SPP would submit that the complaint, though does not narrate that it happened in the chamber of the Deputy Commissioner, there are statements recorded and Mazar drawn later that everything has happened in the chamber of the Deputy Commissioner. Therefore, the offense is made out and the investigation should be permitted to be continued. I have given my anxious considerations on. The aforenarrated facts are not in dispute. The issue at present is with regard to the offense under section 353 of the IPC. And the entire the offence has sprung from the complaint so registered by the Deputy Commissioner. The complaint registered by the Deputy Commissioner reads as follows, Annexure F, page 42. So it is the complaint of the Deputy Commissioner so registered on 19/3/2024 that on 14/3/2024 at about 7 p.m. Without any permission from the Deputy Commissioner, the petitioner has conducted a press conference in the premises of the Deputy Commissioner, which has stopped the Deputy Commissioner from performing the duties. And therefore, it has become an offense under Section 353 of the IPC. The justification of the learned senior counsel is that when he walked out of the chamber of the Deputy Commissioner, when he had agitated with regard to CL7 licenses being given, 8 CL7 licenses being given to someone or any other issue, the people from the press had taken a bite from him with regard to what has happened inside. The justification stands to reason for the reason that there is no averment in the complaint that the petitioner has entered the chamber of the Deputy Commissioner, created a problem or stopped the Deputy Commissioner from performing her functions. If that is not the complaint, the foundation becomes shaky. The state is wanting to build a superstructure on the shaky foundation by recording statements after the event has happened. The event admittedly has happened on 14/3/2024 and the crime comes to be registered, complaint itself comes to be registered on 19/3/2024. Therefore, between 14/3/2024 and 19/3/2024, it is obvious that the state was collecting evidence to register the crime.
State was not collecting, respondent.
Sorry, the second respondent was collecting evidence to register the crime. Therefore, the very incident is shrouded with such improbability that would lead to obliteration of the crime. It becomes apposite to refer to the judgment of the apex court in the case of Bhajanlal versus so-and-so, 1992, supplement 1 SEC page 335, paragraph 102, quote the 7 postulates there. The apex court has held that at the stage of crime, it can be obliterated if in the event the complaint does not narrate. In the event, if the event is said to be true, even it does not make out an offense. The offense in the case at hand is the one punishable under Section 353 of the IPC. Section 353 reads as follows. Section 353 mandates that the public servant should be stopped from performing public duties by usage of criminal force by the accused. There is no such allegation in the complaint that is narrated. Therefore, the permitting further proceedings against further investigation even against the petitioner would undoubtedly become an abuse of the process of the law and result in miscarriage of justice. Idaleke?
Manik Tanejan, latest judgment of the apex court.
That is Mahendra Kumar Sonkar. Yes. Then better. Therefore, for the aforesaid reasons, following order, allowed quashed. Great.
Defamation. Respondent.
Defamation, my lord.
Demolition.
Defamation.
Defamation.
Defamation. Who has defamed whom, sir?
My lord,
That's
for
the
filing PCR in DA case, so they have filed a defamation.
I filed the petition, my lord, in 7242.
Hmm.
Wherein, my lord, I challenged the private complaint and the subsequent reference under 156.
Oh, this.
Yes, please.
Yes. Yen madidri.
My lord, I have conveyed the mind of the court, my lord. They are ready to take any order your lordships passes. Only one.
They are bound, sir. What is this?
My lord, one discretion I would like to make a mention, my lord. Earlier round of litigations have all ended. Your lordship may
Yes, sir, is there in this?
For the defamation part of it.
Oh, okay.
Defamation, not on the main.
No, defamation we'll see.
Because main aspect is the advocate having given the complaint, my lords. On the basis of the complaint, my lords.
No, I have seen the papers. How many times does he be, he's dragged into these proceedings with, without any rhyme or reason every time.
ನಮ್ಮ
ನಿಮ್ಮದು ಬಿಟ್ಬಿಡಿ.
ನಾನು ಎಬಿಟ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ.
No, your defamation, you leave it, will pass necessary orders.
My lord,
But you can be there, no, yes.
in my lord's
In this
the
case, in the-
defamation,
Yes,
in defamation case, my lord, they have filed a suit for civil damages, civil suit. Any observation shall,
That you contest whatever, let them contest that.
any observation made herein shall not affect the rights there, and my lord, there is a suit pending. They have only produced the.
Then I will just close it saying that you have filed a suit for civil damages before the concerned court. Then the
Please.
defamation case which springs from the same thing,
Please,
I will obliterate that and permit you to pursue that.
Annexure E, my
I
lord,
will not make any observation here.
please.
Only on that ground will close it. Adu nadili adar ಪಾಡದು. ಇದು ಹೇಳಿ sir.
So in this case, my lord, the complaint, my lord, time and again has given multiple complaints. That, my lord, is part of record also. We even stated, my lord, on previous occasion.
Who is the complainant?
I am the.
Yes, sir.
I am the, my lord, I am a advocate practicing in Hassan, my lord,
ಇಂದು ಹಾಸನೇನಾ?
the complainant, not me, my lord.
All right.
I am representing the advocate, the complainant.
Previous matter, other previous matter, ಎಲ್ಲ springing from Hassan.
Here, yeah, my lord, in fact, it is a complaint. My lord, this is the complaint, the basis for the complaint, my lord, is the details given by the accused himself in another case, SC case which he has filed, where in his factory, my lord, there's a dispute between his employees and issue was there. Under the oath, my lord, he has given the details of all his property. A person who was
Whose properties?
his and his wife's property.
All right. That was when was the first complaint?
My lord, that is, he has filed that case. It is not related anywhere on this one. So the details are all as a court record. It has been marked, exhibited. And based on this, a complaint has been filed
Before the vigilance.
Before the vigilance, it has been filed.
What happened then?
My lord, they did not respond to anything.
They did not respond.
Yeah. And then, my lord, it is a PCR is filed before the
Hmm.
the sanctioning authority. My lord, in fact, before the court, it has been filed.
Hmm.
There, my lord, it is observed that, your lordship, the court observes that because I am the sanctioning authority and I will have to be providing the document, it is not appropriate to proceed before me, and a direction was sought from this court, my lord, to transfer it to the appropriate another court. And the proceedings there happened, and an FIR is already registered. In this matter, it was referred, and thereafter a FIR is also registered. There
So the basis is the complaint given to the vigilance.
Yes, madam.
All right. Now, that was the first time. Next time, yaವಾಗ?
No, there is only one. I don't know.
ಹೇಳಿ.
Don't have a.
He has given a complaint to the registrar of the and they have conducted the investigation and they said that there is nothing possible. They are still closed. Thereafter, it goes and files present PCR second. Every time they are in the district, there is not there.
No, ಅದೇ every time ಅಂದ್ರೆ how many times this has happened?
No. There is nothing like.
PCR, first PCR ಅಲ್ವಾ?
Only for one PCR, my lord. And they are told I am a RTA activist or nothing, my lord. I have nothing. I have not made any. Huh?
You
Yeah,
are
the
not-
complainant.
You are not the complainant.
No, I am the complainant, my lord. I have not made any.
Oh, RTA.
Ramifications is bigger.
Question, huh?
Follow-ups have done, RTA applications are done only in respect of this, man, not in.
In both I'll pass. 21st will dictate. 21st will dictate.
I appear for respondent number 1, your lordship. My objection may be taken on.
ನೀವ್ ಯಾರು? ಹೈಕೋರ್ಟಿಗ? ಯಾರಿಗೆ?
Lokaयुक्त.
Lokaयुक्त has registered an FIR.
Refer to Lokaयुक्त.
Yes, ma'am.
Give it. Yes.
And FIR, they are registered an FIR also.
On 21st I'll dictate. Yes.
Obliged.
Heard so and so. Let's post the matter for dictating orders on 21st.
Objection may be taken on.
The learned counsel, Baby Patil, files his objections. The same is taken on record. Yes. Then I will pass that order only on that day. Interim order subsisting shall continue till the next date of hearing.
Obliged.
Yes. Both.
14?
The second respondent.
Lodged by the second respondent husband against the wife.
Uh,
And they have produced a report of a forged signature, my lord, by the FSL.
hmm.
This is a private FSL has filed it. I did not know, my lord. I,
ಏನು ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್
truth, ಅಲ್ಲ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ, ಇಲ್ಲದು ತಗೊಳ್ಳಿ. 24 their objections they have filed, my lord.
Forensic lab, my lord.
For evidence. By mistakenly, I was just wondering how can they do that because without any notice.
ವೆಲ್ ಲೆಟ್
This
ಮಿ
is done by, my lord, forensic lab.
1 minute, 1 minute.
Clues, sorry.
Page
20, our objection is to page 24. Our objection, not in the main petition. 24. Yeah, the clue for evidence forensic investigation private limited. Before PCR.
clue for evidence forensic investigations.
Same day, both fixed deposit was cleared.
We'll refer it to the FSL.
In fact, I'm told that has been done, my lords, after the learned magistrate has referred
Where
the
is that? Where is that
for
report? sir?
investigation. I'm told that the document in question, which
Yes.
ex facie I can demonstrate is forged by her. There is no ground in the petition also alleging that the husband has in fact signed the FD receipt. I write to the bank the very day. If I had signed
Now,
the
the
FD receipt, I would
complaint
not
is
write to the
against the
bank.
wife, is it?
Yes, yes.
All right. Hmm.
And now after the 156(3) order, I'm instructed that the document in question has been referred to the FSL.
Get the records.
I'll secure, man.
Secure the entire records.
After 10 months, the
Whatever it is. Document remains document, sir.
No, sir.
10 months ಆದ್ಮೇಲೆ signature and change
No
ಆಗಲ್ಲ.
second opinion about it.
Yes. They heard the learned senior counsel Shri M.T. Nanay appearing for the petitioner and the learned senior counsel Aditya Sondi representing the respondent. The issue in the list is with regard to the wife forging the signature of the husband and drawing money.
No, sir.
Yes,
Fixed deposit,
How much?
9 lakhs and all.
And withdrawing the fixed deposit of rupees 9 lakhs.
plus interest.
13 lakhs.
Plus interest.
No, no.
All
13
right.
lakhs with
Very
interest.
much.
All right, 9 lakhs,
9
yes.
lakhs, 18,000.
The
15.
learned senior counsel would seek to contend that the signature is verified by a private laboratory and not by the forensic science laboratory run by the state. The learned senior counsel for the respondent submits that after the reference under 156(3) of the CRPC, the signature is also referred to the FSL and a report is before the concerned court. Therefore, the learned HCGP to secure the records before the concerned court with particular reference to the reference of the signature to the FSL and place it before the court on the next date, list on 20th.
Lords,
In the fresh
either way,
matters.
it would be a matter for trial, my lords. Would your lordships be?
No, let me see what is the report of FSL because
Very-
there is a judgment where it should not be referred to private laboratories.
Lords, that reference is by me prior to the complaint to buttress
But
my
if
private
it is,
complaint.
if it has happened after 156(3), then it goes, it's a matter of trial. I just want to see that document.
Very well, most certain, most certain.
My lord. Complaint for the offense of cheating, the forgery, etc. in respect of purely a civil dispute, my lord. Properly, purely civil dispute, my lord. Your lordship had heard this matter, my lord, and specifically posted for disposal. Since they short time, may I directly take my lord to the synopsis they have filed, my lord. Or synopsis they have filed.
Who appears as the respondent? Oh, Nayantara madam.
They had argued, my
They have
lord.
filed their
Today,
objection also.
Where, my lord, in respect of purely civil dispute, my lord, property was already registered. After the registration of the property, my lord, complaint comes.
I know, the respondent is the purchaser.
Oh, immediately they get all the money also freezed, my lords. My
I
lord,
have
2000
passed a detailed order.
Oh, the 2005 is the re-grant order, my lord. We have entered into
No,
registered.
no, I have passed a detailed order.
Please,
Yes, my lord, detail order.
And what they now.
Exploring the possibilities of the settlement, nothing happened?
Nothing, nothing, my lord. My
All
lord,
right.
they have got, after very next day of the affair, they got freezed all.
We'll pass it over.
My lord,
I have directed defreezing of the account. Pass over.
And
Pass
entire amount of banks of, please,
Pass over. Yes.
please.
Next. ಏನ್ ಫೇಕ್ ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಇದೆ? ನೆನ್ನೆ ಯಾಕೆ ಅರ್ಜೆಂಟ್ ಆಗಿತ್ತು?
ಪಾಸ್ ಓವರ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್.
ಫೈನ್, ಪಾಸ್ವರ್ಡ್.
70.
Apply for the petitions. 498. Mother, brother and sister have been added as.
My lord, charges framed on 15/7/2023, my lord. Much prior, 1 year before.
No, no, no.
Page number.
I will not interfere.
46 and 47.
I am not going to interfere.
46 and 47, my lord.
You should have filed it earlier.
No. Charges were only framed on 15/7/2023, my lord.
23. When did you file the petition, sir?
Petition is filed on 25th April 24.
24.
Thereafter. the
Anything
matter-
else, sir?
Thereafter, the matter stand posted for evidence. CWN present
Bind over ಆಗಿದೆ.
and she takes time, my lord. Just.
Well, I will direct conclusion of the trial, no problem.
It's not one document. Page number, they have only produced in the page 74 and 76.
Hmm.
Just, they have only produced in the charge sheet, one, along with charge sheet. 76 kindly, 76.
Yes, sir.
I can't read that. Just.
You can't read that.
Aduna.
ಆ ಥರ ಇದೆಯಾ?
Because I don't want to read out in the book. Open.
1 minute. Page?
Page 74. This is a discharge summary.
All right.
Course in the hospital.
I will read.
Course in the hospital, last line.
Psychiatry. So,
Allah, she has these tendencies and also thereafter, again.
what is the offense? 498 A.
498.
So other tendency again ಸಂಬಂಧ.
ಅದು ಆದ್ಮೇಲೆ ಸಾರು ಇನ್ನೊಂದು in her own complaint, page 20, my lord, page 20.
You are the husband.
I am the husband, mother and brother and sister, page 20, my lord.
Why did you let the petition remain?
2008 they are married, my lord. 2021 this complaint is filed and she only states that 19/2/2021 ನನಗೆ ಬೇರೆ ಮನೆ ಮಾಡಿದೀನಿ ಕರೆದ್ರು ಅಂತ ಹೇಳಿ ನಾನು ಹೋಗ್ಲಿಲ್ಲ. ಆಮೇಲೆ I was hospitalized. Then she has lodged a complaint. No allegations have been made out. No just general allegations. Against other accused, there are no allegations at all. Investigation lo ಏನು allegations ನಮ್ಮ ಮೇಲೆ ಏನು ಬಂದಿಲ್ಲ ಸರ್, including the petitioner husband.
No, don't argue for the husband, you will lose others.
But mother, sister and brother, my lord.
Yes, sir.
My lord, with respect to the other accused, my lord, 2 to 4, ಅವಾಗ ಬಂದು ಹೋಗ್ತಾ ಇದ್ರು.
ಅವಾಗ ಬಂದು
ಹೋಗ್ತಾ ಇದ್ರು, ಪ್ರಚೋದನೆ ಮಾಡ್ತಾ ಇದ್ರು ಅಷ್ಟೇ ಇದೆ.
So ಅವಾಗ ಬಂದು ಹೋಗ್ತಾ ಇರೋದಕ್ಕೆ 498 A, 323. Why not 6, 323, 504?
Charges framed, my lord, in other cases also, my lordship has taken a view that once the charges is framed, my lord.
Even when there is a misuse of legal process and allowing continuation of trial would be unjust and our high courts have.
Give it.
2012, Dr. Ramappa, he was a state of Karnataka,
Please.
2012 Karnataka. I will. play
Give the judgment or take my judgment, we'll dismiss it. ಮಧ್ಯಾಹ್ನ, ನಾಳೆ, tomorrow. Then dispose ಆಗಿಲ್ವಾ?
Can respond to the complainant, Madam. Can you see page 26, Madam? Tashidar, the deputy Tashidar recommends for, gives a report stating that there is no encroachment on the land and recommends for withdrawal of the case pending before the land grabbing court. Madam.
Yes.
No, may please record, my lord, there is encroachment. Unfortunately, my lord, 2 years, 2 months, there is no investigation in this case.
Encroachment ಕಂಡಿಲ್ಲ.
ಎಲ್ಲ ಮಾಡಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿಲ್ಲ for various
Why
reasons.
ಮಾಡಿಲ್ಲ?
I have asked the SP to seek an explanation from the concerned officer.
The learned additional SPP submits that, sorry. To a query of this court, the learned additional SPP would submit that investigation has not taken place for the last 2 years and 2 months. Therefore, the investigating officer shall show cause as to why the investigation has not been conducted in the case at hand for the last 2 years and 6 months. In that light, till the explanation is submitted, there shall be an interim order of stay of further investigation.
I've spoken to SP, my lord. I've asked him to seek an explanation.
And what is that he is referring to,
No,
that
he-
it should be
all these
closed?
things, my lord, then I looked into the, perused the files, my lord. There's a clear encroachment. This is a complaint filed by the
you
government
have-
I
official.
filed
my lord.
a document along with a memo, my lord. Personal kindly, but the surveyor has filed the report, my lord, stating there is no encroachment. They say Nala has been enclosed. The surveyor says BBMP has put concrete on the Nala and water is flowing, my lord. That is the report given by the
Yes,
surveyor.
sir.
No, they have,
Copy has been furnished to the government, my lord.
no, I'll look into that, my lord, but the instructions, my lord, then after looking at the paper,
The learned counsel for the petitioner has filed a memo along with documents enclosing a survey sketch of survey sketch of the surveyor, which depicts that the encroachment, which depicts no encroachment, as the BBMP is said to have put a concrete on the Nala and water is freely flowing in the said Nala, and there is no encroachment by the petitioner. Learned additional SPP would secure instructions. There shall be an interim order of stay of further investigation for all the aforesaid reasons. List on 20th in the fresh matters list. The affidavit of explanation by the investigating officer be filed by then. Yes.
memo copy.
Kottilva copy.
Copy has been served, my lord. Applying to ಇನ್ನೊಂದು copy ಕೊಡ್ತೀನಿ.
Kodi.
19.
ಅದು ಸರ್ವ್ ಆಗಿದೆಯಾ?
ಸರ್ವ್ ಆಗಿದೆ.
ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ? ಅಷ್ಟು ಬೇಕು ನಂಗೆ. 25/7. The council, the petition respondent complainant has been served on 25/7/2024. ಅಲ್ಲ 27/5. 25/7. 2024. Therefore, one more opportunity for his appearance to be granted. List the matter on 20th in the fresh matters list. ಅವತ್ತು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ yes. ಭಾರತ್ ಮಾತಾ ಕಿ ಜೈ ತಾನೆ? Yes. ಅಲ್ಲ, that is the issue. Yes. Interim order subsisting shall continue till the next date of hearing. 20 pass over.
21.
Yes, Latif.
Please. The application filed by the.
You are appearing in
accused-
person?
Yes, sir.
Lord, the application filed by the accused under section 91 of CRPC to produce the tower location of the complainant and the investigation agency was conducted a raid on 4/12/2021.
You are complainant, huh?
Accused.
A1, sir.
Oh, you are the accused. All right. Tower location yak ಬೇಕು?
That is the matter. That
Why?
is, because of that, Lord, we are, that order has,
But what are you going to prove with the tower location?
Lord, there are, the trial court has directed us to produce those tower location. That was our order is under challenge.
ಸರ್, ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿರೋದು ಒಬ್ಬ ಆದ್ರೆ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿರೋದು ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿ.
ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿರೋದು
ಇನ್ನೊಬ್ಬ ಆದ್ರೆ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿರೋದು
ಇನ್ನೊಬ್ರು
ಇನ್ನೊಬ್ಬ
ಅಂತ ಹೇಳಿ,
ವ್ಯಕ್ತಿ.
ಇನ್ನೊಬ್ಬ ಅಂತಲ್ಲ.
ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿ ಆದ್ರೆ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿರೋದು ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿನ ಲಾರ್ಡ್ಶಿಪ್. FIR ಅಲ್ಲಿರೋ ಅಲಿಗೇಷನ್ ಯಾವುದೇ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ, ಆದ್ರೆ ಮಹಾಜರಲ್ಲಿ ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿ ವಿರುದ್ಧ ಮಹಾಜರ್ ಡ್ರಾ ಮಾಡಿದ್ದಾರೆ.
Who demanded, who accepted?
Lord, the actual demand by accused number 1 and accused number 2 only, 1 only they accepted and partial amount has given to accused number 2.
ಲಾರ್ಡ್ಶಿಪ್,
Then why do you want the tower location? Of whose tower location you want?
ಐದರ್ ಕಂಪ್ಲೇಂಟ್ ಆರ್ ಪೊಲೀಸ್ ಅಫಿಷಿಯಲ್ಸ್. ಯಾಕೆಂದ್ರೆ ಇವ್ರು ಹೇಳ್ತಿರೋ ವಾಯ್ಸ್ ನನ್ನ ಪ್ರೂವ್ ಮಾಡೋದಕ್ಕೆ FSL ರಿಪೋರ್ಟ್ಗೂ ಕಳ್ಸಿಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್ ಇವತ್ತರೆಗೂ.
Lord, the matter is under, when it was filed,
Why
Lord,
have you
matter
not
is,
sent it to FSL?
now it has sent, Lord, charge sheet was filed during the pendency of this petition. Lord, on 25/8/2024.
What is the date of trap?
4th December 21.
4th December 21.
21.
For 3 years, why did you not send
Lord,
it to the FSL?
Lord, as on the date, Lord, it was an AC.
Please see for page number 45. ಅವ್ರ FSL ರಿಪೋರ್ಟಿಗೆ ಕಳ್ಸಿರೋದು 45.
Lord, as on the date.
ಫಿರ್ಯಾದಿ ಮಾದರಿ ಧ್ವನಿ.
ಅದರಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಮರ್ಜರ್ ಕಲದಲ್ಲಿ ತನಿಖೆಗಾಗಿ ತೆಗೆದುಕೊಂಡ ಫಿರ್ಯಾದಿ ಮತ್ತು ಆರೋಪಿ
ಎಲ್ಲಿ
ಎರಡು
ಓದ್ತಾ
ರವಿಕುಮಾರ್.
ಇದ್ದೀರಾ? 1 minute, ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೆಕೆಂಡ್ ಲೈನ್.
ಫಿರ್ಯಾದಿ ಅವರ ಮಾದರಿ ಧ್ವನಿ ಅಲ್ಲ.
ಅಲ್ಲಿಂದ
ಸಣ್ಣ ಪುಟ್ಟ ಇಲ್ಲಿ ಏನೋ ಮಾಡ್ಕೊಂಡು ಅದ
Page number 45.
I'm at
First
45.
paragraph, second line. ಮೇಲಿಂದ 2 lines.
ಆರೋಪಿತ ಮೇಲಧಿಕಾರಿಗಳ ಅದ
ಅಲ್ಲಿಂದ.
ಹೇಳಿ.
ಬಿಟ್ ಕೂಡ ಅವರಿಗೆ ಇಂಟರ್ಸ್ಟೆಡ್ ಮರ್ಜರ್ ತನಿಖೆ ಕಾಲದಲ್ಲಿ ತೆಗೆದುಕೊಂಡ ಫಿರ್ಯಾದಿ ಮತ್ತು ಆರೋಪಿ 2 ರವಿಕುಮಾರ್ ಅಂತ ಇದೆ ಸರ್. ಅದ್ರದ್ದು ವಾಯ್ಸ್ ಸ್ಯಾಂಪಲ್ ನ FSL ರಿಪೋರ್ಟ್ ಕಳಿಸಿದ್ದಾರೆ. ಇಲ್ಲಿ
ರವಿಕುಮಾರ್
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಆರೋಪಿ 1 ಅವಿನಾಶ್ ನವರನ್ನ ಮೀಟ್ ಮಾಡಿದಾಗ ಮಾತಾಡಿರೋದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿದೀನಿ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ರವಿಕುಮಾರ್ ಮೇಲೆ ಯಾವುದೇ ರೀತಿ ಅಲಿಗೇಷನ್ ಇಲ್ಲ, FIR ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ಲ. ಆದ್ರೆ ಇಲ್ಲಿ ಕಳಿಸಿರೋದು ಮಾತ್ರ FSL ಗೆ ಆರೋಪಿ 2 ರವಿಕುಮಾರ್ ವಾಯ್ಸ್. ಪಿಟಿಷನರ್ ಹೇಳ್ತಾರೆ ಆರೋಪಿ 1 FSL ಕಳಿಸಿದೀನಿ ಅಂತಾರೆ. ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಸರ್.
Lord, the demand was made by accused number 1.
ಎಲ್ಲಿ ಸರ್?
Lord, kindly see the demand, the pre-trap measure.
Matter is a stage of trial, is it?
Yes, Lord. Now, Lord, the charge,
Correct allow ಮಾಡಿದ್ದಾರೆ 91 application. Anything else?
Lord, now the charge sheet is filed. I'll go through that, Lord, the charge sheet. It is not part of this petition. During the pendency of this petition, charge sheet was filed. I'll verify it in the charge sheet, Lord, whether they collected the sample or sent to the FSL or
Wednesday in the fresh matters list. 6 day ಆಗಿದೆಯಾ?
stay agide.
Wednesday we'll close it.
Please.
He is right in asking. Prima facie. Yes.
ನಾನು ಕೇಳ್ತಿರೋದು ಪ್ರಿಸರ್ವೇಶನ್ ಅಷ್ಟೇ. ಕೊಡಿ
Lord,
ಅಂತ ನಾನು
it is
ಕೇಳ್ತಿಲ್ಲ.
his defense, Lord. He can adduce the
see.
defense at the stage of defense.
Sir, if you have not done the foundation itself, what defense? We'll see.
We collected the samples.
Kodi. Yes, list on 11th in the fresh matters list. Next.
22.
Interim order application.
Interim order subsisting, ಅದು continue ಮಾಡಿ.
Notice the offense are under 376 and 506.
You're appearing for respondent?
Respondent number 2, my lord.
Learned counsel so and so undertakes to appear, undertake, you already filed wakalat?
Not yet, my lord. I just received the
Learned
file.
counsel so and so undertakes to enter appearance for the respondent. Petitioner to, respondent registry to print the name of so and so is appearing for the respondent. Yes, file your objections.
Yes, my lord. Short accommodation.
Notice the matter is already committed to trial. There is no
Let it
interim order
come.
in this.
So what?
There is no interim order. That may be
No
considered.
interim order, I know. I have not granted an interim order.
IA may be considered, my lords.
No, yes, let him file his objections. List on 21, sir, 2 weeks.
Grateful, my lord.
Yes, list on 24th in the fresh matters list.
Great.
Yes.
23.
Yes, Latif.
Lord, second respondent is the police. The state may be directed to take notice.
The learned HCGP is directed to accept notice for the second respondent as well. Registry to print the name of the second HCGP appearing for the second respondent. List after 2 weeks interim order subsisting shall continue to the next date of hearing.
And it is covered by the Firdos Khan case, Lord.
Covered,
Word ಇದೆ ಆದ್ರೆ my lord, what has happened, my lord?
rest after 2 weeks. Covered illa andre illa. Yes, next. Interim order ಇದೆಯಲ್ಲ?
Ide.
Entry ಮಾಡ್ರಿ.
Next. Yes, Avinash.
Aggrieved by the order dated 1/7/20.
311.
Please, ma'am.
Not behind the fact, the petitioner has admitted in the cross-examination, there is an inordinate delay of 2 years for filing complaint.
All right.
The complaint is
The
barred
court
by
will
time.
take note of. Now 311 application ಏನಕ್ಕೆ ಬೇಡ ಅಂತ? Why is it rejected?
My lords, on the grounds that, my lords, no application was annexed to the application, no documents was annexed to the application, my lords.
Were they or were they not?
Were they, my lords?
Which,
My lord,
which
the
document?
sufficient cause has
Promissory
not shown in
notes,
the application.
promissory notes, my lords.
Annexure ಮಾಡಿದ್ರಾ?
Annexure ಮಾಡಿರಲಿಲ್ಲ, sir.
ಯಾಕೆ
ಮಾಡಿರ್ಲಿಲ್ಲ.
ಮಾಡಿರಲಿಲ್ಲ.
And what's wrong with the order?
My lords, your lordship.
You
have
can't
observed-
seek 311 application in thin air, sir. Something should be there.
I understand, my lords. My lords, your lordship have observed, my lords.
I have observed many things in many cases, but I will observe this also in this case and dismiss it.
Lords. It's a complaint, my lords, where, my lords, I may be.
Yes, we will give him one opportunity. Let him produce all the necessary things and file an application afresh.
Please, my lords.
The petitioner is before this court calling in question an order dated so and so rejecting an application filed under section 311 of the CRPC. The rejection is on the score that the petitioner did not append to the application all necessary documents that he would want to seek to be examined or further cross-examine the, you are the complainant, is it?
Please, my lords.
further examine the accused. The petitioner submits that illaru hakidira.
ಇಲ್ಲ ಹಾಕಿದ್ದೀನಿ.
The
Chief examination of the complaint.
the petitioner has produced the necessary documents before this court, though admitting that the petitioner did not place those documents on record. In the light of the documents being in existence before this court, I deem it appropriate to grant an opportunity to the petitioner to file an application of fresh appending all the necessary documents that he is wanting to pursue by way of examination in chief of the petitioner for the aforesaid reasons following order. The order date petition allowed, order date so and so stands quashed. The petitioner is permitted to file a fresh application under section 311. The concerned court shall pass necessary orders in accordance with law, bearing in mind the observations made in the course of the ordered accordingly.
This is NDPS, NDPS,
Yes, Tejas.
Please, my lord. My lord, I'll place the investigation papers, my lord.
Est ganja?
100 grams of ganja, my lord, from the possession of this petitioner.
Possession of whom? In your possession?
Yes.
Let him get the papers.
I'll get
Yes.
the papers.
List on 19th.
Please.
The learned HCGP to secure, learned HCGP Tejesh to secure instructions or same order, huh? Yeah. The learned HCGP, Tejesh seeks time to secure the investigation papers, comma, yet again. Therefore, as a last chance, the HCGP is directed to secure the investigation papers, failing which the court would be constrained to grant an interim order. List on 19th.
26.
It's a matter where the bank officials of the second respondent are involved in forging and sanctioning loan against my property, my lord. And
Where
there's
are-
no specific
notice
allegation
agidya.
against me, my lord.
No, sir, wait.
Annexure B may be.
No, sir. Who is served? Jawad served again. 28. List the matter on 19/8.
Not, I have to file a memo.
Please, sir, do it.
There's a
You want to
matter
withdraw?
pending before this honorable court.
Ah.
Where this honorable court has granted a stay with regard to second respondent bank
Give
official.
it, give it.
On the same matter, my lord.
Will-
Case and counter case.
Wills, bank officials, case and counter case, sir.
I have filed, my complaint is the first complaint, my lord.
Counter blast.
Based on that, they file and there's an interim order, my lord.
Tag this petition along with writ petition 7122 of 2024. List them all on 11th in the fresh matters list.
Not interim order.
That day, sir. Either will vacate that or grant here. Yes.
27.
In this case, my lord. Lord, there is no allegation against this petitioner 1 and 2 is the
But what is the allegation?
Letter. Section 420.
511.
Yes, my lord.
Yes.
Lord, in the FIR itself, complaint itself, my lord, page 12, my lord.
Yeah, 511.
My lord, I have placed the investigation papers, my lord. I was directed.
1 HCGP, 2 emergent notice. The HCGP shall secure the investigation.
My lord, I have placed, my lord, on the last occasion.
That, permit me to read.
1 minute, sir. Why 511?
Lord, allegation ಇಲ್ಲ.
Investigation papers.
ಅಲ್ಲ ಅಲ್ಲಿ ಮಿಲ್ಲಡ್ ಇವರು ಫೋರ್ಜರಿ ಮಾಡಿರೋದು ಇಬ್ರು.
List on Monday, Monday in the fresh matters. Yes.
Please.
28.
I have a quarrying leave, my lord, to query at server number 1. My lord, the allegation is.
Actually, I have to secure papers. For the first time, my lord, I am seeking time to secure papers.
I'll begin to grant interim orders if we don't secure
my lord,
henceforth. Tuesday in the fresh matters
My lord,
list.
Please.
The learned HCGP Tejesh seeks time, comma, yet again to comply with the order dated 13/8/2024. In the event it stands uncomplied on the next date, this court will be constrained to grant an interim order of stay. Yes.
29. For the petitioner in this matter. 307, 506, 341 are the offences alleged. Petitioner is no assailant. Yeah, complainant says that some 3 to 4 unknown persons assaulted him in the complex of the.
Oh, you're
palace.
accused number 7 in this case.
He is no assailant, your lordship. The allegation is, none of the offences alleged can be attributed to him. He is not present at the spot, and the motive that is attributed to him dates back to 2021. A OS was registered by the daughter of the de facto complainant.
Let the complainant come. Yes.
Your lordship,
Complaint serve ಆಗಿದೆಯಾ?
sir, notice.
No, my lord.
Lordship, if I may take your lordship to the document, the complaint, your lordship, ಅದರಲ್ಲಿ ಹೇಳೋದು page.
Let the
90.
complaint, emergent notice to the second
Lordship, one
respondent.
moment, your lordship. OS matter pending ಇದೆ. 2021 ಅಲ್ಲೇನೆ daughter of the
Interim order
complainant.
ಆಗ್ಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ madam.
ಕೊಟ್ಟಿಲ್ಲ, your lordship. There's no.
The emergent notice to the respondent returnable by the 26th of September. List on 26th in the fresh matters list. Interim order subsisting shall continue to the next date of hearing. Yes,
There was no interim order.
last time order ಇದೆ. Yes.
30.
I appear for respondent number 2 in this matter. I filed wakalat on it.
You have filed wakalat.
I filed wakalat.
The learned counsel so and so submits that he has entered appearance for the second respondent registry to print the name of so and so as appearing for the second respondent. List after 2 weeks, interim order subsisting shall continue to the next date of hearing. No date. ಇದೇನ್ ಮತ್ತೆ? ಇಷ್ಟೊಂದು ಯಾಕ್ ಹಾಕ್ಲಿ? ಅದೇ ಹಾಕಿರ್ಲಿ ಸದ್ಯ. We'll take it on. ಅದು last time interim order extended ಅಂತಾಗಿದೆ ಅದಕ್ಕೆ. Thought it was there. Pass over. I'll hear you in the afternoon. Finish your work and come. Yes. Madam, tell her not to say. Madam, without reference, let her not extend the interim order like that. Yes. Next.
31.
Lord, in this matter, charges is framed on 18/3/2021, man.
21, 3 years ago.
Evidence comments ಆಗಿ almost.
ನೆನ್ನೆನೂ ಬಂದಿಲ್ಲ ಇವರು.
Please.
There is no representation way of the petitioner. List the matter after 4 weeks. The pendency of this petition before this court will not come in the way of further proceedings before the concerned court. Next.
32.
I praise 2 weeks time to file an affidavit, my lord, one-way entry passport.
In this case, my lord, your lordship had directed me to get instructions from the Indian Embassy, Washington. Please, my lord, the instructions are here, my lord.
Good.
ಅದೇ. But he has withdrawn his travel document.
Was pending against me. Yes, no, sent back. You have requested for withdrawal of the passport?
The page 4, my lord. Page 4, my lord, his letter, my lord. Passport application withdrawn letter. He has withdrawn it, my lord.
You approach the court for a short validity passport if you want.
Lord, probably my learned friend does not know how to apply, my lord. I am giving him the.
Copy kodi.
No, this is the format, how it has to be applied there, my lord, in the Indian Embassy.
ಅದು ಏನ್ ಮಾಡ್ಬೇಕು ಅದ್ ಮಾಡಿ. You have yourself withdrawn the passport.
Please.
Yes. We'll list it after 3 weeks.
Great.
List after 3 weeks. Yes.
33.
Appearing for the petitioner, my lord, 306 and 66 E and 67A of IT Act, my lords.
ಏನು ಇಷ್ಟೊಂದು? ಏನಿದೆ document ಇಷ್ಟೊಂದು?
Charge sheet, my lords, entire charge sheet. The entire charge sheet, they have completed the investigation and filed charge sheet only on the basis of the voluntary statement of the accused, my lords. No materials.
The accused. Voluntary statement, of your voluntary statement.
Yes, my lord.
Sir.
Page number 13, my lord. Column 17.
What were you in relation with the deceased?
Living relationship, my lords.
Anything else?
My lords,
Ilva?
No, my lord.
the entire communication has been this, my lord. The reason is she has lots 51 lakhs, my lords, in share trading. For the reason she had, even the columns number 17 also states that, my lord.
What was, the last call was to you?
Yes, my lord. Even the chats has been,
They're all matter. Very evidence. Voluntary statement biಟ್ಟು.
The statement.
What did you,
WhatsApp chat.
what is your WhatsApp chat ಏನಿದೆ?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ. Nothing has been done, my lords. The WhatsApp chat.
List the matter in admission on 19th. Early parallel.
My lords.
Wait, yes. If you are not connected at all, then it's a different thing.
Notice.
Next.
34.1. 34.1, Lord, there is an interim order granted by this court.
Whereas I'm at 34.
Hmm.
So I produced the order sheet on the previous occasion, my lord, saying that there is an stay proceedings pertaining to a few of the accused numbers. So then in this petition, that has been tagged along with 34.1, my lords.
This is a very strange complaint, my lord.
Where, ಅದು ಕೂಡ entry ಮಾಡ್ರಿ ಯಾವ್ದ್ರಲ್ಲಿದೆ?
My lords, I've given a separate memo.
1 minute.
Yes, my lord.
Me wearing.
My lords, now I've come here.
Co-accused, huh?
petitioners-
You are co-accused?
First thing.
Yes, co-accused, my lords. So I am here for A1.
This court on 29 to, ಇದು ಯಾವ್ದ್ರಲ್ಲಿ ಬರೀರಿ ಅಂದ್ರೆ? ಇವ್ರ ಕೇಸಲ್ಲಿ ಬರೀರಿ.
Yes, mine is 8158, my lords.
ಅದರಲ್ಲಿ.
of 24.
This court on 29 to 2024 in favor of the petitioners in writ petition 6318 of 2024 has passed the following order. In the light of the interim order subsisting qua the other accused in the companion petition, there shall be an interim order of stay as is obtaining in the aforesaid case till the next date of hearing. One notice ಆಗಿದೆಯಾ? ಇಲ್ಲಲ್ಲ?
Yes.
One,
No, not the
one HCGP, two emergent.
In one it has happened. Yeah, in my case.
Yes, next.
Case interim order has to be extended. In
Uh,
my
int-
case.
Interim order subsisting in 8158 of 2024.
631. 631.
Sorry, 6318 of 2024 shall continue till the next date of hearing.
35.
Post immediately after service of notice upon the respondent. Next. Interim order, yeah.
Someone serve ಮಾಡಿದ್ದೀನಿ.
Interim order ಇದೆ. Interim order subsisting shall continue till the next date of hearing.
They are
Madhukar.
prosecuted under the Factories Act. But a workman, but petitioners are in the business of construction of ships. They had, there was a hull shop for which repairs were to be carried out on the roof because it was leaking. We had given it on a contract for repairs of that roof, not part of the factory manufacturing process. But he employed about 2 persons to fix the screws. Admittedly, this is the part of the. He fell down and injured his leg. And therefore a complaint is filed alleging 32C of the Factories Act.
304 ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ. They are under the Factories Act. All that I am bringing to Lordship's notice is, but if it is not part of the manufacturing process, Factories Act is not applicable. In fact, I was telling them that you may be liable for 304 part 2 in a different part 1. But not under the Factories Act. May I request Lordships to kindly permit me to read the definition of factory under the Factories Act. Section 2M. Factories Act. Section 2M. 2M. Factory means any premises including the presence thereof, whereon 10 or more workers are working or were working on any day of the preceding 12 months and in any part of which a manufacturing process is being carried on.
What are you?
Lord, I'm occupier, of course, my lord. So I'm occupier. This person who is injured was employed by my contractor for whom, my lords, I had asked them to repair a roof of a hull shop.
But no, it was a factory.
Within the factory premises, but within the factory premises, not my submission before your lordships is, if ordinarily, my lords, if I do not employ them for the purposes of the manufacturing process, lordships have seen the definition of manufacturing process under section 2K, but it come within the definition. The honorable
Who died?
Nobody died. Nobody. It's an injury.
it's
Injury
accident.
of accident, injury. He fell down. But I
304 ಬರಲ್ಲ.
no, I'm just bringing no any other offense, but he did not die. He injured his leg, but we have provided them all the medical care, etc. We may be also liable for compensation on the civil side. But
How much have you paid?
Our claim madidara. We will pay more, but I will say they have not yet made. We will pay that surely. No, hospital is one thing.
Hospital expenses.
Hospital expenses they have taken care, but we will also pay them under the provisions of the Workmen Compensation Act.
No, that they will claim. Apart from that, what do you pay?
Lord, if they are to come and make a claim, make a
Your advocate on record should know.
whatever it is, we will commensurate with the injury which he has suffered and the loss of work, etc.
Apart from what he would claim under the workman's compensation.
Yes.
All right. Yes.
We have to be fair. There is no question. If he has got injured, the workman, we must compensate.
Yes, sir. Heard the learned senior counsel Prabling Nawadgi appearing for the petitioner. An employee, a workman.
It's only one aspect. One observation of the Honorable Supreme Court on this question, what I thought I must place.
I'll grant stay, but you have to inform the court about the compensation.
No, certainly. Besides that, I thought I must bring to Lord's notice the reason why. Para 34.
Party, my lord. Party, let them make
party ಮಾಡಿಲ್ವಾ ಅವ್ರನ್ನ?
ಅವನನ್ನ ಮಾಡಿಲ್ಲ. Because only assistant director of factories.
Normally state inspector of factories initiate ಮಾಡ್ತಾರೆ ಅವ್ರಿಗೆ.
True.
We can add them. We'll
add the victim.
Para 34 of this judgment. Para 34 lords. But on the conjoint reading of the aforesaid provisions, it becomes clear that factory is that establishment where manufacturing process is carried on with or without the aid of power. Carrying on this manufacturing process or manufacturing activity is thus a prerequisite. It is equally pertinent to note that it covers only those workers who are engaged in the said manufacturing process. Insofar as these appellants are concerned, construction of building is not their business activity or manufacturing process. In fact, the building is being constructed for carrying out the particular manufacturing process, which in most of these appeals is generation, transmission, and distribution of power. Obviously, the workers who are engaged in the construction of the building also do not fall within the definition of worker under the Factories Act. On these two aspects, there are no cleavage of power, so and so. That is the principal note which has been raised in the present question, notwithstanding the fact that will come to pass.
We take this view.
No, I am
in the facts of this case.
No, the reason is this one. We contemplated different situations. For one-off activity, if I have to call somebody into my factory for doing something ancillary, no way connected with manufacturing.
That's why, as a one-off case, one-off compensation, we'll issue a one-off interest.
No, I am not for a moment. For Lordship, we were contemplating different situations. Let us say, I call for catering business, catering
into the factory.
No, that's all
Something
right.
happens.
It's not.
But however, if I'm ordinarily employed, then I am liable for this. That
It's
is
all
what.
right. Yes, we'll see. But compensation on
No,
humanitarian.
certainly, Lordships may record my statement. They have instructions. We
Heard
will pay.
learned senior counsel
can't dispute
Prabin
that.
Navatgi appearing for the petitioner. The learned counsel for the advocate on record shall implead the victim as a party respondent to these proceedings. One, sorry.
Anup Shetty. Yes, please.
Learned HCGP is directed to accept notice for respondents 1 and 2, emergent notice to the third respondent. The learned senior counsel would seek to impress upon the fact that the workman who sustained injuries on an accident happening on, when is that?
12/8/2023.
On 12/8/2023 was not a worker who was employed in permanence with the petitioner, but was an employee who was engaged by the contractor and would seek to place reliance upon the judgment of the Apex Court in the case of 2016 10 SCC page 329. The decision, the issue would be thrashed out at a later point in time. The learned senior counsel would submit that apart from the hospital expenses that are taken care of by the petitioner, they would also pay certain amount of reasonable compensation to the injured third respondent. In that light and the matter requiring consideration, there shall be an interim order of stay of further proceedings quae the petitioners till the next date of hearing.
Lords, if Lordships feel it necessary, or if Lordships direct, we'll find out how much money we will deposit, and also Lordships may record that statement also, if we can just ask.
The
so that-
learned senior counsel would on instructions submit that certain amount of money would be deposited before this court towards the compensation that is observed here and above.
Yes.
The deposit shall be made by the next date of hearing, list on 26th
Please.
in the fresh matters list. Yes, next.
37.
Wait, please, my lords.
No settlement?
No settlement, my lords. So we are on merits.
Diljit sir is appearing for the petitioner.
Yes, my lords.
My lords. My lords, may I just take the liberty of passing on a 3-page memorandum, my lords, just to assist my lords, because as usual, the pleadings are
Then
very,
shall we hear it in the afternoon?
as my lord pleases.
Not today, why?
Several matters in the afternoon. Lordship may fix a date.
Now,
then
what's
we'll
the
argue it.
what's the issue in this?
This is that 340 application, Lord.
Oh,
The
perjury.
340
Perjury application. I'll make my submissions.
Hmm.
Your Lordship may fix a date anytime, Lord, next week or at
My lord,
2:30 or at some time, Lord. Take what?
Diljit sir will fix it on 18th.
18th, I'm not there.
That should be all right.
Well,
Can it be 19th? Sorry,
18th or 19th, whatever day is convenient to both of you.
19th at 2:30.
List on 19th at 3:30 PM.
Right, very good.
Yes, perjury ಅಷ್ಟೇ ಅಲ್ವಾ?
ಅಲ್ಲ ಅವ್ರು ಇಲ್ಲಿ ಪರ್ಜರಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ನಾವು ಅಲ್ಲಿ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತೀವಿ.
All right.
So
Will not make a surgery out of perjury here. Yes.
you may have to do another 340.
No, we'll see. Yes. Next.
okay.
38.
Non-amendment of cost title.
Last occasion, Lord.
Heard Diljit ಅಂತ ಮಾಡ್ಬಿಟ್ಟು ಮಾಡಿ.
There is only amendment I sought for is for prayer, which I have already carried out.
The learned counsel for the petitioner submits that the cost title has been cost title.
ಇಲ್ಲ ಕಾಸ್ಟ್ ಟೈಟ್ಲಿಗೆ ಏನು ಅಮೆಂಡ್ಮೆಂಟ್ ಇಲ್ಲ. ಓನ್ಲಿ ಪ್ರೇಯರ್ ಕೇಳಿದ್ದೆ, ಪ್ರೇಯರ್ ಅಮೆಂಡ್ ಮಾಡಿ ಅಮೆಂಡೆಡ್ ಇದನ್ನು ಪೆಟಿಷನ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ.
The learned counsel for the petitioner submits that what was sought was an amendment to the prayer and that has been carried out. In that light, the registry is directed not to show non-amendment of cost title in the cause list. Interim order subsisting shall continue till the next date of, ನೀವು respondent ಈಗ?
Please, Lord, I'm for the respondent.
ಯಾವ್ದು 39, 38?
38.
Third ಅಂತ ಇದೆ?
So that is in respect of Lord R3 IP for the society.
All right, we'll hear it. Yes. Urgency ಇದೆಯಾ?
Some urgency.
ಏನ್ some urgency?
But investigation is stayed here.
The correct. What's the matter? sir?
The matter is I sought for two prayers, my lord.
Huh.
One is the day when they have served the 41-year notice, only 420, 408 is the offense, 7 years. 7 o'clock, they served the notice. When I went to the police station, I have been arrested. And then
There's a.
I also
interim
see
order.
predominant, yes.
Rest the matter after 2 weeks, interim order subsisting shall continue till the next date of hearing. Next.
May I request in the last week, my lord? But I'll be out of station for some time.
2 weeks, date ಕೊಟ್ರೆ ಬರಲ್ಲ ಇಲ್ಲಿ, date ಕೊಡದೆ ಇಲ್ಲ. Yes.
Lordship, I fix the date, no, okay.
October.
So the investigation is stayed, my lord,
Next bench.
there is misappropriation of more than 20
The
crores.
same judge who granted the interim order will come back, you will hear it, yes.
My lord,
Hearing for respond number 2 in
39, my lord, 39.
39.
Literally.
Before my learned friend starts, my lord, I only want some time because the entire charge sheet has not been placed on record.
Charge sheet is filed?
No, my lord, it's not the
Entire charge sheet
entire
has
charge
not
sheet.
been-
Charge sheet
my
is
lord.
filed.
I managed to get one certified.
Managed to get.
My lord, I applied for the certified.
All right, no problem.
My lord, I will
We'll
just
ask
submit,
the
my
state
lord.
to
Yes,
produce
my
it.
lord, if they can do
Just
that.
submit, my lord, what is the facts of the case.
Huh.
My lord, serial
There is
number,
an interim order.
there is an interim order. My lord,
Oh, this is
39,
that Bloda committee.
for the committee.
My lord,
Ah.
one
My lord,
submission, my lord.
39 and 39.3 and 39.4
Ah.
are the cases where, my lord, complaint given by an RTA activist saying that, my lord, there is section 420, offense under section 420.
Ah.
My lord, as for 39.1 and 39.2,
Hmm.
the complainant who had given a complaint has, my lord, settled the matter with us. And my lord, he has given, my lord, a MOU has been entered before the sub-registrar. And my lord, that copy is also here. Now he has agreed, my lord, to withdraw this complaint also
No,
with
no,
the
my
MOU.
lord, completely false, my lord.
31,
I will just-
39.1
I appear for respond number 2 in that case.
Nagarajappa, yes.
Please, my lord,
Nagarajappa, in the
I appear for
Nagarajappa's
respond number
case-
2 in that, Nagarajappa, my lord.
What's your
Completely
name?
false.
What is your names?
Harsha D. Joshi, my lord, appear.
Learned counsel Harsha D. Joshi submits that he has entered appearance for the second respondent. A registry to print the name of so and so as appearing for the second respondent. Adagli. Next.
My lord, in
I
that
will
case,
file
my
my
lord,
objection, my
if I may,
Ah.
if I may permit, my lord, produce the MOU, my lord, where they have agreed, my lord, to withdraw the case.
Yaru, that Nagarajappa,
Nagarajappa,
Kodi.
Copy.
Page,
my lord, page 4,
page 4.
page 4 my lord, of the memo which I just filed, my lord.
Ah.
The deed of agreement is made on executed on so and so Nagarajappa Munraju, who is the petitioner here in my lord. Next page, your lordship may kindly see. Whereas the first party has informed about such mistake to facts to so and so, and with this concern, the first party hereby confirms the second party that the issue related in the above said complaint is resolved amicably and there are no claims against each other. And further, the first party hereby confirms that he has no objection to withdraw the complaint and hereby informs the second party that he can apply for quashing of the said complaint and the first information report before the appropriate judicial. Now, my lord, the entire allegation in the complaint is that we forced him, my lord, to do a sale deed. The complaint is given after 14 months. The allegation in the complaint, and he has, my lord, and it is a registered MOU.
My lord, one submission, my lords. In that agreement to sell, my lords, the amount, consideration
Yes,
amount.
agreed to withdraw the complaint
Not
itself, sir.
My lord, I will seek
Seek
instruction.
instructions.
And one more thing, my lords, in 1 crore 61 lakh rupees, they have stated in agreement of sale, which they have produced in the main petition, my lords. In the entire bank statement, my lord, we have gone through it, my lords. No amount has been credited to the vendor, my lord, and the complete signature has been forged, my lord. Pratik Kumar,
Nagarajappa is the complainant.
Nagarajappa is the complainant, my
And
lord.
then what is this? If he has registered the complaint and
Please, my lord, I will.
registered in what agreement that he would withdraw everything?
I will verify, my lord.
Verify.
Please, my lord.
Heard the learned counsel Bipin Hegde appearing for the petitioner. The learned counsel would submit that in petitions 39.1 and 39.2, the complainant is one B Nagarajappa. After registration of after the crime,
After the crime.
after the registration of the crime, the said complainant has, by way of a registered agreement, agreed to withdraw the complaints so registered by him. The learned counsel appearing for the second respondent is taken by surprise, as he is not aware of any such agreement being entered into between Nagarajappa and the petitioners, notwithstanding the fact that it is a registered document. The learned counsel would seek time to secure instructions and make his submissions on the issue. Therefore, I list this matter on 18th at 3:30 PM for further hearing. Yes.
Lord, as far as that serial number 39 and
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಬರ್ಲಿ ಅವತ್ತೆ. Yes.
Lord, the interim order granted earlier. as-
Interim order subsisting in any of these cases shall continue till the next date of hearing.
For the petitioner. The petitioner is a warehousing corporation, my lord, who is a victim before this
ಅದೇ
honorable.
ಗೊತ್ತಾಯ್ತು.
Please, man.
Pass order, sir. Not been able to get time to pass orders.
Please.
Will list it on Tuesday or Wednesday.
Please, ma'am.
Yes.
Lordship, if your lordship may reserve the matter.
ಅದಾದ್ರೆ ಜಲ್ದಿ ಬರುತ್ತೆ. ನೋಡೋಣ.
And
ಅದು
allocate date
ಅದು ಪೈಲ
ಬಂದು
ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. Wait, yes.
Please, I'll leave it to this.
Wednesday ಅಲ್ಲಿಗೆ. Yes.
Please.
Appear for the respond petitioner. The last occasion, this honorable court did the permission a previous marriage details. Yesterday, I filed a memo along with documents,
Previous marriage.
marriage details.
My lord, previous marriage, my lord, there is a mutual divorce. As a matter of fact, here, my lord, the offense, my lord, under section 498A,
Where?
6.
Earlier proceedings ಅಲ್ಲಿ.
ಅವರೇ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Yesterday, I produced other side copies served. Adding importance.
List the matter on
Kind
18th
permission, my lord.
in the fresh matters.
With
list.
allow kind permission, my lord, there is an order on 13/8/2024. To the effect, my lord, the warrant of any kind hanging on the head of the petition shall remain stayed.
So what?
ಅಲ್ಲ ಅದಲ್ಲ ಅಲ್ಲಿ ಒಂದು DV Act ನಲ್ಲಿ there is an order for maintenance. I have filed execution petition. He is taking advantage of this order.
It is
and
made
asking
clear,
the court
it
not
is
to-
made clear pendency of this proceedings and the interim order subsisting will not come in the way of any proceeding pending between the parties other than the one that is projected before this court. Yes.
Interim order may be continued.
Interim order subject to the aforesaid modification shall continue.
ಅಲ್ಲಿ ವಾರೆಂಟ್ ಅಷ್ಟೇ ಇರೋದು ಇಲ್ಲಿ.
ಅಷ್ಟೇನೆ, ಅದನ್ನ ಈಗಲೂ ಅಷ್ಟೇನೆ.
No, appear with the petitioner. Not talked. The matter is almost settled, my lord.
Settled.
Settled, October 10th ಗೆ ಏನೋ ಸ್ವಲ್ಪ amount ಕೊಟ್ಟು ಏನೋ ಮಾಡ್ತಾರಂತೆ.
ಆಯ್ತು. List the matter October 18th ಗೆ ಹಾಕ್ಲಾ?
ಹಾ.
List the matter on October 21st. Yes, next. Not before me.
Your lordship.
He's
Request
not
for a
there.
time pass over.
He's not
before
there.
me. Yes. next.
Then his junior is there.
Interim order continue. Next.
44.
Appear for petitioner. Appointment of special PP is called in.
I represent the de facto complainant in this case, my respondent number 4, man. May
Ah.
permitted to file the wakalat.
Change ಮಾಡಿದೀರಾ?
Lordship, I am intended to change the SPP.
Change.
Till that time, my lord,
Okay.
the.
44. We are 46.
Yeah.
46. I know,
That may be
but then
stable.
44.
Prosecution?
ಇಲ್ಲಿ earlier interim order
There
ಇದೆ.
are two matters, my lord.
Earlier interim order is
One connected matter.
You
Where is
change and then
46?
move the court, sir.
Oh.
Why do you,
That is what your lordship last.
this we will have to lay down something. Henceforth,
46.
an affidavit should be filed that he is not engaged, you have not engaged the counsel in any case.
Some guidelines need.
We'll do that.
Yes.
ಅಷ್ಟೇನಾ?
Till that new SPP, my lord, trial court ನಲ್ಲಿ ನನಗೆ ಟ್ರಯಲ್ ಆಗಬಾರ್ದು. Since it is an heinous offense, morning session ಅಲ್ಲಿ
Right, sir.
ಕಾಣುತ್ತೆ.
We'll pro-
ಅದಕ್ಕೋಸ್ಕರ
from 6.
may permit to engage new SPP.
We'll protect status quo till then.
No, my lord,
Yes, ma'am.
in this matter, there is an order to continue go on with the regular PP, my lord. My lord,
Yeah,
from
regular
6 years,
PP
my lord,
The issue is special PP has some connection with the complainant.
that is not in my matter, my lord. The other matter is.
Whatever matter.
44.1.
Arising out of what, sir? Both?
No, different, my lord.
Different?
Yeah.
PP.
ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಈಗ?
SPP is the same, my lords, in the both matters.
In both matters,
SPP is the same.
Balakrishnan.
Preference.
He is the advocate for both of you,
Both the
both the
matters.
complainants.
ಹೌದು.
Both the complainants.
In my case, he has appeared before also, after the appointment also he appeared for the
ಓ,
complaint.
ಇದು ಸೇಮ್ petitioner da, which I passed,
ಹೌದು.
same narration.
Same case, my lord. Earlier, your lordship directed, my lord, even the payment also, my lord, remuneration part also. Again, the same mistake they have.
Since they wrote an application, we will
Wait,
consider this.
list tomorrow, we'll dictate tomorrow.
The compilation of judgments may.
ಕೊಡಿ. List
Role
tomorrow.
of public
Tomorrow
prosecutor and
at
fairness,
4
my lord,
at
and
4
duty
PM.
of the public prosecutor. Role of public prosecutor, duty,
List
my lord.
tomorrow at 4 PM for dictating. Yes, next.
Interim order may continue.
Interim order subsisting will continue till the next
May
date.
permit to file the work.
Register ಮಾಡಿ. Oh, ಅಲ್ಲಿ ನಾಳೆನಾಗೆ ಇದೆ ಕೊಡಿ. Learned counsel so and so enters appearance for the second.
Advocate General is there. Number 4.
Respondent complainant registry to print the name of so and so as appearing for the complainant. Next.
Even in my matter, madam, he was appeared for the deceased also. He got a bail for deceased also.
ಯಾವ್ದ್ರಲ್ಲಿ?
Connected
ಆಯ್ತು,
with-
ಸೇಮ್ ನಾಳೆಗೆ ಎರಡು ಡಿಕ್ಟೇಟ್ ಮಾಡಿ.
45.
The sound is okay.
ಏನ್ madam?
Volume.
Investigation. Lordships are
Giri,
directed
Giri.
to produce
Yes,
letters.
government.
With the case, my lord, that I made
I have produced a different petition.
only grievance that, of course, my lord, there is a lapse in investigation. There is some lapse in investigation, but the grievance, my lord, that they're coming after 2018, and then they're coming now, post filing charge sheet against.
No, if there is lapse, there should not result in failure of justice.
That's correct, my lord, but when the accused was died, they made a similar allegation, and then the case was transferred to CID, there also investigation was done, B report was filed.
No,
Now-
list on Tuesday. ನಾನು ಅಲ್ಲಿ
Lordship,
ಗೊತ್ತು.
Your Lordships have directed me to produce letters that were given by the de facto complainant to different authorities. I have filed, Your Lordships.
ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ?
ಎಲ್ಲ ಹಾಕಿದೆ.
ಆಯ್ತು.
In
Note,
addition to.
Tuesday,
And
yes.
there is one judgment I wanted to.
ಕೊಡಿ ಅದು ಕೊಡಿ. Yes. Give everything Tuesday.
46.
Later call.
Tuesday for dictating. ವಿಜಯ್. Tuesday for dictating ಅಂತ ಹಾಕಿ. ಇದು ಮೇಡಮ್. Yes. Who is the learned attorney general here?
I am, may I present myself virtually, Your
Investigation,
Lordship?
Valmiki matter.
Oh, yes, sir. Valmiki. Yes, sir.
I'm sorry, I am presenting myself only virtually and not physically.
No problem, sir. Yes.
I heard that the reply is not yet been filed. I thought
Filed
let me.
today, man.
You filed today.
Today.
Copies are not served on me.
So I thought let me save some time and cost.
Because we had too much of Delhi in quite couple of days, man.
Okay, we'll also take it up on 23rd if possible.
All right, whichever date of all of your choice. I am
23rd,
here.
the Attorney General is asking for 23rd.
23rd, sir.
23rd, yes, I'm in Bangalore on 22nd.
All
I
right,
thought.
we'll take it on 23rd at 2:30.
Yes.
Yes. List, the respondents have filed their statement of objections.
Only
The state has filed its statement of objections. Heard ಎಲ್ಲಾರ್ದು ಹಾಕ್ಬಿಡಿ.
I'll take a copy and file my.
By then you file.
Yeah.
that, yes. The so and so, the learned, the Advocate General submit that the state has filed its statement of objections today. The learned senior counsel, Shri Professor Ravi Verma Kumar submits that he would file his objections as well by the next date of hearing. List the matter on 23rd at 2:30 PM.
Grateful, Your Lord.
Yes.
Great.
The Attorney General ಅಂತ ಹಾಕಿ. Yes. Next, yes, sir.
For petition in this case.
Case. I've sought for insertion, my lordship. I'll file a detailed synopsis with the objection, my lordship. Insecticides, officer has given some instructions, my lordship. Some records has to be placed, my lordships. They followed the proper.
ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ, my lordship.
ಆಯ್ತು ನೋಡೋಣ.
ಇಲ್ಲ.
ಹೋಗ್ಲಿ, objection ಹಾಕ್ಲಿ ಬಿಡಿ.
ಹಾಕ್ಲಿ.
There's an interim order operating.
Please, my lord. One in the last matter.
Wherever it is not there, we will grant.
Please.
The learned HCGP submits that instructions, the learned HCGP on instructions would submit that the detailed statement of objections would be filed in these cases. According to the learned HCGP, the procedure that is stipulated under the act is completely followed in the case at hand. Therefore, the HCGP would submit objections would be filed if 10 days time is granted. Lest the matter on 26th interim order subsisting in any of these cases shall continue till the next date of hearing. Interim order not subsisting in any of these cases, in the cases where interim order is not subsisting, there shall be an interim order of stay till the next date of hearing. Yes.
For the petition, the petitioner is husband, 498 and 306 of IPs. The only allegation, if you are not able to prepare the food and serve to me and children, go die. Page number 36 is the gist of the allegation.
We'll see. Yes. Ashtena.
This is only the allegations, ma'am. Please, may permit me to read
Yes.
page 36. ದಿನಾಂಕ 12/5/2020 ರಾತ್ರಿ ಸುಮಾರು 8:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಘನನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಮಾದನಾಯಕನಹಳ್ಳಿ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನ ಕಿತ್ತನಹಳ್ಳಿ ದಾಖಲ ದೇವಿ ನಂಜಯ್ಯನಪಾಳ್ಯದಲ್ಲಿರುವ ಆರೋಪಿ ವಾಸ ಮನೆಯಲ್ಲಿ ಕಲ ನಂಬರ್ 12ರಲ್ಲಿ ಕಂಡ ಆರೋಪ
ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ?
ಇಲ್ಲ.
First time.
ಪ್ಲೀಸ್.
Learned HCGP is directed to accept notice for the respondent. First respondent, emergent notice to the second respondent returnable by the 27th.
Please. Covered by judgment, my lordship judgment is.
306. Yes, husband. Who else can instigate?
My lordship judgment, page number 183 for a
I
moment,
know,
my lord.
I have rendered
My lordship,
not one but 10.
please, mere uttering the words, go and die, my lord, I will not.
All right, if the husband says it's a different, we'll see. Yes. 26th, 7th, 27. Yes.
49.
Just remains my lordship, similar
Here you
matter
go.
to that bank.
Defreezement, huh?
Defreezement, similar. Here the wife is there before the court. Wife and son's accounts were frozen, my lords.
ಈಗ ಯಾರದು defreeze ಮಾಡಿದ್ದಾರೆ?
Son has been defreezed, my lords. Wife,
ಇವ್ರದ್ದು ಮಾಡಿಲ್ವಾ?
the wife, my lords, is yet to be.
Heard the learned counsel Sunil Rao appearing for the petitioner. Additional SPP is directed to accept notice. We'll take it on Tuesday and close it.
Please, my lords.
List on Tuesday in the fresh matters. Let's seek instructions, sir. We'll close this. Yes, sir. Defreezement ಗೆ.
No, my lords, that has been done. In the previous petition, my lords, your lordship's order has been complied. This is, my lords, his mother's.
List on
Previously,
Wednesday in the fresh matters.
Please.
Yes. Copy ಕೊಡಿ ಇವತ್ತು.
my lords, it's been served, but
Served.
more will be.
Yes, next.
MMDR case Manoj on 10th.
ಯಾವತ್ತು ಹಾಕಿದೀವೆಲ್ಲ?
10th of.
List on 10th. Along with all other matters. Yes, next. ಇದೆಯಾ? ಇದ್ರೆ continue. Interim order comma, if any,
Disclose an offence under the sole
if any subsisting shall continue till the next date. Please.
Lordship, wife has filed lordship petition under section 12 of DB Act and also filed application. It has been allowed by the trial court. Husband preferred appeal and that has been reversed. My lordship, I sought my lordship not to oust from the lordship business premises.
ಈಗ ಅದು you are getting ousted?
Yes, my lordship.
Yes. The emergent notice to the respondent. Which order have you challenged?
Next year, my lordship.
What is the order?
It is a order in appeal.
Order in appeal.
How?
What stay have you sought? And there shall be an interim order of stay as prayed for till the next date of hearing. List the matter on 18th in the fresh matters list. Next.
Orders 52.
2.1. 52.1 I have pen for petitioner.
ಏನ್ ಜಗನ್?
That's 498A against in-law has been stayed.
Stay ಇದೆಯಾ?
Stay.
A week's time is granted to do the needful.
Lord, I am for the petitioner in 52, my lord.
ನೀವ್ ಯಾರಿಗೆ ಸರ್?
I am for the petitioner in 52.
ಅದು ಯಾರು petitioner?
My lord, Nasimuni, sir.
Huh?
My lord, I am sorry.
Who is the petitioner there, sir?
R2, my lord.
Why have you filed?
My lord, this is a case of complaint and counter complaint.
Counterclaim has been brought by them. Therefore, subsequent to my petition, they have filed a petition to call the notice.
What is the offense here?
Lots 323 to 506.
ನೀವ್ ಹಾಕಿರೋ ಕಂಪ್ಲೇಂಟ್ ಆಯ್ತು? Why?
Lord, they invited us to their home.
Yes, list the matter. 2 weeks' time is granted to do the needful. In the light of the interim order subsisting in the companion petition, there shall be an interim order of stay in the case at hand as well.
My lord, in both, there is.
ಇದೆಯಾ?
Idea, sir.
Sir, 2 weeks' time is granted to do the needful. List the matter. After 2 weeks, interim order subsisting shall continue till the next date of hearing. Yes.
53.
Yes, madam, applications,
My lord, it has been filed from my previous council. of,
retirement
divorce.
ಹಾಕಿದಾರ? ನೀವೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? All right. The only indulgence can be shown is I will take away the malicious prosecution permission that is granted. Everything else I have given reasons.
My lord, there are
So,
evidences
no,
I have attached
No,
in my
madam, that's
recall.
not, I can't go sit in appeal against my order, saying that there is an error. That I will grant. That is the only indulgence I can grant.
There is a suppression of fact.
No, madam, that you have to challenge it in the apex court, not,
My lord,
you challenge it in the apex court. That malicious prosecution thing I will delete.
then kindly allow me to seek a certificate of appeal, my lord.
No, no,
because
that impossible, that will not. You have a right of appeal, you can write. Not in every circumstance, this court will say certificate of appeal to the Supreme Court. You have special leave petition, you always have a right.
My lord, in the recall, I have filed all the evidences
You,
supporting.
it's all right, you file everything before the apex court.
My
Whatever you want, that particular portion, I'll delete, that's all.
My lord,
the-
kindly consider this one.
No, madam,
Let
that
me
I will,
argue
I will pass orders, not that I will not pass orders.
And remarks, expunging of remarks, my lord.
Huh?
Expunging of remarks.
There is no remarks made at all.
My lord, there is a.
There is no remarks made. I only extracted whatever you have placed before the court. That's all. No individual remarks made at all.
My lord,
You
there
can,
is a
you can
remark-
challenge that before the apex court.
Remark in
The
order,
only
my
thing
lord.
is I have granted the husband to initiate malicious prosecution. That I will delete. That's all.
My lord, it is affecting my MC case.
That's why I'm telling. And I will observe that the observations made here
has
will not
attached-
come in the way of any other proceeding.
That remarks is affecting my MC case, my lord.
That's what I told you.
Attitude of the.
Any
complainant.
observation that is made in the case will not come in the way or influence any other proceeding. I am not going to expunge anything.
My lord,
Yes.
it is already affected. They have
No, madam,
attached that.
I will not, yes. My malicious prosecution is initiated already?
No, my lord,
Yes,
that's
all
not
right,
that one.
yes.
Expunging of remarks.
No, no,
That
that I will
remarks
not.
they are.
There
going
is
to
no
consider.
remark made, yes. Which is that IA 2 of 24 in.
Then
What are the
kindly-
IAs?
Kindly allow me to argue the matter, my lord.
What are the IAs, madam?
Is 2, 3, 4. One is for expunging of remarks.
Hmm.
Second is delay. Third one, fourth one is for recall.
For
Recall.
recall.
And fifth is for certificate
One.
of appeal.
Fifth is for?
Certificate of appeal.
All right. The application in IA 2 of 2024.
Just asking, I'm just requesting to expunge.
No,
the
madam, I
remarks.
can't rehear the end. It is not an appeal.
Expunging of remarks.
No,
Kindly
madam, that
consider.
also nothing. I have given reasons for whatever I have said.
Affecting my MC case, my lord.
I will say that will not affect, yes.
My lord, they have attached as evidence.
That I will say, yes. The respondent in person, this court on so and so date had disposed the matter. The respondent in person has preferred several applications. Application in IA 2 of 2024 is preferred, that expunging other, for expunging of the remarks so made in the order. There are no individual remarks made except what the respondent had communicated to the husband. Therefore, expunging of those remarks would not arise. The apprehension of the respondent in person is that this is used by the husband before the concerned court. I deem it appropriate to observe that any of the observations made in the case at hand is only for the purpose of consideration of the case of the petitioner under section 482 of the CRPC. Those observations will not influence, bind any other proceeding pending between the parties before any fora ordered accordingly. IA 3 of 24 in.
3 is for delay.
Huh?
Delay.
Delay. For the, which delay? Delay in filing 2, is it?
Yes.
So and
yes,
so.
my lord.
For the reason stated so and so application, in the light of the clarification made here and above, the application IA 3 of 2024 need not be considered. The same is disposed as unnecessary. IA 4 of 24 in.
3 is having like it is.
Delay, madam, that is delay.
Because of
that-
my health, my lord.
Delay,
Right.
don't worry about delay. I've already told. Yes, IA 4 of 24 in.
Recall. Recall.
The IA 4 of 2024 is filed seeking recall of the judgment. The judgment is not rendered not rendered without hearing the parties or otherwise. Therefore, recall of the said judgment would not arise. The only relief that can be granted in the said application is this court had observed or granted liberty to the husband to initiate malicious prosecution against the wife for the reason indicated in the order. Since the reason indicated in the order. the
Lord, I
said
have,
observation of the permission being granted for initiation of malicious prosecution stands deleted from the order dated so and so. If any malicious prosecution proceedings are initiated by the husband on the strength of the said order shall stand obliterated. The IA 5 of 2024 is filed for grant of a certificate to file an appeal to the apex court. The certificate of filing an appeal is not necessary, is unnecessary, or would not be granted in the light of the respondent, in the light of the respondent having all right to prefer an SLP before the apex court if the respondent so desires, ordered accordingly. Yes. Next.
This matter, my lord, and petitioner, my lord. Notice is not served, my lord, for respondent. After service of notice, my lord, list this matter, my lord.
Yes.
This matter, my lord, notice is not served to the respondent, my lord. After servicing of notice, my lord, matter may be listed.
ಏನಿತ್ತು? Police post
498
immediately.
P0
Post immediately after service of notice upon the second respondent, interim order subsisting shall continue to the next date of hearing.
There is
Ide? Yes, next.
55.
Three basic violations that have taken place, my lord.
Lord,
Public servant.
It
Yes,
has
my
come
lord.
in orders.
It has
I'll
come in
file my
orders.
objection, Lord, 2 weeks time to file.
ಏನಕ್ಕಿದು?
Already
lords.
charge sheet is filed and they filed a discharge application before the trial.
Discharge pending ಇದೆಯಾ?
Pending is.
My lords,
Pending ಇದ್ರೆ ಅಲ್ಲೇ
my
continue.
lords, kindly notice this, my lords. 17A not complied. A decision taken by an SP, my lords, who is now retired. The decision
What
taken,
decision, sir?
my lords, there was a selection done so far as 6 posts are concerned.
Which post?
My lords, post for 2 women constables, one civil constable, my lords, and 2 other persons. So 6 posts were filled up by 2 selection committees which the SP headed. After he had appointment letters were issued, immediately thereafter, the appointments were set aside by the DG IGP. Explanation was called for. I give the explanation. They accept it and recall the order of setting aside the appointments. After 2 years, my lords, the candidates who were selected, they are asked to be discharged. They go to KATs, get appropriate orders for them to continue. Now, my lords, on this basis, my lords, an FIR comes to be registered for a decision taken by the SP. Now, if a decision is taken, my lords, 17A will clearly come, my lords, where they need an approval. No approval was taken, my lords, because approval in this case will be through the Ministry of Home Affairs, my lords. No approval taken. Charge sheet when it's filed, my lords, no sanction taken. Without a sanction, cognizance is taken. Now, while taking cognizance and issuing process, straight away NBW. On 3 scores, my lords, 17A, 19, and issuance of NBW without even a summons being issued, my lords. I think Satyendra Kumar Antil, Indra Mohan Goswami's case, my lords, so far as NBW, 17A and 19, I don't even have to explain, my lords, because the section itself says if it is going to be a decision taken by you. And now the decision is justified, my lords, because KAT has given those candidates a relief. So I don't know how without 17A and 19 they.
But why has it come in orders then?
My lords,
And
on the previous
The
occasion.
filing of charge sheet in the year 2021. And all these grounds are raised in the discharge application. That is
What
pending.
has happened to the discharge application?
Still pending, Lord, it is, Lord, they kindly see the order sheet.
Yes, sir.
They are taking time and we filed objection on 4/9/2023. And they have to.
Pendency of discharge when 3 legal aspects, my lords, which should come for consideration under
All
482
right, you
itself.
know, you should know what you should do.
Can withdraw that at any point of time, my lords, but these 3 points, my lords, can a
If
proceeding
you
continue?
if you do
If the-
that, then I will ask.
Yes,
them
if
here.
the base itself goes, my lords, I think,
It's all right.
I will, yes, my lords.
You can't have
Could I,
petitions in 2 different fora.
could I make a request, a short date, my lords, in the meanwhile, we will
Lord, 2
withdraw
weeks.
that.
I'll file my objection.
And my
There.
learned
Illa.
friend,
Here.
Here.
If they are withdrawing, Lord, I have no objection. and filing the
This
fresh
petition, they
petition.
are not
It's a
withdrawing,
light.
sir.
Not
Don't be so happy.
after withdrawing that,
Discharge
my lord, they,
application, they are withdrawing. Is what he
Discharge.
said.
Humble submission, my lordship.
ನೀವ್ ಯಾರಿಗೆ sir?
Criminal petition number 11657 of 23.
ಹಾ.
Petition ಲತೀಫ್ ಅವರಿಗೆ ಅಸೈನ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
ಯಾರ್ಗ್ ಅಸೈನ್ ಆಗಿದೆ?
ಲತೀಫ್ ಸಾಹೇಬ್
ಲತೀಫ್ ಅವ್ರ ಅಸೈನ್ ಆಗಿದೆಯಾ?
ಅಸೈನ್ ಆಗಿದೆ.
ನೀವ್ ಯಾರು?
ಬಿ ಪಾಟೀಲ್.
ಬಿ ಪಾಟೀಲ್ ಕೊಲೀಗ?
ಎಸ್.
All right, yes. ಎಷ್ಟೊಂದು colleagues ಇದ್ದಾರೆ. The learned, the registry to delete the name of B Patil in both these cases and print the name of B Latif as appearing for the respondent Lokayukta.
direct them to serve a copy of the petition.
ಯಾಕೆ ಇಲ್ವಾ ಕಾಪಿ?
I have a connected matter, I have a petition. copy.
Connect, ಕೊಡಿ ಕಾಪಿ. Petitioner to serve set of papers upon the counsel Shri B Latif in criminal petition 11657 of 2023.
Could we request the matter to be on Monday? We will tomorrow itself recall our discharge application
beda.
because three
Well-
important points, my lord, that's.
All right, we'll take it on.
Because now, my lord, 17A, my lords, I don't even have to state anything. So much has been argued on 17. And my lords has seen it threadbare,
Yes,
not a recommendation, but here a decision, my lords.
yes, we'll list it on 13th.
13.
List on 13th in the fresh matters list. Objections, if any, by then.
Obliged.
Your lordship, the matter has been posted for furnishing of PF. We had already paid the process, your lordship.
Counsel for the petitioner submits needful has been done, office to verify, huh? Office to verify, less the matter. ಯಾರ್ vacating stay ಹಾಕಿರೋದು?
It's
State ah?
state, your lordship.
Yes, sir. List the matter on 13th. Yes, next.
Interim order may kindly be.
Interim order subsisting shall continue till the next date of hearing.
I represent the petitioner.
Office objections, accepting the submission of the, ಏನಿದೆ?
ಏನಿಲ್ಲ,
ಏನಿಲ್ವಾ?
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. We have already petitioned.
Accepting the submission of the counsel for the petitioner, office objections overruled, list on Monday in the fresh matters list.
Accused has already, the interim order has been passed with regard to accused. number one.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದ್ರಲ್ಲೇ. Writ petition,
For what?
I have produced. I have produced at a page.
Connected matters ah?
Same co-accused. At page number 33, I have produced the coordinate bench.
Coordinate bench.
Coordinate. Page 33.
Yes, co-accused ಕೊಟ್ಟಿದ್ದಾನೆ page 33. Next. ಮಂಡ್ಯ ಬೇಡ, next. ರಾಜೇಂದ್ರ ರೆಡ್ಡಿ. The, ಏನು, furnishing of PFY ಕಟ್ಟಿಲ್ವಾ? Will vacate the interim order. The learned counsel for the petitioner submits needful would be done in the course of the day. In the event it is not done, the interim order would stand automatically vacated in the course of the day, beda. If the needful is not done by the evening of tomorrow, the interim order would stand automatically vacated. Subject to the aforesaid condition, the interim order stands extended to the next date of hearing.
Previous case, interim order.
Interim order, ಇರೋದ್ continue ಮಾಡಿ.
Previous.
ಕೊಟ್ಟಾಯ್ತು sir.
ಅಲ್ಲ, previous case. 57.
57 ಅಲ್ಲೇ.
57.
ಹ್ಮ್.
Interim order, IAH.
ಕೊಟ್ಟಾಗಿದೆ.
Obliged. Obliged.
In my case, my lord, there is no interim order in respect of A1.
Husband.
Husband.
No interim.
No allegations against husband.
No problems.
Date may be, short date may be.
ಬರ್ಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ ಬರಲ್ಲ, ಡೇಟ್ ಕೂಡ ಏನು ಬರಲ್ಲ.
Date ಬೇಡ.
20ನೇ ತಾರೀಕು.
October. Yes.
23.
October. Yes. Maintainability.
Lord, we had filed a petition before the committal, my lord. That is pending. We have filed a memo for withdrawal as well in that petition, my lord.
Where is that? Which is that petition?
Petition number 5530 of 23.
Just ಮಾಡಿಸಿ ಮೇಡಮ್. ನಾಳೆ ಮಾಡಿಸಿ ತೊಂದ್ರೆ. Yes.
Interim order, my lord.
There's no interim order.
There's no
No interim order. Yes. List on Monday in the fresh matters list. Yes, next.
60.
Office objections, claim maintainability stands over.
Petitioner in the case, 60.
Post immediately after service. of
Petitioner
notice
in the
upon-
case, awaiting police report ಅಂತ
Correct,
ಐತೆ
sir. Post immediately after service of notice upon the second respondent, interim order subsisting shall continue till the next date of hearing. Same.
ಸ್ವಾಮಿ
order.
ಇದರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡರ್ ಕಂಟಿನ್ಯೂ ಆಗಲಿ.
ಆಯ್ತು sir. Yes.
62.
61 same order, 62.
ಡೇಟ್ ಸ್ವಾಮಿ 60.
Yes.
My lord, that. 2, my lord, I am for respondent number 2.
Respondent number 3, my lord, in 62.
I
Office
appear for the,
objection ಏನು? Who
I
appears
appear for the petitioner, please, my lords. I appear for the petitioners.
Why
The
office objection is not complied?
Yes, second objection is complied, please, my lords. First address ಅವರು ಆಫೀಸ್ ನಲ್ಲಿ ತಪ್ಪು ಕೊಟ್ಟಿದ್ರು ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಏಜೆನ್ಸಿ ಅದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ದಿದ್ದೀನಿ ಮಾಸ್ವಾಮಿ. ನಾನು ಯಾವ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದೀನೋ ಆ ಅಡ್ರೆಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ದಿದ್ದೀನಿ. So I pray my lords to
Accepting
overrule
the
the
submission, office objection stands overruled.
please, my lord. The case is, please, my lords.
Interim order illavalla.
ಇಲ್ಲ ಮಾಸ್ವಾಮಿ. The respondents were directed to file objections, please, my lords.
File your objection.
Connected matter, my lord.
2 weeks time is granted to file statement of objections.
I make one submission. Connected matter, my lord, 8316/2024. I believe, my lord, arising out of the same crime. Your lordship has granted stay on last Monday.
Take this, tag this petition along with so and so,
So is
this
that
on
the-
24th.
FSL report, my lord, has come. FSL report says that, handwriting expert says that the documents have been tampered with. That is not
Right.
been placed.
We'll-
Short date, my lord.
We'll take it on 16th then, 16th and Rajana. 17th, yes. 17th.
Grateful, please.
17th in the fresh matters list along with the said petition. Next,
63.
post immediately, interim order continue ಮಾಡಿ.
My lord, 17th is holiday, please.
17th is not a holiday, sir. Yes.
Calendar green. Please.
Green idre, not a holiday, sir. Restricted holiday. Don't restrict yourself, please come to the court.
Please. Sorry, my lords.
Yes.
I represent the petition in this
For
case.
post immediately after service of notice, illa furnishing of PF ಕಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಅದಲ್ಲ 64 my lord.
64 ಅಲ್ಲೇ.
63 sorry my lord.
63 post immediately after service of notice upon the second respondent. Interim order ಇದೆಯಾ?
Entry ಮಾಡಿದೆ.
Interim order subsisting shall continue till the next date of hearing. Yes, madam.
64.
ಯಾಕೆ ಕಟ್ಟಿಲ್ಲ PF? ಕಟ್ಟಿದ್ರಾ? FPF ಅಲ್ಲ ಕೇಳಿರೋದು PF. ಅದೇ ಸೇಮ್ before the evening of tomorrow. Same interim order ಇದೆಯಲ್ಲ? Subject to the condition. Next.
65.
Petitioner my lord.
Post immediately after service of notice upon the respondent. Interim order.
Entry ಮಾಡು.
Continue. Yes.
Right.
Post immediately after service of notice upon the respondent.
Interim order.
Unda.
Yes.
Yes.
67.
Continue.
Quash the proceedings against the petitioner number
Post
1.
immediately after service of notice upon the second respondent.
Interim order.
Interim order. Yes, next.
68.
ಯಾವ್ದ್ರಲ್ಲಿ?
68.
68.
Because last time around I made a submission saying the records were misplaced.
Ah.
Then department inquiry was ordered. Now the department inquiry, my lord, deputy commissioner has directed, to place the report, my lord, which
Directed what?
initiated the proceedings against the two, officers who were responsible for,
ಆಯ್ತು ಕೊಡಿ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ.
they need not know, my lord. It's a departmental proceeding. Because two police officials, my lord, were responsible for not bringing the file. And the file was kept in the cupboard and the investigation was not done.
Oh, I had
Yes, my lord.
passed a detailed order in
Yes,
the
yes,
earlier
sir.
case. Yes, sir.
2019 my lords
Correct. 4 ವರ್ಷ FIR register ಮಾಡಿರಲಿಲ್ಲ ಅದು.
FIR register ಮಾಡ್ತಾರೆ.
ಮಾಡ್ತಾರೆ 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಮಾಡ್ತಾರೆ.
No, my lords. FIR
Affidavit was filed before this court that I forgot because it was in the cupboard, office was shifted. Is that the case?
FIR, no. FIR was
FIR was
registered in the year of
registered.
2019, but charge
Investigation
sheet,
was not taken forward.
charge sheet, my lords, never not filed for 5 years. So that is, my lordship has passed an order saying that why charge sheet was not filed for 5 years.
ಒಂದ್ಸರಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಇನ್ಕ್ವೈರಿ ಆದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. Henceforth you will investigate immediately. This is how victim will not get justice.
Your lordship has granted stay only to place this, report, my lord.
Let the
basic-
inquiry go on.
Inquiry go on, investigation also has to continue, my lord, sir.
Investigation will continue, sir.
No, my lords.
You
since
come
five-
on merits. We'll hear you on
Yes,
merits
yes.
tomorrow,
Monday, my lords. Monday or Tuesday.
Tuesday in fresh matters.
Please.
Next.
Please.
69.
Post immediately after service of notice.
Interim order ಇಲ್ಲ ಸುಮ್ನೆ.
Respondent number.
Yes.
Yesterday I filed
Learned counsel so and so submits that his entered appearance for the respondent. List the matter on Monday in the fresh matters list. Next.
Please, my lord.
70.
Office objection, my submission is only, I have produced an internet copy in last.
Overruled Monday.
9th charge.
Overruled Monday. Yes.
71.
ಪರವಾಗಿಲ್ಲ. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾರೆ?
Warrant ಆಗಿದೆ, sir.
Respondent?
Respondent number 2, my lord.
Learned counsel so and so
72.
Yesterday I filed wakalat.
submits that his entered appearance for the respondent number 2 registered to print the name of so and so is appearing for the second respondent. Interim order ಇದೆಯಾ?
ಇದೆ.
Objections, if any, in the next 2 weeks, interim order subsisting shall continue till the next date of hearing. Yes, next.
Obliged. 72.
Offense under 406 and 420.
Correct. Office objections ಏನು?
Comply with the office objection.
Comply ಮಾಡಿ. List the matter on Monday in the fresh matters list. In the event office objections would stand complied without a memo being moved before this court. What urgency? No problem, sir. Not yet frozen, alva. We'll see, we'll see. Yes, Monday.
73.
They madre will issue a consequent direction to defreeze. Yes.
Monday.
Monday, yes.
Monday.
Bail petition on special order, my lord.
Bail?
307.
Why bail before me?
I'm disabled before Honorable Justice HVS.
307.
Special order. He is there in custody for the last 4 months, more than 4 months.
Will you take notice then?
I'll accept notice.
Accept notice list on Monday in the fresh matters list. Tuesday, na? Or one time could have 4 months in the custody, there are 4 months and 4 days. Yes, list on Monday in the fresh matters list.
Then 15 days I filed. ಒಳಗೆ ಇಟ್ಕೊಂಡಿದ್ರು file.
Nani, what can be done? Bail ಅಂತ ನನ್ ಮುಂದೆ ಮೂವ್ ಮಾಡಿದ್ರೆ next day ತಗೊಂತಾ ಇದ್ನಾ?
ನಾವು ಮೂವ್ ಮಾಡಂಗಿಲ್ಲ ಅಲ್ಲಿ. We have to file it before RJ, then he has to get special order.
Don't worry, bail ಅಂತ ಮೂವ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟೊಂದು ತಗೊಂಡಿದ್ದೀನಿ. I'll take it the next day itself. Yes. Because the question of liberty, we'll see, yes.
24.
Maintainability. 2 weeks time granted to comply with the office objections. Next.
75.
Post immediately after service of notice upon the 75. Sirajuddin.
3 o'clock, Rahul sir will come.
ಏನಿದು?
Shakuntala guidelines in the.
Shakuntala? Who is Shakuntala?
Guidelines on premature release, your lordship.
Oh,
Maharashtra.
guidelines. All right. ನೀವು Shakuntala ಅಂದ್ರೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ?
Sorry.
Huh? Yes.
3 o'clock,
Password,
sir.
password.
Sir.
Yes. Post immediately after service of notice upon.
Notice is not necessary, my lord, because the
Notice ಮಾಡಿಲ್ವಾ?
notice is not necessary because they're accused
Not
of not
necessary,
trying to
why?
because you 200 ಕೆಳಗಡೆ PCR ಫೈಲ್ ಆದ್ಮೇಲೆ 201 ಕೆಳಗೆ ರಿಟರ್ನ್ ಆಗ್ಬಿಟ್ಟಿರೋದು ಅಷ್ಟೇ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇರೋದು.
ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡಿದ್ದೀರಾ ಮತ್ತೆ? ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ?
ಫಾರ್ಮಲ್ ಪಾರ್ಟೀಸ್ ಅಂತ ಆಗಿದೆ.
ಕೊಡ್ಬೇಕು ನೋಟಿಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಮಂಡೇ ಮೇ ಬಿ
Yes, list on Monday in the fresh matters list. We'll dispose it. Post immediately after service of notice upon the third respondent.
Seeking a stay, my lord. He is accused number 10, my lord. But in even, my lord,
Yes, immediately. Next.
197 CRPC.
Immediately without a memo being moved before this court. Next. Post immediately after service of notice upon the second respondent. Entry ಮಾಡಿದ್ರೆ entry ಮಾಡಿ. Same order.
28 and 79 may be tagged, my lord.
Tag 78, 79 together. Yes, next. 80.
Wait, please, minutes. This is a challenge.
What is the office objection?
Well, the office objection is that annexure has not been mentioned in the prayer. Otherwise, my lord.
Mention, what's the problem?
And my
That's
lord,
not the only office objection. There are about 6.
my lords, the other is.
There are about 6, you will need to fix them. Yes.
Please, minutes.
In the event office objections will be complied with, list the matter on Monday in the fresh matters list.
Please, minutes.
Yes, without a memo being moved before the court. Yes, Sakaman. Come back.
My lord, may I mention on matter, my lord, serial number 5, my lord. My lord, may I mention, my lord, your lordships, my lord, I am told has dismissed.
Court officer, sir. 64 serial number. ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ ಆಫ್ಟರ್ 2 ವೀಕ್ಸ್ ಅಂತ ಯಾವುದು 59 ಏನು
Court officer? Fresh matters list. Court officer? Court officer? Court officer ಕೇಳ್ತಿದ್ಯಾ?
ಹಲೋ
Serial number 11?
My lord, with your lordship's kind permission, I may kindly mention item 43, my lord. I was informed
I
that
extended the interim order also.
grateful.
My lord, may I mention serial number 5, my lord?
Serial number 100. Aito. Oh, which one? IAS versus IPS. All right.
My lord, may I mention serial number 5, my lord?
Mediation. All right, we'll take it on 20. ಈಗ ಫೇಲ್ ಆಯ್ತಾ? ಅಲ್ಲ, you have failed or mediation is failed?
Respected senior counsel is making false submission before your honor. We quit. There. My lords, yesterday, my lords, I was present in the mediation. Through online, it was conducted. Online ಅಲ್ಲಿ conduct ಮಾಡಿದ್ದು. ಅವರು ಕೇಳಿದ್ದು ಒಂದೇ ಪ್ರಶ್ನೆ, are you agreed with these points or not? We said no. So mediation failed.
You don't, ಅದಕ್ಕೆ ಅಗ್ರಿ ಆಗಿಲ್ವಾ?
Agree ಆಗಿಲ್ಲ.
ಏನ್ ಬೇಕು? Pound of flesh?
No.
What do you want? ಅಲ್ಲ, what do you want? Pound of flesh? Then
I'll argue the matter.
all right, argue the matter, no problem. List on senior ತಾವಿದ್ದೀರಾ ಸರ್ ಅದರಲ್ಲಿ?
Senior counsel Sandesh Chota is.
That's all right. List in the second week of October.
Specific date may be given, but no, my
Move
lords.
move the matters.
My lords.
Move the matters. Interim
May I
orders
mention
subsisting shall
serial number
continue till
5,
the
my
next date of hearing.
Next week, my lords, at least.
No
make it
time,
date,
sir, next week.
please. We are ready with the matter, my lords.
No problem. Yes, list on 15th October.
Next week, my lords.
No, sir.
Please.
ಈ ತಿಂಗಳು ಇಲ್ಲವೇ ಇಲ್ಲ.
First week, my lords. First week, my lords.
ಆಯ್ತಲ್ಲ, ಬೇರೆಯವ್ರದ್ದು ಕೇಳೋಣ ಸ್ವಲ್ಪ. Wait, senior counsel is there. Yes. ಒಂದ್ ನಿಮಿಷ ಸರ್. ಅವ್ರಿಗೆ ಹೇಳಿದ್ದು ನಿಮಗೂ ಅಪ್ಲೈ ಆಗಲ್ಲ. ಒಂದ್ ನಿಮಿಷ ಸರ್. What is that, sir? ಎಲ್ಲ 80 ರೀಚ್ ಆಯ್ತು. ಮಂಡೇಗೆ ಹಾಕಿದ್ದೀನಿ. ಯಾವತ್ತು? No, the whole problem is I wouldn't have seen the file at all. ಅದೊಂದೇ ಕಾರಣಕ್ಕೆ ಮಂಡೇ ಇಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ತಗೊಂತೀನಿ. Tomorrow there are already 200 matters, sir. Yes. All right. Then you do it, Mohammed could not. ಗೊತ್ತಾಯ್ತು, correct. ತಾಯಿ No, he will not. It's not. ಅಷ್ಟೇ. That's true. Then you do one thing, sir. You no, you serve on Madhukar Deshpande now. I'll take it at 4:30. Yes. ಈಗ ಹೇಳಿ ಸರ್. Yes. 74. ಇರ್ಲಿಲ್ವಲ್ಲ ನೀವು? ಕೇವೆಟ್ ಫೈಲ್ ಮಾಡಿ ಬರೋಷ್ಟೊಂದು ಲೇಟ್ ಆಗೋಯ್ತಾ? ಸರ್, ಯು ಕಾಂಟ್ ಪ್ರಿಡಿಕ್ಟ್ ದಿಸ್ ಕೋರ್ಟ್ ಲೈಕ್ ದಟ್, ಸರ್. ಎಸ್, ಏನ್ ಬೇಕೀಗ? ಮಂಡೇ ಹಾಕೋಣ. ವಾಟ್ ಈಸ್ ಮೇಂಟೈನಬಿಲಿಟಿ? ಇರಲಿ ತಾಳಿ. ಕಮ್ at 4:30. ಮತ್ತೆ ಕೇಬೆಟ್ ಫೈಲ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ. ಎಸ್,
My lord, may I mention serial number 5, my lord?
ಫೈಲ್ ತರಿಸಿ. ಹಾ ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 13th. Then we'll finish it. Yes. 498 ಏನಾ? ಆಯ್ತು, ಫಿನಿಶ್. ಅಲ್ಲಿ ಬರ್ಕೊಂಡಿರಿ, ರೀಚ್ ಆದಾಗ ಮಾಡ್ತೀನಿ. ಎಸ್ ತಯಾರಿ ಮೇಡಮ್, ಅದು ರಿವ್ಯೂ ಯಾಕೆ ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ? ನಾನು ರಿವ್ಯೂ ಅಲೋ ಮಾಡೋದ್ರಿಂದ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿಯಿಂದ ಆಚೆ ಬರ್ತಾರೆ. ಆಫ್ ಕನ್ಸಿಡರೇಷನ್ ಬೈ ದಿ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್. All right. Not tomorrow. Mangalore, Friday is a holiday. This Friday is a holiday. So last Friday was also a holiday. Then we'll use your Wednesday hacksiri, madam. Madam, Wednesday review petition number kudi.
Yesterday I moved a matter, my lord. My lord, Biscom matter, my lord, wherein FIR was challenged, my lord, and the matter was dismissed. Sanction, my lord. Now, my lord, it was directed to be listed today, my lord. Now the office is, my lord, trying to classify it as GM electricity. I have filed it under
GM
528.
my sanction is a pursuant to my order. Yes, get that file. List marks. Yes. We'll see why sanction is refused in that. Yes. Sanction go GM KEB go ಏನು ಸಂಬಂಧ? Yes, ask him to list the matter, madam.
My lord, may I mention serial number 5, my lord?
Yes, Nandish.
My lord, your lordships have dismissed the writ petition, my lord.
Exactly.
Please,
Disposed.
my lord.
Charges
Please.
frame agide ಅದಕ್ಕೆ.
Please, my presence may be recorded, my lord. I'm sorry, my lord, I
Right.
couldn't log in the morning, my lord.
Yes, Nandish ಬೆಳಗ್ಗೆ ಅವ್ರಿಗೆ ಹೇಳಿ ಪ್ರೆಸೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ. ನಂದೀಶ್
Yes.
ಪಾಟೀಲ್ ಅಪಿಯರ್ಡ್ ಅಂತ ಮಾಡಿ. ಎಸ್,
I'm deeply obliged.
2:30 ತಗೊಂಡ್ಬಿಡಿ. ಇಲ್ಲ, 1 ನಿಮಿಷ. ದೇರ್ ಆರ್ ಸಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಅದು ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳಿ. 1 minute.
My lord, I'm so sorry, my lords.
1 minute, sir.
I'm for responding number 2.
Offense
498.
ಕೊಡಿ ಮೇಡಮ್. ಯಾರು who is not well? All right, give it.
I'm filing power for.
Learned counsel so and so undertakes to enter appearance for the respondent, registry to print the name of so and so as appearing for the respondent. ಏನ್ ಸೆಟಲ್ಮೆಂಟ್? reunion or ಖುಲ್ಲಾನಾಮ? All right. ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು they were before the family court ಅಂತ ಹೇಳಿ. ಅದು ಇಲ್ಲಿದೆ. I'll tell you. Page 62 ಅಲ್ಲಿ they have settled the dispute before the family court. That's where I am, madam. 1 minute. Para 5 in the para 11. Yes. All right. 124 correct. All other settlements will take it later. This is BDA matters, huh? Where is the respondent? Akshay Gowda. Following Indira Devi.
Government still thought it is not the court sanction. The reason probably I will point out, my lord, on the narration of facts. Ultimately.
All these are officers or what?
But they more of private individuals.
Okay.
And for washment that took place, but basically for the officers, my lords, for
Hmm.
whom no sanction had been accorded,
Hmm.
and my lords had allowed those petitions.
True, but
All-
where
all
is
that
this?
happened in 2022, my lords.
Respondent, complainant ಬೇಕಲ್ಲ? ಅಕ್ಷಯ್ ಗೌಡ. Delinking. ಯಾಕೆ? Nitin, you're appearing in place of Nitin Ramesh? Registry to delete the name of Nitin Ramesh as appearing for the petitioner and print the name of so and so. In 124.1, ಆಮೇಲೆ? One and? Oh, you're already on record. Fine. Why delink? Oh, you should say why delink. You asked me for delinking. They're not connected? Yes, sir.
It's the same line number, same charge sheet. They
Then
have
why
that
should it be delinked? It's already linked. We'll not delink it. Heard the learned senior counsel Sundesh Chowta appearing for the petitioner. There is no representation on behalf of the second respondent complainant. List the matter on 13th at 2:30 PM. Yes. Interim orders ಇದೆಯಲ್ಲ? Interim orders subsisting shall continue till the next date of hearing. ಇನ್ಯಾವುದು 2:30 ಇಲ್ಲಲ್ಲ? ಬೇಡ. ನಾಟ್ ನೆಸರಿ. ಬದಲಿಂಗ್ ಬೇಡ. ಲೆಟ್ ಇಟ್ ಕಮ್. ದೇಶ ರೆಡಿ ತಾನೆ ಇಲ್ಲ. Respond number 2. ಈ ಕಡೆ ಬನ್ನಿ.
The respond number 2, my lord, on record counsel, my lord, is not keeping well. I pray for a week's accommodation.
Vacating stay ಇದೆ. ನೀವೇ ಹಾಕಿರೋದು.
Part 2 ನ
Learned counsel appearing for the second respondent who has filed an application seeking vacation of the interim order is said to be indisposed today and therefore seeks a week's time. List on 13th. After 20th, we'll vacate the interim order. Yes, 13th. ಯಾಕೆ 13th ಇಲ್ಲ? ಅದೇ 13th ಯಾಕೆ ಬೇಡ? Seen, ನೀವು ready ಆಗಿ. Yes, 13th. Interim order subsisting shall continue till the next date of hearing. 80? ಎಲ್ಲಿದೆ 3 o'clock? ಯಾರು ಬರ್ತೀನಿ? ಎಲ್ಲಿ ವೇರ್ ಇಸ್ ಬರ್ಲಿ? Let him come. Yes. Ask ಅದು ಜಗದೀಶ್ವರ. Ask Rahul to come. Parole extensions. Yes.
83?
Correspondent to the-
Strangely, my lords, at 83, my lords, there seems to be an interim order that had been granted without even complaint being part of the records. FIR ಹಾಕಿದ್ದಾರೆ, ಕಂಪ್ಲೇಂಟೇ ಹಾಕಿಲ್ಲ. ಅದ್ರ interim order ಇದೆ, my lords.
Flow ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿರ್ತೀವಿ ಒಂದು. ನಂದಲ್ಲ.
ನಿಮ್ದಲ್ಲ.
Yes.
So, my lords, without complaint, ಈಗ quashment ಹೇಗಾಗೋದು? So, in fact, my lords, stay.
ಕಂಪ್ಲೇಂಟ್ ಇಲ್ವಾ?
Complaint produce ಮಾಡಿಲ್ಲ, my lords.
ಅಲ್ಲ,
They would
ಇದೆಯಾ ಇಲ್ವಾ? ರೆಫರೆನ್ಸ್
Complaint
ಆಗಿದೆ.
My lords, this is not a reference case.
Then there is some crime here.
FIR ಇದೆ, my lords.
87 of 24.
FIR.
What is that?
ಅದ್ರ ಜೊತೆಗೆ complaint, the main complaint where the allegation is ಅದಿಲ್ಲ.
ಅಂದ್ರೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
Produce ಮಾಡಿಲ್ಲ. And without that, my lords, I don't know how probably office did.
ಇಲ್ಲ, annexure A1 page 12.
ಇಲ್ಲ, my lords.
So page 32.
ಇಲ್ಲ. Sorry.
Z-work. I think last week I passed some order in Z-works complaint. Yes, Chinmay.
Sir.
Which is that order that I passed in
30, my
Z-works
lords, is
complaint?
saying
That work,
page-
please not, that work, please not, you had passed,
Which is that order? Sir?
I think quite recently.
yes.
Quite recently.
Last
it was
week, I
passed.
guess.
Yes, my lords.
Dinesh Dalmia was.
I don't know what, Leonard, the senior counsel C.V. Nagesh sir had appeared.
I think they, the petition,
International fraudsters ಅಂತ ಹೇಳಿದ್ರು.
ಅದರಲ್ಲಿ
That's
petition,
what he
petition
said.
was dismissed and investigation could go on in that, my lords.
ಈಗ ಕಂಪ್ಲೇಂಟ್ ಒಂದಿದೆ ಇಲ್ಲಿ, ಅದಲ್ವಾ?
ಇಲ್ಲ, ನಮ್ I don't know, my lords. ನಮ್ ಕೊಟ್ಟಿದ್ದ ಕಾಪಿಯಲ್ಲಿ my lords, only we have FIR, page 32 ಅಲ್ಲಿ FIR ಇದೆ.
No,
Mistake, because
just see.
34 onwards is police.
ನೋಡಿ
Maybe probably the copy they've served on us, maybe that. Ma'am,
ಕೊಡಿ.
ಇದೆಯಾ? This is the one, my lords. ಆದ್ರೆ probably ನಮ್ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ page nation correct ಇದೆ. All the page nations are there, but the complaint ಇಲ್ಲ. So I wondered, my lords, without a complaint being there, how there was an interim order?
The complaint ಇದೆ, FIR ಇದೆ. Yes.
Hangandre, my lords, could it be
First
posted?
ground over. Next ground.
Alla, could it be posted on, because we are under the impression of
madam.
complaint only.
Exploring settlement.
No, my lords, we have not received any.
That work will settle.
ಅಲ್ಲ, ನಮ್ಗೆ ಕಾಸು ಕೊಟ್ರೆ ಸೆಟಲ್ ಮಾಡ್ತೀವಿ, my lords. And not that we are, wow, they give us what is due to us, we are ready to settle, my lords. There's a lot of
Your due amount appears to be undue.
huge amounts due,
ಅದೇ
my
ಅದಕ್ಕೆ
lords.
undue amounts. Yes.
We carry out the work, ultimately they are in a position to get that amount. Idರಲ್ಲಿ 5 crores odd is not paid to us, my lords. 15, I'm sorry, 15 crores, 5.
Then discount. Yes. Yes, madam. Pass over.
Some other date.
Passed over by 1 week. Yes. List Wednesday.
Please.
List where is that order of mine?
We'll give it, my lords.
Is it the same parties?
No, my lords.
Different party.
Accused are different. Because, my lords, we have had number of transactions in which some of it has led to filing of complaints. my
Well, that's why I said, where will that work settle the matter?
lords. Settle mark.
Unless their amounts are settled. All right. Yes.
Please, my lords.
List the matter on Wednesday. Next.
Admission 84.
Huh? NDPS. ನಿನ್ನೆ ಇತ್ತಲ್ಲ ಇದು. Oh, this matter. Voluntary statement. Paritosh judgment ಕೊಡಿ. ಇವರಲ್ಲಿ Malangod. He said he has nothing. No, which is your matter, madam? 6? Take that matter first. Madam, serial number 6. ಒಂದೊಂದಾಗಿ ಹೇಳ್ತೀನಿ. 6, 80 and 100 I think are connected. First 6 I will. The petitioner, what accused you are, madam? Petitioner accused number 3 in special CC 2076 of 2023 is knocking at the doors of this court in the subject petition, calling in question the proceedings, the entire proceedings in the aforesaid special CC registered for offences punishable under section 8C read with section 20, so on, madam, prayerly there. Heard the learned counsel, what's your name you said? So and so, appearing for the petitioner, and the learned counsel Shri Mallan Gaud representing the respondent, Narcotics Control Bureau. Facts enumerated are as follows. It transpires that on receipt of certain information of illegal transportation of drugs in 4 different parcels booked at Sri Maruti Courier Services Private Limited, Hebbal, Bangalore, the respondent police constitute a team and search the place at 12:30 PM. And on the same day, in the presence of the witnesses, when the parcels were opened, it was it transpires that it contained cannabis-ganja in each of the 4 parcels. Therefore, the respondent registers a suo motu complaint against the petitioner and other accused persons. On the same day, issued summons to the petitioner and recorded the statement under section 67 of the NDPS Act. After the recording of the said statement, again on 1/12/2022, the statement of the petitioner was recorded, in which it is alleged that the petitioner had confessed to committing the crime, stating that the petitioner had placed an order on his WhatsApp to one person called Raja, and the said Raja had couriered the parcel to the address of the petitioner. The petitioner then is taken into custody by the respondent and later released on, later enlarged on bail. The learned counsel, the police then file a charge sheet against these petitioners and the concerned court registers special CC 2076 of 2022 for the aforequoted offences. The registration of the filing of the charge sheet and the registration of special CC 2076 of 2022 for the aforesaid offences is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that there is no recovery of any contraband substance from the hands of the petitioner. Neither the parcel showed the address of the petitioner. The only circumstance that drew the petitioner into the web of crime was the telephone number that was found on the cover of the parcel at Maruti Courier Service. It is on that score the petitioner was interrogated, and while interrogation has confessed to the crime as afore narrated. The learned counsel would submit that voluntary statement or confession made under section 67 of the NDPS Act cannot be used as evidence against the maker of the statement. Maker of the statement. This court on 30th August 2024, by a detailed order, stayed further proceedings against the petitioner, awaiting the response of the learned counsel for the respondent. The counsel for the respondent, on verification of the records and instructions, would submit that apart from the statement that is tendered by the petitioner, accused number 3, there is no corroborative material that would pin down the petitioner for the aforesaid offences. The learned counsel would submit that necessary orders be passed by this court. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The afore narrated fact of the petitioner being drawn into the web of crime is not disputed. How he gets into the crime is what is required to be reiterated. The respondent is said to have received information about a parcel being sent from Maruti Courier Service. They were 4 in number. All the 4 is said to have contained ganja. On ganja being found in those 4 parcels, the police register a suo motu case against several accused. All the accused are before this court. After the registration of the crime, the accused were interrogated and their statements were recorded under section 67 of the NDPS Act. Recording of the statement led to the filing of the charge sheet against these, filing of a complaint rather, against these petitioners, drawing them as accused. All the accused are here. Amar. All against the accused 2 and 4, accused 2 and 3, you're 3, right? Accused 2 and 3 are before this court in the subject petition. The undisputed facts in the case at hand is that accused number 2 and 4, their names were not found on the 2 and 3, sorry. Accused number 2 and 3, their names were not found on the envelope that allegedly contained ganja. What was found was the telephone number. The telephone number, page, your address was there, that. Why are you, use the mic, madam?
The name is different.
Uh,
Page 32 is Rajesh Sharma. Page 49, the parcel is addressed to Arpital Dalmia.
1 minute. It is an undisputed fact that the covers in which the covers which allegedly contained ganja did not bear the address of the petitioners in both these cases. Nimdu irlilva?
Common address.
Common address and
Investigation
number.
is to indicate that it's a public address.
All right. They did not bear the names of these two petitioners, accused 2 and 3. The address on the cover was common. What contained in these two covers were the telephone numbers. The telephone numbers are that of the petitioners.
Please.
It is the finding of the telephone numbers on the cover led the police to interrogate and record statements of these petitioners, which forms a part of the complaint so filed for their 4 quoted offences. Apart from the confession statements recorded by the respondent police of these petitioners, there is no other material that can pin down these petitioners, as the parcel, though contained ganja, was not the address of the petitioners, nor in the name of these petitioners, except the telephone number, which is mysterious that except the mysterious except the mysterious printing of the telephone number on the complaint. The petitioners are said to have confessed to the crime while recording the statement under Section 67 of the Section 67 of the NDPS Act. The complaint so filed against these petitioners read as follows. Madam. A perusal at the complaint would indicate that no recovery of ganja was made from the hands of these petitioners, but the statements pinned them down. The Apex Court, it becomes apposite to refer to the judgment of the Apex Court in the case of Tufan Singh versus State of Tamil Nadu, reported in 2021 4 SEC page 1, court para 158, madam, wherein the Apex Court has held a voluntary or confession statement made under Section 67 of the NDPS Act cannot be used to pin the accused down for the offences under the NDPS Act so and so. Except the voluntary statement, there being nothing on record as accepted by the counsel for the respondent even, permitting further proceedings to continue against these petitioners would run foul of the judgment rendered by the Apex Court in the case of Tufan Singh and the subsequent law that is laid down by the Apex Court in the case of Balwinder Singh. Where is that, Amar? Madam, idralide unjudgmental first. Then a print out the court rules. In the light of the aforesaid law as laid down by the Apex Court in the aforequoted judgments, permitting further proceedings against these petitioners would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, the following order allowed quashed. Adrallu ಇನ್ನೊಂದು ಅಮರ್ ಕುರೇಲ್ for the same crime, right?
Yes, madam. Same.
For the reasons indicated. Nimdi serial number. Serial number.
Serial number 20.
Serial number 6 dictation ಕೊಟ್ಟಿದ್ದು. Serial number 20 for the reasons indicated in the so and so heard so and so ಅಂತ ಮಾಡಿ cost ಅಂತ. Next. ನಿಮ್ದು ಯಾವ್ದು ಸರ್?
Serial number 84, man.
84 ಇದೇ crime?
Ide. No, separate crime.
Separate crime? Then we'll hear it separately.
Please, I'll go with.
Yes.
Lordship.
84 is reached, is it?
Reached, sir, my.
This is 2022 matter.
What has happened, my lord? The lordship suggested to hear the matter in detail. Interim order was not granted. For that reason, it is for admission, my lord. On 29/5, 2021, the CCB raided the apartment. By the reliable information, they raided the apartment. There they got 6 persons were with contraband materials, and all procedures were taken place. They seized, and all formalities were seizure procedures were done. The FIR was drawn on 1 to 6 accused, my lord. Thereafter, on 3rd, the further investigation, these 7 to 10, the accused were arrested. On 3rd, 6, 2021, wherein petitioner is accused number 10, my lord.
Right.
Thereafter, the recovery measure was done against 7 to 8, 9. Recovery was done against them, my lord. Except this petitioner number
No,
10.
this is MDMA,
Yes.
LSD,
Yes.
ecstasy.
Yes, my lord.
Yes, sir.
In respect of the accused number 10, there is no recovery at all, my lord. Kindly have it on.
That's all right.
Please.
You are not, it is not like your case is akin to what was decided now.
Please, my lord.
Yes, sir.
I'll take it to the conspiration statement 329, my lord.
329.
329. Ink page.
You are accused number 10.
10, my lord. ನನಗೆ ಕಳೆದ 2-3 ವರ್ಷಗಳ ಹಿಂದೆ ನಾನು ಮತ್ತು ನನ್ನ ಸ್ನೇಹಿತ
Is this the only thing against you?
Yes, my lord. No recovery at all, my lord. Total 11 accused are there. Against all 10, their recovery has been made, my lord.
Oh, you gave it to them?
Please, my lord.
You gave everything to them?
No, the thing is, recovery is not made against me.
No, why? Nothing was found with
When
you.
nothing is found.
That's why I asked you, gave everything to accused 1 to 10.
No, my lord. What has happened? 1 to 6 were earlier the accused were there. The recovery of the measure was done on 29/5/2021. The further investigation was done. These people were arrested along with the 4 persons. The accused number 10 along with the 4 persons were arrested. Regarding that, 7 to 8 recovery was done. Against 9 was also done. And against me, there is no recovery at all, my lord. And the column of charge sheet, kindly have it on charge sheet 66.
Jagdish, sir.
Charge sheet.
ಇದು ಬಿಟ್ಟು ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ?
The reason why there is no recovery from him is that the other accused was arrested. Those arrest news was flashed in the news in the TV.
Oh,
please, man.
ಅಷ್ಟರಲ್ಲಿ ರೆಡಿ ಆಗ್ಬಿಟ್ರಿ.
Please, what?
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ ನಿಮ್ಗೆ.
Kindly have it on the charge sheet, my lord.
ಸೊ ಫ್ಲಾಶ್ ಆದ್ಮೇಲೆ ಇವ್ರಿಗೆ ಫ್ಲಾಶ್ ಆಗಿದೆ, ಇಟ್ಕೋಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ.
Lordship, the recovery has not been made on column number 7 of charge sheet. Column number 7. All accused, about 10 accused, the recovery was made, my lord.
27 ilva allegation?
27 was there. There they deleted, my lord, during the charge sheet. Lordship having a 64. Page 64, be kindly see. The section 80C, 20B, 21C, 22, 27A was earlier in the FIR, it was there. It is deleted, my lord.
And there is no conspiracy?
No.
Yes, sir.
There is no material at all for a conspiracy also, my lord.
You have to say anything?
Allegation is the conspiracy, but unfortunately subsequently.
Why is it dropped?
Everything
undoubtedly conspiracy.
Says, my lord, that in fact, accused number 7, 8, 9, even their voluntary statement, they say that all these people together decided to sell and they were selling together. And the recovery from accused number 7,
The recovery from 7, 8, 9 also. There is procedurally, they have not done it, my lord. How, like 1 to 6.
ಅದು 7, 8, 9 ಬಂದಾಗ ಅದು ನೋಡ್ಕೊಳ್ಳೋಣ. ಪ್ರೊಸೀಜರ್ ನಿಮ್ದು you are 11 or 10?
I am 10, my lord.
accused number 10.
ನನ್ನ ಜೊತೆ ಏನೂ ಇಲ್ಲ ಸರ್.
ಏನು
ಇಲ್ಲ, please. No recovery at all. There is no material to show that I have involved.
No ecstasy, No MDMA, no LSD.
Please, my lord, he is a student.
ಅವ್ರ ಹತ್ರನೇ ಇರೋದು.
ಇಲ್ಲ ಸ್ವಾಮಿ. The entire material, if you go browse to this also, we don't find any material, incriminating material on him.
ಅದಕ್ಕೆ ಈಗ you can't say innocent student ಅಂತ. Wait.
Let him approach the trial court, my lord, let him ask for a discharge.
ಇಲ್ಲ sir.
Why?
Otherwise, my lord, that.
Why
because
if
of-
there is
No,
nothing-
it is not that surprise, he was arrested because of other accused being arrested. And their arrest has been flashed in the news media. That is the only reason, my lord, it was, we could not make any recovery from his hand. Otherwise, my lord, we could have recovered from his also. Therefore, there's statement of co-accused also which speaks about it. Let him ask for a discharge.
Where are you studying?
The design and all the things.
Design.
Yes, ma'am.
What design?
Graphic design, my lord.
Graphic design.
Online graphic designing, freelancing, and he is 22 years old, my lord.
Correct.
Where
Please,
they
my lord.
purchase in the dark.
The
web.
menace has hit that age only.
He added to that, my lord. There is no material to show that his involvement, my lord. Lordship.
Yes, sir.
Them uploads to trial court, my lord, and ask for a discharge.
ಸುಮ್ನೆ ಯಾಕೆ?
Only issue is that it becomes a.
It entirely affects his career, my lord. That is there.
As you
If
saw,
it is material, then I can say.
no, it was not like that post office matter. As you sow, so you reap.
Lordship.
If it's affecting your career, it's because of that.
Lordship.
Jaisi Karni.
Now elaborately that Baldev Singh's this thing. You have elaborately discussed about the thing is same thing. It is I fall in that squarely. I fall in that squarely. I fall in. I squarely fall in that.
4 ಸರಿ ಆಯ್ತು ಸ್ಕ್ವೇರ್.
67 and 53, my lord. Is the student.
ಅದು ಆಯ್ತು. Yes.
Added to that, my lord. There is no material at all, sir.
ಅದು ಆಯ್ತು.
Lordship, the thing is, the entire material.
ಮತ್ತೆ please don't go to materials.
Lordship.
Sometimes the process is a punishment.
Lordship.
Sometimes the process is a punishment, my lord. It may not-
ಈ process ಆಗಿದೆಯಲ್ಲ?
ಇನ್ನೂ ಆಗಿಲ್ಲ.
ಆಗ್ಲಿ ಅಂತ.
ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ
Lordship.
You're on
The
bail.
entire 1 to 6 accused.
Bail.
Please, my, I am on a bail, my lord. Entire 1 to 6, the voluntary statement, they named all accused name except this accused name, this
789
petitioner.
speaks.
That is there, my lord.
789.
789, the 7 and 8, they generally they stay that along with him, we were doing. 7, I'll take it.
If it was ganja, anyway, it's a narcotic.
Lordship, that is.
This is not narcotics, sir.
Lordship, what has happened?
What is found with you is not a narcotic substance.
Lordship.
It's not a narcotic drug, it's a psychotropic
If
substance.
full trial it takes place also, that it is abuse of the process.
Abuse of the process.
He is going, Lordship, the consider for this thing, entire material. If anything it is there,
Let him come back.
let him show.
Discharge
Please,
doesn't
my,
happen, let him come back.
kindly have it.
NDPS ಅಲ್ಲಿ.
Lordship, it is clearly in a Balwant Singh case, Lordship have clearly and elaborately explain the things. I fall squarely in that.
No, square saku. Tomorrow. Yes. I'll squarely fall in your prayer. Yes.
Illa Swami,
Tomorrow. Yes. Tomorrow will dictate.
Please.
Entry ಮಾಡ್ರೆ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ.
ಅದು ಸಾಕು ಇಲ್ಲಿವರೆಗೆ ಟ್ರಯಲ್ ಆಗಿದೆ.
Lordship, that this case has been transferred to another session.
ಕೊಡಿ ಅದು ಕೊಡಿ. Will allow it, but tomorrow.
Obliged.
Yes.
Yes.
Rahul.
Apologies, sir, but I was on my
No
legs.
problem, sir.
Serial number
You should
82.
keep coming to this court till the ಹೆಂಗೆ? Extension ಗಳಾಗದೆ ಹೆಂಗೆ?
Serial number 8, no, serial number 82, it may be that one.
30 more days. Why 60? ಸಾಕು. Premature release ಕೊಟ್ಟಿದ್ದಾರಾ? Recommended for premature release.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ premature release ಇಲ್ಲ ಇದ್ರಲ್ಲಿ.
No, he has been recommended, but there is no record for the first time. Before the FCRC. For the first time, he has been out for 30 days.
I leave it to your lordship.
No.
No, he's
No
surrendered
adverse,
in time. No adverse.
Back in time.
Yes, he's back in.
60 days. Extend. No more extension.
I,
Final
more
extension.
serial number 75, that 15 days parole is been let off.
ಯಾವ್ದದು? Emergency parole.
Yeah, guidelines, your lordship.
ಅಲ್ಲ guidelines are ನೋಡ್ತೀವಿ apparently.
I'll post it on 13th.
ಆಯ್ತು.
ಈಗ ಒಳಗಿದ್ದೀರಾ ಆಚೆ ಇದ್ದೀರಾ?
Achi,
ಆಚೆ ಇದ್ದೀರಾ, ಅಲ್ಲೇ ಇರಿ.
15 days, your lordship.
ಯಾವತ್ತು
Yes,
ಎಕ್ಸ್ಪೈರ್
sir.
ಆಗೋದು?
1ನೇ ತಾರೀಕು ಹೋಗಿರೋದು.
No, that 90 days parole has been given and extension another 15.
38 ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹೌದು.
15 days.
Okay.
Let it come on 13th. Yes.
God bless.
The lordship may have it on.
ಅದು ಗೈಡ್ಲೈನ್ಸ್ ಲೇ ಡೌನ್ ಮಾಡಕ್ಕಷ್ಟೇ.
So 18th, I'll look into the guidelines and then we'll
ಎಲ್ಲಿ
compare.
if you ask Jagdish, he will give you. Yes.
No, that I need some time to compare and just
Rahul needs time to compare.
No, your lordship.
Your
Because,
ನಿಮ್ದೇನ್ ಚಾಲೆಂಜ್ ಸರ್ ಮತ್ತೆ ಈಗ?
Your lord.
Wait, both of you don't speak.
There are
Hmm.
things copied and pasted.
Maharashtra.
That is,
Time of
somewhere-
British.
Yeah.
Copy paste.
So many things which should be addressed.
Okay.
Prevent of building and the prison's punishments in the prisons and the prison authorities, they cannot punish directly, they will punish for the 5 years and they will enter into the, if a offense is committed in the prison.
Mic use ಮಾಡಿ.
If an offense is committed in a prison without conducting a trial or investigation, they will directly punish for the 5 years and they are not recommended for the premature release for another 5 years. And that authorities, the court is the court can only punish the persons.
How can you pass sentence?
no, we are not passing any sentence. I
What
don't
is
know what
saying?
submission is making regarding what aspect.
If any prohibited item is found in the possession of then a prisoner,
What is filed?
if any, there are so many offences which I'll bring to the knowledge of this lordship at the time of hearing, my lords. Tomorrow, the case is posted for the food, my lords. At that time also I will address.
Food.
That food in the prison, my lords.
Lordship, that is that
that
matter
nutrition
regarding.
food ಮಾಡಿದ್ವಲ್ಲ?
No, my lords.
No, one of his petitions has been tagged along with,
Darshan.
It is coming tomorrow, yes, my lords.
so in that matter he is trying.
There are some punishment, it's not punishment, though it's called as a punishment, speaks about not availing some of the facilities if you violate the prison.
But in the prison, nutritious food is not given to the.
No,
Is not given.
We'll place all those documents, what
what is-
facilities are
Even-
given.
What do you have as a diet chart under, obtaining under the prison manual you have, or you have something else?
Produce all those documents.
Food,
Allah, food.
documents.
No, your lordship,
Hmm.
food is being provided, there's a canteen. And there's a bakery
So
also.
he
There's
was telling about what is provided.
No, your lordship will.
You
come
want
up
me
with-
to
we'll
repeat
file-
that?
we'll File necessary affidavit.
You want me to repeat that? He says if ragi balls are thrown, it rebounds back to them. That is the food that is given
Lords,
in the prison.
if they give the food at 4 o'clock and they have to have that dinner at 8:30 or 9 o'clock, obviously the food, and it is the not good quantity and good quality, my lords. Quantity is also is not sufficient for the prisoner to have. There no sufficient food is given, no nutrition food.
Why do you eat food at 9 o'clock when it is given at 4 o'clock?
Let's see, it is the dinner, my lords.
Oh, dinner is given.
Yes,
at
dinner is given at 4 o'clock.
4. Yes, sir.
That rule was at the time of British, my lord, because there was no electricity facilities and at the time of, they cannot prepare.
Necessary
Not because of that.
affidavit of
The
food.
British finished the dinner at 6 PM. That is why. Yes. Not because of electricity. Yes.
Lordship, ಇದು 15th ಗೆ this others, serial number 75 regarding the premature release manual which my learned friend is.
When do I take?
Even, my lords, one submission. my
So
lords.
one by one
Sub-
now. Release a food.
No, my lords, food is tomorrow, my lords, and the premature release guidelines, the prison authorities for some prisoners, they discriminate and they will recommend for the release of who has undergone 11 years, 11 and a half years. And there are simultaneous, there are so many prisoners who are languishing in the jail for 18, 20, 24 years, which your lordship has heard the petitions.
No, it depends upon the offenses that you are convicted of.
No, my lords, it depends upon
If
the,
you are convicted
it
of
depends
terrorist-
upon the.
terrorist activities, where is the
Terrorist
question?
activities,
No, I'm not speaking about the terrorist activities, and the case which is before your lordship, he has already undergone 19 years, my lords.
302.
Yes, 302. He has already undergone 19 years.
Then Dandupalyana?
No, Dandupalla, they have already undergone 24 years and they are been on the parole. And other matters who were 302, if the entire prison authorities are involved in the corruption matters, if I pay for them, they'll recommend me to the premature release.
ಮೈಕಲ್ಲೆಲ್ಲ ಹೇಳ್ಬಾರ್ದಲ್ಲ. ಎಸ್.
No, your lordship, a date may be fixed. In this particular matter, we will look into the Maharashtra rules.
He has given
Yeah,
everything.
that ನೋಡ್ತೀವಿ ಸಮಯ.
ನೀವು ನೋಡಿದ್ದೀರ ಅದು ಕಾಪಿ?
No, my lords.
ಅವ್ರಿಗೊಂದು ಕೊಟ್ಬಿಡಿ. ಅವ್ರಿಗೊಂದು ಕೊಟ್ರೆ he will assist the court. Yes.
ಹಳೆ ಕ್ಲೈಂಟ್.
ಹಳೆ client ಅದು.
Oh, ಸರಿ ಸರಿ ಆಯ್ತು. Then we'll take that on 13th. 13th ಆಗ್ಬೋದು. 18th ಬೇಕಾ?
18th ಗೆ.
No, that parole ends on 14th.
14.
What I have granted on 30th.
So 14th ಗೆ.
We'll take it Saturday, sir. ಅದು.
ಹೌದು,
13th,
I'm-
yes.
13th.
ಯಾಕೆ ಅವ್ರು ಮಾಡಲ್ವಾ ಅದನ್ನ?
Yeah, but he has been recommended for 3 times.
ಪರವಾಗಿಲ್ಲ, ಏನ್ ಹೇಳಿ ಮೇಡಮ್? ಹೇಳಿ ಪರವಾಗಿಲ್ಲ. ಏನ್ ಪ್ರಿಮೆಚೂರ್ ರಿಲೀಸ್ ಈಗ?
His co-accused has been already been released.
Your lordship, please give me the petition copy because.
ಅಲ್ಲ, the whole thing is, see, premature release committee ಮುಂದೆ, when 10 accused go, you release 5 accused and detain 5 accused. All of them are charged of the same offense. Why is that?
No, I'll seek instruction.
That is his
No,
plea
I'll
of
look into why.
discrimination.
The
this was not
prisoner
considered.
who work according to the jailers and superintendent, they go to work in their homes, my lords, and they'll be
Homes,
recommended.
sir.
Yes. They'll do the work of maid, they'll go up cleaning their vessels and also they'll be recommended very easily. And the prisoners who can afford
sir.
something.
13th.
That only.
What's up, please?
All right.
No,
Sir,
I'll
We'll
seek instructions why.
consider it
what is-
comprehensively on 13th.
Right.
Yes.
Much obliged.
Yes. ಏನ್ ಪೊಲೀಸು? ಹೋಗ್ಲಿ ಬಿಡಿ. ತೊಂದ್ರೆ ಇಲ್ಲ. ಅಲ್ಲ, ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಆಗ್ಬಾರ್ದು. 13th ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಎಸ್, ಕಂಟಿನ್ಯೂ.
Continued 85.
ಎಸ್, ಕಮೆಂಟ್.
Alcohol supply.
ನೀವ್ ಯಾರು?
4 and 5.
ಇವ್ರ ಮೇಲೆ ಏನಿದೆ?
ಅಲ್ಲ, ಇವರನ್ನೇ ಅವರಿಗೆ ಕೊಟ್ಟು ಮಾಡಿಸಿರೋದು.
ಅವ್ರಿಗೆ ಹೇಳೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಮಾರಿದ್ದಾರೆ. ದುಡ್ಡು ರಿಕವರಿ ಆಗಿರೋದು 1 ಇಂದ, ಮಗುವನ್ನು ತಗೊಂಡಿದ್ದು 1 and 2 ಇಂದ.
ಓ, ದಟ್ ಮಾರಿರೋದು. ಎಸ್. ಬಟ್ ಇವ್ರ ಮೇಲೆ ಏನಿದೆ? ಮಗು ಅವ್ರ ಹತ್ರನೇ ಇದೆ ಅಂತ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ.
ಸ್ಟೇಟ್ಮೆಂಟ್ 1 ತಿಂಗಳು ಆದ್ಮೇಲೆ ಮಗು ಎದ್ ರಿಕವರ್ಡ್ ಅದನ್ನ ವಾಪಸ್. ಕೋರ್ಸ್ FIR was filed earlier.
ಅಲ್ಲ, ಇವ್ರು ತಗೊಂಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Complaint was registered earlier. So then child was recovered from the parents.
From the parents only. Then how do you pin them down?
The issue is that the child was handed over back to the parents.
When?
That is absent in our investigation.
Not there in the.
No, that is not there in the complaint. That is not there in the
The
statement.
complaint kottaga magu was not with the parents.
ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಾಗ ಹೌದು. ಆಮೇಲೆ when the statement was recorded, the children rather was with the parents. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ಆರೋಪಿ 1-4-5 ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಸಮಾಜಿತ ಶಿಶುವನ್ನು ಹಣಕ್ಕೆ ಕೊಡುವುದೊಂದಕ್ಕೆ ತನಿಖೆಯಿಂದ ಹೊರಪಡಿ. ಎಸ್. Why don't you do it properly when you do it? All the zeal. But everywhere loopholes are
Clear
left.
case of a trafficking, but unfortunately,
How do we permit trial to go on in this?
there are other means of you could have taken the child, but of course, we have not.
As on the date you recorded the statement of the parents, biological parents, the child was with them. And he says never taken. And money was recovered 15,000,
15,000, total 50,000 ಗೆ ಮಾರಿದ್ದು.
huh?
ಅದರಲ್ಲಿ 15 ರಿಕವರಿ ಆಗಿದೆ. 35,000
Accused number 1 ಇಂದ. Who is accused number 1?
Parents.
Parents ಇಂದ. ಅದು ಇವ್ರ ದುಡ್ಡು ಅಂತ ಹೆಂಗ್ ಗೊತ್ತು?
ಹೇಳ್ತಾರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಒಂದು ಬೈಕ್ ಮತ್ತೆ ಬೈಕ್ ತಗೊಂಡಿದ್ದಾರೆ ಚೈಲ್ಡ್ ಅನ್ನ ಮಾರಿ ಬೈಕ್ ಮತ್ತೆ ಉಳಿದ ಹಣ ರಿಕವರಿ ಮಾಡಿ.
ಅಲ್ಲ, ಇವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ? ಎಲ್ಲಿದೆ? Page,
Lordship, may see page 24, my lord. Page 24, my lord. Bike ಮತ್ತೆ amount ಇರೋದು.
ರಂಗನಾಥ್ ಯಾರು? Prasad and Nirmala. Yes, mister, why would they tell lies? Why would they utter falsehood in the statement that is given? ಇಲ್ಲೇ ಹೇಳಿದಾರಲ್ಲ, page 26. No, because the offense is unpardonable, that's the reason examination. ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡೋದು.
2 ತಾರೀಕಿಗೆ FIR ಆಗುತ್ತೆ. 6 ತಾರೀಕಿಗೆ ಅರೆಸ್ಟ್, ಎಲ್ಲಾ ವಿಟ್ನೆಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ 6 ತಾರೀಕು. ನೆಕ್ಸ್ಟ್ ಮಂತ್ 12 ತಾರೀಕಿಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಬರುತ್ತೆ.
ಅದೇನು ಜಲ್ದಿ ಮಾಡಿದ್ರು ತಪ್ಪು, ಲೇಟ್ ಆಗಿ ಮಾಡಿದ್ರು ತಪ್ಪು.
ಏನಾದ್ರೂ ಇವರನ್ನು ಇಂಪ್ಲಿಕೇಟ್ ಮಾಡುವಂತದ್ದು ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಏನು ಇಲ್ಲ, ಎಕ್ಸೆಪ್ಟ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್. ದಟ್ ಟು ಹಿಯರ್ಸೇ ಸ್ಟೇಟ್ಮೆಂಟ್.
More call details ಎಲ್ಲ ತೆಗೆದು ಮಾಡಿದ್ರೆ ಸರಿಯಾಗಿರ್ತಿತ್ತು. Unfortunately, we have not done. All those things we could have done it, but we have not done.
That's the way to do it. All right. List on 20th. Interim order subsisting shall continue till the next date of hearing. Next.
86. I'm appearing for the petitioner in this matter, Your Lordship. We have appeared before this court seeking the quashing of the 138 proceedings instituted against the
Who
petitioner.
appears for the respondent, madam?
He is a part.
Served unrepresented.
Yes.
Yes, what's the matter?
Your Lordship, the case of the respondent is that he had, the petitioner allegedly asked him for financial assistance of 2 lakh rupees, which the respondent gave to him. And for this purpose, the petitioner allegedly issued 2 checks of 1 lakh each, which were dishonored. Subsequent to which legal notice was issued and complaint was instituted against the petitioner.
138.
Yes, Your Lordship. But the checks that have been produced at Annexure C and C1, there are 2 checks. Your Lordship, the account number that is mentioned therein does not belong to the petitioner at all. The account details pertaining to that, though, that account number is given in Annexure D, which is contained at page number 16. If you can see, the name is not of the petitioner at all. The complaint, sorry, the legal notice and the complaint of the respondent states that the petitioner was allegedly conducting business. Even the complaint which is contained at page number 19, if you can see the details of the accused, it states that he has business, he is 38 years old, and his address is mentioned. But Your Lordship, the petitioner is actually a 22-year-old student, 23-year-old student. He just completed his MBBS studies. He has no knowledge, he has no connection whatsoever with the respondent herein.
The checks are produced?
In the lower court, Your Lordship. Yes, but the checks, the account number the account does not belong to the petitioner. The signature on the checks is not of the petitioner. The signature of the petitioner is contained at the affidavit at page number 40. If you compare this with the checks at Annexures C, that is on page number 14 and 15.
Notice was sent to you?
Yes, but I have not received it. I was pursuing my studies in Shimoga. The notice has gone to the address. I have no knowledge. I have not accepted I have not received any notice. I only found out about the case when summons of this summons pertaining to the same were issued to me. Subsequently, I've appeared before the lower court, trial court, and I've filed application for bail, which was granted. Your Lordship, I have never met the respondent. I have no idea who he is. He is trying to exert pressure on me. Sorry?
For what?
Your Lordship, the checks that were issued were in the name of my father. The account number pertains to my father. My father is a businessman. He would have issued perhaps the checks to some third party in the course of business. Even he has no knowledge of the respondent. And the respondent is missing.
Your accused number?
There is just one accused, Your Lordship.
Sole
Me.
accused.
Yes. The case has been filed against me, although I have no nexus to this matter at all. In fact, even there is an email from Karnataka Bank that is contained at
Page
towards the end, Your Lordship, it was filed with a memo. The last,
Towards the end,
sorry,
yes.
it was subsequently filed, Your Lordship,
Yes.
along with a memo. This email also by Karnataka Bank.
Annexure H.
Annexure H, sorry. This email also clearly states that the check numbers mentioned therein, that is two checks, 532521 and 532522, do not belong to the account number of the petitioner.
Yes, 1 second. So, 2023. Madam, yavat sir vallu? 10, 12, 23. Heard, the petitioner is before this court calling in question proceedings in CC 2957 of 2022, registered for offences punishable under section 138 of the Negotiable Instruments Act and section 420 of the IPC. In CC 2957 of 2022, who had heard the learned counsel appearing for the petitioner, the counsel for the respondent, though served on 10/4/2023, has remained unrepresented even today. Therefore, the counsel for the petitioner is heard. The petitioner is the accused and the respondent, the complainant. An alleged transaction is projected by the complainant contending that the petitioner had availed of certain financial assistance at ₹2 lakhs and had issued 2 checks in favor of the respondent complainant. The checks having been dishonored has led the complainant to the Court of the Learned Magistrate invoking section 200 of the CRPC for offence punishable under section 138 of the Negotiable Instruments Act. The concerned court takes cognizance, registers criminal case for offence punishable under section 138 of the Negotiable Instruments Act and section 420 of the IPC. The registration of the crime and issuance of summons to the petitioner has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the petitioner is a student who is pursuing his studies in where is the Shumaga?
He just completed his
All right,
MBBS.
at the relevant point in time.
Yes.
At the relevant point in time was pursuing his studies in Subbaiah Institute of Medical Sciences, Shumaga. He's a student of MBBS. The learned counsel would further submit that he has only one bank account at the Karnataka Bank, who also have issued an endorsement that there is no check issued by the petitioner that would be drawn on Karnataka Bank. The learned counsel would further contend that there is no privity of contract between the petitioner or the respondent, as the petitioner is not even aware of what business the respondent would run for him to enter into a transaction or seek financial assistance from his hands. As observed herein above, the complainant remains unrepresented. The afore-narrated facts are not in dispute. What is projected is an alleged transaction. The transaction is receipt of an amount of ₹2 lakhs by the petitioner and the petitioner issuing 2 checks. The complaint, if the perusal at the complaint would indicate that the age of the person who has signed the check according to the complaint is about 38 years. And the petitioner, who is said to be pursuing medicine at Subbaiah Institute of Medical Sciences, is aged 22 years. There is no correlation between what is stated in the complaint and what are the actual facts in the case at hand. As observed by the learned counsel as contended by the learned counsel for the petitioner is said to have been caught in the crossfire of issuance of certain checks, not by the petitioner, but why should we bring the father? Yes, caught in the crossfire between checks being issued by someone else, as admittedly the petitioner is not the signatory to the checks so made. The petitioner appears to have been drawn into the web of proceedings under the Negotiable Instruments Act without any rhyme or reason. The other reason that would vitiate the proceedings is The cognizance being taken by the learned magistrate for offence punishable under section 138 of the Negotiable Instruments Act coupled with section 420 of the IPC. This, whether is maintainable or not, is now referred to a larger bench by the apex court in the case of so-and-so 2022 SEC Online SC page 1010. Therefore, on these twin counts, permitting further proceedings against this petitioner would become an abuse of the process of the law and result in miscarriage of justice. In that light, the so-and-so quashed. Next.
87.
Huh? What's the matter, sir? ಇದು ಬಿಡಿಯೇನಾ? ಬಿಡಿ ಅದು ಅಕ್ಷಯ್ ಗೌಡ 4-5 ಕೇಸ್ ಇದೆ, ಇಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ. 2:30 I have specifically posted because last time also he was not present. Today also he is not present.
I'll inform.
Why?
This is a case where without even option of a corner side sale deed has been executed by creating a document as if this property was put to auction and he has been a successful bidder, and not a sale deed is executed. And the present petitioner is one among those who has facilitated.
Yes, sir.
Does not even belong to that section or department.
Who?
Case worker.
You're a government servant. BDA employee.
Case worker who has no access to any of the documents of other departments.
Case worker ಇರೋಷ್ಟು access ಬೇರೆ ಯಾರಿಗೂ ಇರಲ್ಲ. Don't tell me about case workers.
Allegation is that he took the file to verify it to the account section, got it back and said
Case
it
worker will have access to all cases of all departments in that department. ಅದೆಲ್ಲ project ಮಾಡಲೇಬೇಡಿ. Yes, list on 18th at the request of the council appearing for the petitioner. Interim order subsisting shall continue to the next date of hearing.
58.
Yes, for the
Lordship, Mr. Jeevan J. Niralgi, council has filed wakalat for in respect of R2, your lordship.
So what's to be done?
We want time to file objections, your lordship.
When did you file wakalats?
It was filed on yesterday.
Yesterday. Enter ಮಾಡಿದ್ಯಾ? Learned counsel representing Jeevan J. Neralli submits that he has entered appearance for the respondent only yesterday, date ಹಾಕಿ. Therefore, list this matter in the second week of October. Interim order granted earlier stands extended to the next date of hearing.
89.
Petitioner in this case, madam.
Petitioner? Mic ತೋಡಿ.
Pray for time, my lord. Senior.
Raise time. What's the matter? Yes. It's all right, yes.
Civil suit is pending.
You want time? Who wants time?
Yes, for A2.
Who appears for the respondent? Muniraj. Heard the learned counsel appearing for the petitioner. Awaiting the appearance of the learned counsel appearing for the respondent, list the matter on 11th in the fresh matters list. Interim order subsisting shall continue to the disposal of the petition. This should be allowed, sir. Jagdish, sir. Straight away allowed. Money recovery ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? Yes.
90.
ನೀವಿದ್ದೀರಾ? 90.
For the petitioner's counsel. Money recovery suit filed in the form of a criminal complaint.
ಏನು ಇದು ಸೆಟ್ಟು ಆಗ್ದಾ? Chinmay is here.
Please, Lord.
Who is the complainant, sir?
Lord, Zetwork, please. Zetwork.
Yes. Who is the petitioner?
Petitioner is a company by name Avexa. There are.
What? Name?
Avexa.
You had a tripartite agreement with that matter. The other, they have disposed one judgment. They have rendered one judgment,
No,
dispose the
please,
matter.
no, please. No, please.
They,
No, not connected.
no, not connected again. Yes.
Anyway, I am not aware of this. There are too many networks, so I don't know if there are more than one Avexas.
No, there are too many networks, you will lose the network.
But please be kind enough to take page 73.
Hmm.
Basically, there are two agreements. There is an MOU and then there is another master service agreement between the two of us.
Hmm.
I procure contracts from the Andhra Pradesh government and several other public sector enterprises.
Hmm.
He is to execute some of them. In some, he has to supply material. In some, he has to execute the project.
Hmm.
Please be kind enough to look at page 73. The first in the sequence, Annexure H in the petition. Government of Andhra Pradesh writes to me and says, look, there is a problem. There is no work that's going on. Well, what are you doing? That I will not write to him and say, look, on 19th June 2023 and say, look, what is this? You've not done anything. Please proceed. Two follow-up letters. After that, promptly on at page 78, he issues me an invoice saying you owe me crores of rupees and then files a criminal complaint.
All of a sudden invoice brings, is it?
That's right. So there are other
No
transactions
contract
going
between
on.
you?
There is a contract. There are two contracts between us. No dispute about it. So essentially,
You're putting it so.
no, I did say
Yes.
that there are two. There is an MOU and there is a master service agreement. One is for work to be completed. The other is for supply of material. What he would do is he files a complaint. Now, please be kind enough. And this is also the case. Perhaps your lordship may recall. I had pointed out there was an interim order. The court saw the order sheet and said that there wasn't one. It was in the connected matter. We verified, my lord. There was, in fact, my learned friends also fairly pointed out that there was an interim order. There is a mix-up. It was
Not granted.
no. What had happened was there were two petitions, both against Z-Work by another party, nothing to do with me. Interim order comes to be passed in that petition when they are connected. So therefore, once it was disconnected and that was allowed, the interim order was not noticed in this petition. That is the oversight. Be that as it may. In fact, in a statement of objections, he concedes the position that there was an interim order. Now, there are two things.
No, we want an interim order, final order.
Final order, my lord. If your lordship grant me, I'll be very grateful. There is also an application.
Not for the asking.
Of course not. I have to make out a case. I'm fully conscious. It's nothing for the asking. But there is also an application. The other thing that happens is they file a complaint. The very next day, the police freezes 3 of my bank accounts.
What is the amount involved?
But the amount they claim is around 25 crores.
25
crores. This is ultimately a money recovery proceeding that they'll have to institute. And what they do is, after my bank account is frozen, to further arm twist me, not just have they used the criminal proceedings, they're also trying to use the NCLT proceedings. They issue me a notice, demand notice under section 8 of the insolvency code. Of course, we should have replied to that, be that as it may. So therefore, there is also an interim application for defreezing of the account that is before your lordships. I want to bring to your lordship's notice one other fact. Para 4 of their statement of objections, they would say that respondent number 2 came to know around September 22 that they stopped receiving payments. Now, they can't have discovered the fraud after complaints are made to them saying, look, you're not doing any work and you abandoned the site 1 year later. That is my submission.
How will they know otherwise?
My lord, the point is in their objections, they say that in September 22, that they've stopped receiving payments. The complaint they make is in August 23, 1 year later, and after I intimate them about the Andhra Pradesh government's intimation to me. Therefore, my lord, my respectful submission is this is not a case for a criminal proceeding. Civil proceeding, they already have tried to institute through the insolvency process. Let that take its logical end. But if your lordships look at these 3-4 documents.
Take this also to its logical end.
Hey, grateful to you.
Ishtot ಹೇಳಿದ್ದು common merits.
Please look at the first submission I want to make is, please look at the complaint itself.
Page. You're ready?
Yes.
Page 20, my lord.
Page 20 of the petition.
ಅದೇ ನಾವು you are ready ಅಂತ ಕೇಳಿದ ತಕ್ಷಣ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ. Wait.
ಅಲ್ಲಿ ಹುಡ್ಕಕ್ಕೆ 20 ಕೈಯಲ್ಲಿ
iPad problem ಇದೆ.
Problem is that when one bookmarks it.
You can never replace papers.
Sorry.
According to me, you can't make it paperless. You can only make it less paper.
Less paper. I completely bought into that. And I think also you're so hardwired with paper instinct is again to grab.
All right. Yes, sir.
But please look at the complaint. 10th August. The complaint they would make is against the petitioner and the directors.
please be kind enough to come to para 3, where they talk about how that there are many tenders that we have procured. The list is given in the following page, my lord, page 22.
Right.
Please be kind enough to come to para 4 at page 23. Their case is that I have made a false representation and promise that I would make timely payments. Please be kind enough to take para 4, about 6 lines from the top. It is pertinent to note that. It is pertinent to note that from the above mentioned projects, AVEXA and its directors had made a false representation and promise that AVEXA would make timely payments of the invoices amounts, which were due and payable to ZWork within 60 days from the date of the invoice for the goods and services provided by ZWork towards completion of the projects based on the inducement only ZWork agreed to conduct business with. Then 5, in furtherance to the criminal plan, AVEXA and its directors also made ZWork believe there will be transparency in the money received by them, the end clients of AVEXA in the projects. Towards this end, they assured ZWork there will be an escrow agreement account.
What's this? Alexa, AVEXA.
AVEXA.
Yes,
I don't have all the answers. It's not Alexa. Towards this end, they assured.
I thought you were asking Alexa. Yes.
Towards this end, they assured ZWork that there shall be an escrow agreement and the same shall be jointly operated by the parties. AVEXA further assured that all the monies paid by the end clients listed in para 3 above will be credited into the escrow account and the money will be distributed as per the understanding and the agreement between the parties.
Yeah.
Now, the next paragraph, they list out what they call are instances of violations and so on and so forth. Their case is that I've received money, but I've not paid further to them. That is what they say.
Received money and did what?
And I have not paid it forward to them from the government against these.
You have received the money.
That is what their case is. That is the sum and substance of their case. My respectful submission is the answer to
How
that
much
is-
did you receive?
But according to me, that is not correct. I have received monies, I have paid also. It is not as if it's a standalone transaction. Therefore, these accounts need to be reconciled. In fact, that is precisely the reply that I had given to the
There's a
IBC notice.
dispute with regard to payment.
According to me, that is also there. And more importantly, please be kind enough to come to Annexure H,
Page.
page 73. Ma'am.
Yes.
This is 8th June 2000, I'm sorry, 8th June 23. The government of Andhra Pradesh would write to me and say that in the first paragraph, they say that on the subject work so and so, as of today, it appears present progress is very slow and the department has expressed displeasure and so on and so forth. Please be kind enough then to turn to 74. I write to them on 19th June and refer to the letter of intent, MOU, etc.
Yes.
And I point out, look, you are not doing the work as is required. Andhra Pradesh government is complaining. Please do what you need to do. I follow up with one more letter at page 76, Annexure K, 4th July. Then page 78, on 14th July, they would respond not with a reply, but with an invoice of 2.29 crores. To which I immediately say your invoice, or at page 79, I dispute that invoice. Then, after this comes the complaint.
1 minute. Yes, Sandesh sir.
Could I just point out? my
No,
lords?
this appears to be a money recovery proceeding.
This is not a money recovery
Then what?
proceeding at all, my lords. 9 projects which they have taken up, my lords. Now, the projects which they to take up, they enter into agreement with this.
All right.
Now, my lords, under that agreement, my lords, we do all the work. We have an escrow account.
Oh,
The money has to come to the escrow account and then the distribution to take place.
all right.
They bypass this whole thing. What they do is they collect the money, my lords. They don't pay us. We complete the work. They don't pay us. Now, money which they hadn't paid us, my lords, by misrepresenting that the money would come to the escrow account is to the tune of this 25 crores. That's why, my lords, by bifurcating this complaint, my lords would notice what now they were submitting is on transaction 2, my lords. Transaction 1 would be a clear case, my lords, right from the inception till now, my lords. My respectful submission is dishonest intention leading to the ingredients of 420, my lords. From the inception, I can understand, my lords, when payments have been done, certain amount due, we can say ingredients are not there from the inception. It may not come to cheating. This is not a case of that nature. Now, these 2 transactions, my lords, I have bifurcated, though it's there in the entire complaint, I have bifurcated and given it along with a memo, my lords. My lords, it's in fact even along with the objections now filed also, we have clearly put it in precise terms, my lords, as transaction 1 and transaction 2.
That's the complaint also.
ಅದು ಸ್ವಲ್ಪ lengthy ಆಗಿದೆ, so we'll have to see in between what all has happened. This
Yeah.
we have made it more crisp, my lords. And the sum and substance, my lords, see, what is awarded to them, they get us to do the entire job, and under our agreement, the amounts had to come to an.
Now we have instituted proceedings before the NCLT.
My lords, it is not a recovery. My lords, ultimately, prima facie is a case made out for an investigation of cheating or not. Prima facie. Reading of this, a cognizable offense, disclosing a case of cheating or not. Now, my lords, if no case of cheating at all is there, my lords, we say when there's no case of cheating, it's only, my lords, at the inception, there's nothing. Later it comes, some recoveries have happened and remaining not. This is not a case of that nature. At the inception itself, they say we'll have a joint account. Not a penny comes to joint account. They take it behind our backs from, my lords, the person who has given this, the procurement entity, my lords. From them, they take it. I do the work, you enjoy the money. What am I to do, my lords? This is where it comes down. A reading of this entire complaint, whether it discloses a cognizable offense requiring an
He
investigation.
says amounts are paid.
No,
There
my
is a
lords,
dispute with regard to. Now, there is a dispute with regard to payment of
My
amount.
lords, according to us in the complaint, as we have pointed out, the entire
like-
amount of 25 crores, 46 lakhs, 83,233 has not been paid. This is one aspect. Second, kindly notice, my lords, after that, what they do? They get me even to pay bank guarantee. Give a bank guarantee which they are supposed to give it to the procurement entity. They make me give that. Now, look at the risk I am being exposed to, my
The
lords.
ground is that you were lured into all this.
Absolutely, my lords. Absolutely. At least I can understand, my lords, for the work done, some amount you pay. Or something is there in the joint account or escrow account. Nothing. I do all the work. You enjoy the entire amount of it. And then we say that it's civil, you file a civil suit or you get your recovery. It wouldn't be a case of that nature at all, my lords. Similar to what had happened in the earlier matter,
No,
my
if-
lords, where the
If you had
petition.
appeared here.
My lords, I'd have shown some amounts which are there in the complaint itself, which is not there in this, my lords. Here, nothing is given, my lords. When nothing is given from the
Your
inception.
contract arising out of agreement between the two, the
My
NCLT
lords, the
pending.
previous order, if my
Give-
lord sees.
Give me the,
what-
give my lord's
Previous,
statement and
please,
close
please.
it.
Even there, my lords, kindly notice. This is the previous order.
Ah.
One copy. Ma'am.
On identical things, when you appear on both the sides, problem.
Same-
Even you, sir.
Same,
Oh,
same,
Lord.
same with
Right.
both of us, my lords.
Yes, yes.
Him more than we have.
My lords, in this kindly notice
No,
in the.
this is what I was asking. Monne pronouncement.
ಹೌದು ಇದರಲ್ಲಿ ತಾವು kindly, if my lords would notice,
No, this is the case of that international fraudsters.
only difference is international, here domestic. ಅಷ್ಟೇ my lords. ಇಲ್ಲಿ ತಾವು paragraph 5
ಇಲ್ಲಿ
ಅಲ್ಲಿ,
indictments were brought by the court of the United States also against this.
my lords, paragraph 5 ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ, my lords, what was the argument that was done?
No, in a given case, yes, it may result in 406 or 420 in a given case.
My lords, ಇಲ್ಲಿ,
Whether this is the one, this is the case that is to be given, we'll see.
in my respectful submission, it may come under the same category for the reason, my lords, the accounts are opened. How do you bypass the accounts and how do you take the amount directly from the vendors, from the procurement entity? Number one, my lords. Two, at least, my lords, for the work that has been done by respondent number 2, you make no payments. The dues are to the tune of about 25. This is first transaction. Second transaction, another 4 crores. So it comes to 29. Now, what they were pointing out now was second transaction, my lords. Probably, my lords, I'm on a slightly weak footing on the second transaction, but on the first transaction, in my respectful submission, it would be a case
So
for
with 25 crores, you're strong. 4
Absolutely.
crores.
4 crores, my lords, you can say that
Ah,
some, some
4 crores
element.
is too
No,
small
why-
for him. Altogether.
Why I say some element of civil liability.
No, I have dismissed identical.
Of course, I
claims.
quite see. It's not identical. I'll tell you lots as well. Please look at the statement of objections in this case.
1 minute.
I'm sorry. Statement of
Oh,
objections.
this is,
by
what is the petitioner here? Avexa.
Yes.
So this is Avi Moore. We have seen this judgment,
I have seen it.
right health.
Yes.
Ah.
Now, my lord, here,
No, the
okay,
case,
before that,
the case is not. Yes.
I'm sorry, let my friend complete, my lord. There are two, three
ಆಯ್ತು,
points.
ನೀವು ಹೇಳಿ.
Lord, please look at, there is an application filed by us for bank guarantee defreezing. In the objections to that, my learned friend's contention now is that we open an escrow account but divert money unto ourselves. That is not correct. Please see para 7. His whole case is petitioners have failed to establish an escrow account under the agreement. So therefore, it is not as if,
The case is worse off.
no, it is not. It is not.
If you have claimed that
Worse
you will open an escrow account and
Right.
amounts will come to that, you don't even open an
No,
escrow
no, no.
account.
His case is, I'm sorry, Malay, let me make it clear. His case is, you said you did open an escrow account, but instead you took money into your own pocket. That is his submission now. That is contrary to his own pleading, is my respectful submission.
I agree.
So
with
his
it.
case
I
is
agree with
that
what
escrow
my
account,
friend said, my lords. They didn't open it.
correct.
So they were
Neither of us
supposed to
did, and
open
there
it.
is a reason for that. I'm sorry, Muksi.
ಇಲ್ಲ, ಪರವಾಗಿಲ್ಲ.
Sorry.
ಹೇಳಿ.
There is a reason for that. That is mentioned in the correspondence. There's no difficulty about it. All I'm submitting is this. Today, where is it that he says there is criminality? His allegation now is, you induced me into entering into that agreement wrongly. That is his case today. Now, please see his statement of objections. He says in para 4 of the statement of objections to the main matter, he says he found out in September 2022. I asked myself this question. He says he's completed all the work and yet has not been paid. The letter of the Andhra Pradesh government speaks to the contrary, my lord, and he doesn't take any steps. I asked myself one other question. If he's a contractor, would he have completed all work without receiving a single rupee? In my experience in construction disputes, the answer is no. I can say with some confidence because I've done enough number of disputes in that area, not on the criminal side though. But my submission is this. These are cases where there are running account bills, month on month payments are made. Without that, nothing happens. So therefore, his contention that he's completed the work and has not been paid is wrong. The Andhra Pradesh government letter bears that out. Today, the only submission I want to make insofar as all this timing is concerned, in para 4 of his objections, he says that in September 22, he found out they stopped receiving payments for goods and services. Then in June, Andhra Pradesh government writes to me and says, you've done no work. June, I write to him, July, a follow-up. Then he sends me an invoice. Then he files a criminal complaint. This is the sequence of events. 1 year later, he files a criminal complaint after he says that he knows that payments are not coming. So this story today that, oh, I got induced into a false contract is, my lord, at best is something that needs to be tested in a civil proceeding. Most certainly not in a criminal proceeding.
Ashana,
Just paragraph 5 and 8 of the complaint, my lords, that may be noticed. Paragraph 5, my lords, deals with this account. My lords should have page 23.
what will police do? Recover 25 crores and give it to you?
Let's say probably it's not a recovery, my lords, per se. If they had come forward to say, no, let's settle this different, we might have even come forward under Bhajan Lal's case, I'm sorry, Gyan Singh's case and said, look, they've settled the matter. Now they don't even want to make the payments.
Any chance of settlement?
I will consider that, but all I'm submitting is I did write to him to settle it. On the contrary, he files the complaint, not me.
I think could leave.
I write to him in June and July.
Right Royal under Gyan Singh's case, at that point of time, we can say it can be settled.
Yes, sir.
I will verify, not. I'll find out what the.
Begin to talk.
Absolutely.
Don't ask yourself any question.
No, I will not. I will ask the client the question.
Yes.
Negotiations.
Because
will
if you're
start-
going on asking yourself so many questions, where is the answer?
These answers are from his documents.
My lords, negotiations will start at about 29 crores, my lords. Let us see where it
Crores weak ಆಗಿದೆ ಅಂತ
ಅಲ್ಲ,
ಹೇಳ್ಬಿಟ್ರಲ್ಲ.
then money recovery proceeding ಅಂತ ಆಯ್ತು.
recovery.
Without court fee.
ಏನಾದ್ರೂ ಸ್ವಲ್ಪ
ಅಲ್ಲ.
interest ಬರ್ಬೋದು ಅಲ್ಲಿ.
ಅಲ್ಲ.
Maybe we will talk on those lines and see, my
No,
lords.
you should look into the latest judgment.
On a lighter note, the amount of court fees that work has not paid the government can run for many.
Yes.
I'll verify.
Time for coffee.
My lords,
Every time at 4 o'clock you are about this.
Voices like this.
My lords, could I make a request? Now that we have completed the entire argument, my lords may deal with the matter itself, my lords. Whether there's an
Okay.
offensing, it looks like
That
it is.
work won't settle.
Or I don't think it's looking like any settlement is going to go forward with
No,
them.
you want to explore it. I'll answer it, no problem.
It seems.
Look into the
I
Delhi,
thi-
Delhi
from
race
what-
club.
No, from what I'm told, my lords, it's not the first case against them, my lords. He's done it to others.
No, I am aware.
This is-
That's what. Zetwork has registered so many complaints.
Against Vixa, my lords, they're probably accused in other cases. So if that
I
is,
don't
even in
think-
Telangana, they are. My lords, what they do is they participate in all these tenders, take contracts, my lords, give it to others, take the money themselves. They don't pay the person who's done the work. This has been, seems to be the modus in which,
Modus operandi.
how though?
Let's
So if
not
that
speak
is the
of
case,
modus
my lords, if I
operandi.
even sit with them, it may not get me anywhere, my lords. It
This
may
is
not get
a
me anywhere.
classic prejudice argument. I don't want to
It's
say
there
anything
even
other
in
than the
Telang-
fact that
Probably,
network is
but even in Telangana, they have cases
One
against them.
minute, prejudicing whom?
prejudicing.
With the court?
No, of course, your lordships will never get prejudiced. That I
Lords-
have supreme confidence in.
Manchavaram police station also, there they accused. So if that is going to be the case, what's the point in sitting in
Chavru police station,
I wonder if network is the complainant there also.
Telangana?
Telangana.
Telangana. ED has also proceeded against them. So if all that is there, my lords, why waste time over it? My lords may deal with the matter,
Please.
my lords. If my lords feels prima facie, it's a case for investigation, yes, my lords. But if my lords feels it's completely a commercial transaction, my lords may deal with it.
So, as the latest judgment,
Please, my lords.
Delhi Race Club.
I'll place it, Lord. I'm sorry. I could not, it's not,
Have you
been brought.
seen?
I'll place it. Yes.
My lords, in relation to owed some amount, that is a fraction of the amount, 9,11,000. 9 lakhs
Delhi
11.
Race Club defines what is breach of trust,
And
what is
criminal,
cheating.
yes,
Clear differences between the two, they
breach
don't
of trust
overlap.
and cheating. My lords, there what happened was 11 lakhs, I'm sorry, 9 lakhs 11,000 was due. That was not paid. That was given a flavor of,
You leave lakhs, put in crores.
How?
Same thing.
my lords, that was, no. There, my lords, throughout payments were done. The amount due was then 9 lakhs 11,000, my lords. Then the court went into the issue of saying, would it amount to either a breach of trust or cheating? For both, my lords, they said, entrustment is there in both. Dishonest intention prior to it comes under cheating. So that is how the segregation of breach of trust and cheating was done. And they said in that case, both wouldn't be there. At the I'll give it, my lords. I'll give it.
2248.
I'll give it.
2024
In fact, my lords,
online
we use it when
2248.
we're on the other side to show what breach of trust is and what cheating is, my lords, for that purpose.
So when you come on this side,
Side, we have to show whether at the inception, case of inception.
that side to this side, there is a problem.
Ali, I'd have pointed out, my lords, when it is a case of certain amounts not recovered, then you can fall back on Delhi Race Club, my
All
lords.
right. We'll post it on Tuesday.
Please.
Please.
Tuesday for further hearing.
Please, great,
Heard so and so, list on Tuesday for further hearing, 4 PM.
great.
Obliged, friends.
This Nandakumar sir, you should see this judgment in right health,
I'll look into
so
it.
that the case also is
Please. Lord,
in right health.
Please.
Yes.
Obliged, friends.
Delhi Race Club, my lord. I'll
Allah,
place
right
that.
health,
That is
sir.
the one.
I'll pass.
Sir, London.
91.
For petition.
Granting permission to travel abroad. Where do you want to go? Thailand?
US, you're drawing
US?
on work.
Literally, charge
Your
has been
lordship.
framed, evidence has been led.
Your lordship,
Travel ಮಾಡಕ್ಕೂ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಎವಿಡೆನ್ಸ್
Allah, he's asking for quashing.
ಕ್ವಾಶಿಂಗ್ ಇಲ್ಲ. Yes, sir, quashing ಇಲ್ಲ.
your lordship may,
Kiran, where is the itinerary, ticket, affidavit?
lordship, it's here, but if your lordship can hear the matter, your lordship can.
ಚಾರ್ಜ್
propose
ಫ್ರೇಮ್
the-
ಆದ್ಮೇಲೆ ಇಲ್ಲ ಸರ್, ಎವಿಡೆನ್ಸ್ ನಡಿಬೇಕಾದ್ರೆ I will not entertain.
No, what has
498
happened? Your lordship can look into the
Huh?
order which is passed on 12,
NDPS. Yes, sir.
12/12/23. If your lordship can pass, look into the order. These petitioners have been framed, your lordship. Please look into the page number 36 of the petition.
Yes, sir.
Page number 36, if your lordship can look into, FSL report negative ಬಂದಿದೆ, charge sheet ಅಲ್ಲಿ positive ಅಂತ ಹಾಕ್ಬಿಟ್ಟು charge sheet ಮಾಡಿದ್ದಾರೆ.
Page, FSL report ಎಲ್ಲಿದೆ?
FSL report, page number 36. That is,
Blood sample of Hanumanta, your Hanumanta.
no, Manjunath.
Petitioner
Petitioner number
Hanumanta
2.
ಇದೆ?
Petitioner number 2, your lordship.
ಇಬ್ರಿದ್ದೀರಾ?
Ibrida. Accused 1 and 2.
Now, who is wanting to go abroad?
Petitioner number 2, your lordship. And moreover, they have not complied section 50 of NDPS. Procedural lapses.
Residues of volatile poison, group of drugs were not detected in all the above stated articles. What is the charge sheet?
Charge sheet ali, annexure A, page number 18, last para. ಆರೋಪಿಗಳು ಗಾಂಜಾ ಮತ್ತು ಮಾದಕ ವಸ್ತುವನ್ನು ಸೇವನೆ ಮಾಡಿರುವುದು FSL ವರದಿಯಲ್ಲಿ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಆರೋಪಿಗಳ ವಿರುದ್ಧ ಮೇಲ್ಕಂಡ
Who has filed this final report? Get the investigating officer.
Yes, sir.
How does he play with the lives of people? Not anta baradre ಇಲ್ಲಿ yes ಅಂತ ಹಾಕಕ್ಕೆ what is this?
And that is what
We
the
will direct the
observation.
departmental inquiry to be initiated against this man.
And the-
1 minute.
Achha,
This court will permit you to travel permanently. Wait. The petitioners are before this court calling in questions so and so. This court on 12/12/2023 had passed the following order. A charge sheet comes to be filed upon an investigation by the respondent. While before filing the charge sheet, the blood samples of these petitioners were sent to the FSL. The FSL report reads as follows. ಇದಕ್ಕೆ ನಾಟ್ ಅಂತ ಒಳಗಿದೆ ಆಮೇಲೆ ನೀವು ನಾಟ್ ಮಿಸ್ ಮಾಡಬೇಡಿ. The report reads as follows. The report is indicative of the fact that the groups of narcotic drugs that are necessarily to be present for consumption of drugs were not detected in all the samples that were sent for examination. The officer in charge of the police station files a charge sheet. In the charge sheet, the reason for filing of the charge sheet inter alia reads as follows. Mark madidini. It reads that the samples that are narcotic drugs are found in the blood samples of these petitioners, and it is confirmed by the FSL report. The FSL report indicates that nothing is found. The charge sheet relies on the same FSL report and orders and observes that it is found in the FSL. Therefore, the officer in charge of the police station of Vartur Police Station shall be present before the court on Wednesday.
CW10.
CW?
10.
CW10 shall be present before the court on Wednesday at 2:30 PM.
Your Lordship,
Interim order subsisting.
I'm not available on.
Huh?
I'm not available on, like, ನಾಳೆಗೆ ಏನಾದ್ರು ಹಾಕಿದ್ರೆ
ನಾಳೆ ಆಗಲ್ಲ. ಎಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
ಹೊರಗಡೆ
ಇವ್ರು US ಗೆ ನೀವೆಲ್ಲ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
like out of session, there is some.
When are you back?
On 18th, he is having his appointment, US visa appointment on 12th.
List on 11th at, no, Wednesday ಅದೇ ಹೇಳಿದ್ದು. List on 10th at 2:30 PM.
Until 18th, I am not available, Your Lordship.
Don't worry, sir. You have no colleagues?
I have just saying.
We'll deal with it. Don't worry. Yes. You have made your submissions. We'll take note of it now. Yes, sir.
Yes.
I will direct departmental inquiry against this man. Yes.
It's listed on 11th, Your Lordship.
10th.
Reporting settlement. $230 more. Dinesha EP.
Hearing for the petitioner in this matter.
498 N.
Please, ma'am.
Parties are present.
Please, ma'am.
Learned counsel so and so undertakes to enter appearance for the respondent. Second respondent registry to print the name of so and so.
Filing application for compounding of the offense, my lords. Today,
Compounding offense.
as per annexure E, my lords, before the mediation, the matter has been settled.
Page.
Page 93, my lord. Today we are handing over 1 lakh rupees DD, my lords.
All right, conditions fulfilled. Page 94, 95, and affidavit. Yes,
Number two.
all conditions fulfilled?
Yes.
Yes.
Acceptable.
Rakshit case.
Cell number 2, no, then. 2. Offense?
376, my lord. Breach of promise to marriage.
Breach of promise to marry.
Please, my lord.
Come on, merit, sir. Not on this. No settlement in 376. Even if it is breach of promise to marry, come on, merits.
My lord.
Don't come now. Next date.
Please, my lord.
Why did you move the matter for settlement in 376?
My lord, I made this same submission yesterday morning, my lord. Breach of promise to marriage.
ಬೆಳಗ್ಗೆ 6 ಹೇಳಿದ್ರೆ ಯಾವ ಪ್ರಾಮಿಸ್ ಗೊತ್ತಾಗದೇ ಇಲ್ಲ. Yes. Yes, Jagdish. Let him come on merits. It's better to come on merits. ಎಷ್ಟು ವರ್ಷ relationship?
2017 in the 2023 years, my lord.
Then you're fully covered by judgments. Anyway, the respondents are not going to precipitate it further.
Please,
We'll
ma'am.
pass orders on Tuesday in the fresh matters list.
Please, my lord.
Yes, better to come on merits. ಹಂಗಂತ ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಕಂಡೀಷನ್ಸ್ ಏನು ಫುಲ್ಫಿಲ್ ಮಾಡಲ್ಲ ಅಂತ ಮಾಡಬೇಡಿ, ಅದೇನಿದೆ ಎಲ್ಲ ಮಾಡಿ.
The condition is that they want to part ways, my lord.
ಕೋರ್ಸ್ ನೋ, ಅದೊಂದೇ ಕಂಡೀಷನ್, ಬೇರೆ ಏನಿಲ್ವಾ?
Nothing else, my lord.
All right, yes. On Tuesday, we'll pass orders.
Please, my lord.
Maintainability pertains to KEB classification. Oh. Who is Urmila?
My lord. Respect to sanction to prosecution.
Office objections, que maintainability stands overruled. Yes, where is my order? Who is the
The complainant, my lord. Page 23, your lordship's order.
take notice.
KEB has to. Notice
We'll
has to
see.
go to
Who is the competent authority?
Managing Director KEB. Let's come. Standing to.
Where is the order declining sanction?
Lord, Annexure D, my lord.
Annexure
41, Annexure D, page 41.
B.
D, my lord.
41. The inspectorate report. What is the date of the order? 20th August. The petitioner is the complainant who had preferred a complaint on the death of husband,
Wife.
on the death of the wife and the daughter on account of electrocution. The offense that was laid was the one punishable under section 304A of the IPC. The registering of the crime had driven the respondents, our party madilva, had driven the two officers to this court in writ petition 16281 of 2024. This court had, after looking into the order of the regional of the electrical inspectorate, had permitted trial, had rejected the petition, directing further investigation to be conducted in the case at hand. In the meantime, the police, after investigation, kept the final report ready and sought sanction for prosecution of the petitioners in writ petition 16281 of 2024. The order was passed on 6th August 2024. It transpires that on 20th August 2024, sanction to prosecute these petitioners and sanction to prosecute the petitioners in writ petition 16281 of 2024 has, along with others, has been declined by the competent authority. Therefore, the complainant is again back to the doors of this court. The respondent, second respondent competent authority, who has now declined to accord sanction, shall explain as to how the very material this court found fault with and made not applicable for continuance of investigation is used to refuse sanction to the petitioners therein or the other accused who had depicted gross dereliction of duty, due to which two precious lives was lost due to electrocution. The prima facie, this court found that the act was negligent. Sanction in such case. Therefore, the second respondent shall explain as to why and how and what weighed for declining grant of sanction to prosecute these to the petitioners in writ petition so and so. List the matter on 13th in the fresh matters list. Learned additional SPP is directed to accept notice for the first respondent. Bescom yaru? Learned Counsel Sri A. Chandrachud is directed to accept notice for the second respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List on 13th in the fresh matters.
Voting settlement. Bill number 115.
My lordship, seal number 94.
ಕೂಗಿದ್ದು 115, sir. ಇಲ್ಲಾಂದ್ರೆ ಅಡ್ಜನ್ ಮಾಡಿ ಮೇಡಮ್ 20th. ಇಲ್ಲಾಂದ್ರೆ ಅಡ್ಜನ್ ಮಾಡ್ತಾರೆ 20th.
117.
420, my lords. The offences arising out of civil dispute, both complainant and respondent present.
Where? Who is the respondent's counsel?
In person he appeared, man. Matter is settled, man.
Where settled?
In civil court, my lords. Dispute is
Kodi.
annexure L may kindly see.
Page.
Page 38, man. Compromise petition filed.
The petitioners are before the end out. The petitioners are before this court calling in question so and so. The parties to the list were also before the civil court in OS 405 of 2021 and have settled the dispute by drawing up a compromise, in a compromise petition, drawing up certain terms of compromise. ಇದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ? ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬಗ್ಗೆ. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿಲ್ವಾ ಅಲ್ಲಿ?
Criminal case ಬಗ್ಗೆ ಏನಿಲ್ಲ.
The compromise, the parties have acted in terms of the compromise is what is submitted by the counsel for the petitioner. In that light, in the light of the aforesaid compromise, the parties have filed an application seeking where is the application? Illa application elli?
Here, my lords, we have not filed application. We are
Yeah.
seeking quashing. During the pendency
Without
of,
anything?
no, my lords,
File
during
an application seeking compounding, sir.
existence of interim order, my lords, now, my lords, they have filed charge sheet.
All that, I will stay that, that's not a problem, but file a compromise, compounding application in section 320 or even the BNS, SS. Otherwise, it can't be done.
Kindly have it on Monday, my lords.
Monday, Tuesday ತಗೊಂತೀನಿ ಹಾಕಿ. List on Tuesday in the fresh matters list at 2:30 PM to report compromise. The learned counsel for the petitioner submits during the subsistence of the interim order. The police have filed their final report, i.e. the charge sheet. Therefore, further proceedings shall remain stayed in the light of the compromise arrived at between the parties. Stay in the charge sheet stay ಆಗಿಲ್ಲ. Yes, so and so. Tuesday.
My lord, serial number 116, the matter has been settled, my lord.
So this
ಮ್ಯಾಟರ್ ಕರೆದಾಗ ಯಾರು ಇರಲಿಲ್ಲ.
Just, we could not hear the leave.
Huh?
We were just standing outside, where I could not hear, my lord.
Outstanding.
ಅಲ್ಲ ಹೊರಗಡೆ ನಿಂತಿದ್ದೀನಿ, I could not hear.
All right.
The parties are present, my lord.
All right, ತಗೊಳ್ಳಿ. Yes.
116, serial number.
Offense.
498.
Sir. You are for the petitioner, madam?
One
116 and 121 both.
Terms of the agreement in MFA
mediation report. ಅದೆಲ್ಲ ಹ್ಯಾಂಡ್ ರಿಟನ್ ಇದೆ. ಎಸ್, mediation report ಇಲ್ಲಿದೆ, ತಗೊಂಡ್ಕೊಳ್ಳಿ. ಎಸ್, both. Next. ನಿಮ್ದು settlement ಆ?
ಹೌದು, 118, my lord. The kindly be taken up on Monday, my lords. We are
Monday.
unable to file the
Tuesday.
affidavit for some, please,
Tuesday?
Tuesday.
All right. 118 list on Tuesday.
Please.
119?
APM.
Settlement ಆ?
Settlement for the respondent.
ಏನು offense?
498 A my lords and 370.
Yes, ಕೊಡಿ. Parties?
My lords, wife is my lords in the VC. Father and my lords, the son are here, my lords. Last
Complainant?
occasion, my lords, we had moved it.
All right, yes.
He was in Dubai, my lords. Your lordship directed that he should be present before the court. Now he is before the court, my lords.
Who was in Dubai?
The husband was in Dubai. Lordship directed, my lords, him to be present.
If you want settlement, you should be there. So
Please,
Dubai will
now,
put on
he is
settlement.
here, my lords. Now wife, my lords, because the child is not.
That's okay. That we will see.
You have filed the affidavit, my lords, of the wife.
376 ಇದೆ?
Please, my lords. Irrigation, my lords,
498.
and 376.
498 and 376. Yes. We'll close it. 376 simply added. Yes. Quote it and close it.
Grateful.
ಎಷ್ಟಿದೆ? ಎಲ್ಲಿಗೆ ಬಂದಿದ್ದೀವಿ ಈಗ? ಫಸ್ಟ್ ಓಕೆ. Yes.
Continue, 92?
For petitioner, you want. 399, 402 and 120B of IPC. Last week, the matter is listed. On the set date of incident, the petitioner was in judicial custody, I suppose.
Yes, Jagdish.
Also one such case, my lord, though, they have not recorded a call records, details and other things. That's what could have been led to investigation.
ಇಲ್ಲ 24 hours ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತೀರಾ 399 402 ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಹಿಂಗ್ ಮಾಡ್ತೀರಾ.
120B, the only issue is that he has,
ಇಲ್ಲ 120B ಹೆಂಗಾಗುತ್ತೆ? He was in judicial
no,
custody.
what he has done, my lord, he is using telephones and sending messages to other people, through other people. He is.
Where have you recorded all that? Why do you do all such things? ಮತ್ತೆ ನೋಡಿದ್ರೆ ದೃಢಪಟ್ಟಿರುತ್ತದೆ ಅಂತ ಇನ್ನೊಂದರಲ್ಲಿ ಕಾಂಟ್ರಿ ಟು FSL ಹಾಕ್ತೀರಾ.
They could have
Set your house in order.
They could have collected the call details and other things, but unfortunately not.
ಇಂಟರ್ಮಾರ್ಡರ್ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಕಸ್ಟಡಿಲಿ ಇದ್ದಾನೆ ಸ್ವಾಮಿ. ಈಸ್ ಎ ಕನ್ವಿಕ್ಟೆಡ್ ಪ್ರಿಸನರ್. ಪ್ರೊಡ್ಯೂಸ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್.
ಬೇರೆ ಅದ್ರಲ್ಲಿ ಕಸ್ಟಡಿಲಿ ಇದ್ದಾರೆ.
ಹೌದು.
ಇದೇನು ಇದು ಕಾಸ್ಟ್ ಮಾಡಿದ ತಕ್ಷಣ ಆಚೆ ಏನ್ ಬರಲ್ಲ ನೀವು?
ಈಗ ಪ್ರೀಮೆಚೂರ್ ಇದ್ದಾನೆ ಸ್ವಾಮಿ. 11 years 5 months.
ಅದು 14 years ಆಗ್ಬೇಕು.
ಅಲ್ಲ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ರೆಮಿಷನ್ ಇಟ್ ಇಸ್ 11 now it is 12
ಇನ್ಕ್ಲೂಡಿಂಗ್
years.
ರೆಮಿಷನ್ 12 years ಆದ್ರೆ 302.
302.
Then 14 years ಆಗ್ಲೇಬೇಕು. ಇನ್ಕ್ಲೂಡಿಂಗ್ ರೆಮಿಷನ್ ಯು ನಾಟ್ ಯೆಟ್ ರೀಚ್ ದಟ್. ಕಾಸ್ಟ್ ಮಾಡಿದ ತಕ್ಷಣ ಆಚೆ ಬರ್ತೀರಾ? ಯು ಟೆಲಿಂಗ್ ಆಸ್ ಟು ಇಸ್ ಇನ್ ಕಸ್ಟಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿ now they issued proclamation, even they are not producing from the JC
That
to
will
him.
produce. That is the case, will produce him.
What is the next date?
ಅವ್ನು ಪ್ರೊಡ್ಯೂಸೇ ಮಾಡ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಪ್ರೊಕ್ಲಮೇಶನ್.
The learned counsel for the petitioner submits that an order of proclamation is issued against the petitioner who is in judicial custody. And the learned additional SPP would submit that on the next date, the petitioner would be produced. Online alva, virtually produced ashatan. The petitioner would be produced in accordance with law. We'll list it on some other day and close it. Yes. This court had passed the following order on 28/8/2024 had passed the following order. The learned additional SPP on verification of the records would submit that though there is ample evidence against the petitioner, but the call record details of his presence at a particular place on the relevant date is not made. In that light, there shall be an interim order of stay of further proceedings in CC another? In the impugned CC and
31915.
in the impugned CC, yes.
He is in custody.
Huh?
Anyway, is in custody. Then
Anyway, is in custody.
ಸ್ವಾಮಿ ಏನಂದ್ರೆ ದಿಸ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅದು ಪ್ರೀಮೆಚೂರ್ ಆಗ್ಲಿ ಅದಕ್ಕಾಗ್ಲಿ
ಅದಕ್ಕಿನ್ನೂ 2 ವರ್ಷ ಬೇಕು ಸರ್. ಈವನ್ ಕನ್ಸಿಡರೇಷನ್ಗೂ ಇಟ್ ಇಸ್ ಸ್ಟಿಲ್ ಪ್ರಿಮೆಚೂರ್.
ಪೆರೋಲ್ಗೆ ಅಪ್ಲೈ ಮಾಡಿದ್ರು ಕೊಡ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಆ ಒಂದು ರೀಸನ್
ರೋಲ್ಗೆ ಅಪ್ಲೈ ಮಾಡಿ ಸರ್, ಕೊಡ್ತಾರೆ. ಯಾರು ಕೊಡಲ್ಲ?
ಓಕೆ ಮಚ್ ಆಫ್
history.
Huh?
He has many history. That's why.
ಆಯ್ತು, ನೀವು ಮಾಡಿರೋದು ಮಿಸ್ಟ್ರಿ, ಏನಿಲ್ವೇ ಇಲ್ಲ. ಎಸ್,
Only against this petitioner.
acquit the petitioner only. Next.
93.
Petition. Bring for respondent number 2, my lord.
Huh?
Trespass case brought against the president secretary of the society.
My lord, there are 2 groups, my lord. There was a group A and group B since 2008, my lord. Some of the institutions were falling under the group A, that is the petitioner. And some institutions were falling under category B, my lord. And the exclusive possession was with the complainant, my lord, that is respondent number 2. And once the husband of the respondent number 2 was convicted, immediately they barged into the premises with rowdy elements. Therefore, 448 is there because
Dispute among brothers.
ಅದೇ ಗೊತ್ತಾಯ್ತು. ಯಾಕೆ ಇದು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇದ್ರೆ?
But in the civil proceedings, in fact, a mediator was appointed, but we tried, but they are not in a position to.
ಚೇ ಮಾಡಿದೀವಲ್ಲ.
But because there were some elections and this thing are forthcoming.
Elections.
Some
What
are to
elections?
medical this thing. Right? And passport also, Murad, because of this, I got renewed only
We'll
for.
post it in fresh matters and close it
Very.
on Wednesday. List the matter on Wednesday in the fresh matters list.
94.
94. 94 Maharashtra.
ಏನ್ ಸೆಟಲ್ಡಾ?
ಇಲ್ಲ, ಇನ್ನೂ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಮೀಡಿಯಾ 3 weeks ಟೈಮ್ ಇಟ್ ಮೇ ಬಿ ಸೆಟ್ಲ್ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ. 3 weeks ಮೇ ಬಿ ಇಂಟ್ರಿ ಮಾಡರ್ ಮೇ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಪ್ಲೀಸ್.
ಅವ್ರು ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಬಂದಿಲ್ಲ ಸರ್, ಅದಕ್ಕೋಸ್ಕರ.
ಅವ್ರು ಯಾರು?
ಯಾರು ಸರ್?
ಐ ಆಮ್ ಫಾರ್ ದಿ ಪಿಟಿಷನರ್.
ಇವ್ರು ನಮ್ಮ ತಂದೆಯವರು ಸರ್.
ಸರ್, ಇಲ್ಲಿ ಈ ಅಡ್ವೊಕೇಟ್ ಯಾರು? ಸ್ಕ್ರೀನ್ ಅಲ್ಲಿ ನೋಡಿ ಸರ್, ಅಲ್ಲಿ
ಐ ಆಮ್ ಫಾರ್ ದಿ ಪಿಟಿಷನರ್.
ಓಕೆ ಓಕೆ.
ಓಕೆ ಸರಿ, ನೀವು ಅಲ್ಲಿ ನಿಂತ್ಕೊಳ್ಳಿ, ಅವ್ರು ಹೇಳ್ತಾರೆ. ನಿಮ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪಿಟಿಷನರ್ ಇವರು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್.
ಆ ಕಡೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್. ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಐ ಆಮ್ ಫಾರ್ ದಿ ಪಿಟಿಷನರ್ ಯುವರ್ ಆನರ್.
ನಿಮ್ಮ ವಕೀಲರಲ್ಲಿ
ಸರ್ ಅವರು ಈಸ್ ಇನ್ ಸಿಕ್ ಸರ್, ಅವ್ರಿಗೆ ಹುಷಾರಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು.
ಈಸ್ ಇನ್ ಸಿಕ್ ಸರ್.
ಅಡ್ವೊಕೇಟ್ ನಾಟ್ ಕೀಪಿಂಗ್ ವೆಲ್.
ಆಲ್ ರೈಟ್, ಎಸ್. ಯಾವತ್ತು ಬೇಕು? ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸರ್. ಸೊ ಯು ಆರ್ ನಾಟ್ ರೆಡಿ ಟು ಕಾಂಪ್ರಮೈಸ್.
ಇರ್ಲಿ, ವೇಟ್.
ಅಲ್ಲ ಐ ಆಮ್ ನಾಟ್ ಕಮ್ ಟು ದ ಕನ್ಕ್ಲೂಷನ್.
ಇಲ್ವಾ
ಸರ್? ಇವತ್ತು ಬಂದಿಲ್ಲ ಸರ್.
ಅಷ್ಟೇ ತಾನೆ? ಹಂಗಂತ ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ, ಇರಿ. ಎಸ್, ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 13th. The respondents have appeared in person in the light of the fact that the council representing them is indisposed today. The respondents should submit that the talks of settlement have failed, which is disputed by the council for the petitioner. List the matter on 13th.
One submission, sorry to please. Matter is 26th and fix the date for once again you are sitting together the both the parties. 26 ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವರು ಒಪ್ಪಿದ್ದಾರೆ. So 26th ಆದ್ಮೇಲೆ ನನಗೆ
14th October.
Please, please. Maybe chances are not will find it. Please.
Maybe
entry matter.
Entry matter continues till the next date.
Much obliged.
ಸರ್ ನಂದೊಂದು
95.
ಹೊರಡಿ ಅವತ್ತು 14ಕ್ಕೆ ನೋಡೋಣ. ಎಸ್,
ನಾನು ಕೊಟ್ಟದ್ದು ಸಿಂಕ್ರೆ ಅಕೌಂಟ್ ಮೇಲೆ ಕೇಸ.
ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಕೇಳಬೇಕು, ಅವ್ರು ಇರ್ಬೇಕಾದ್ರೆ ನೀವು ಮಾಡ್ಬೇಕು. 14ಕ್ಕೆ ಬನ್ನಿ.
95.
mainly out on 10th, my lord.
Who is senior counsel waiting? Nagesh sir.
4 o'clock, your lord.
Which matter?
Seal number 80.
80. Oh, that enforcement directorate. I'll take it, sir. 5 minutes. Yes. Madhukar Deshpande serve madidra? Is there. Yes. Yes.
That's my request. Mainly out on 10th, my lord.
10th. ಯಾವ್ದು serial number?
95.
ಅವಾಗಲೇ ಕೇಳಿದ್ರ?
Respondent number 2 in this.
Objection?
Objections active, sir. Next date.
ಹಾಕ್ಬೇಕಾ?
Yes.
The learned counsel appearing for the respondent seeks 2 weeks time, Saka. 2 weeks time to file statement of objections. Interim order subsisting shall
There is no
continue till
entry
the.
order. Entry order ಇಲ್ಲ sir.
ಇಲ್ವಾ?
ಇಲ್ಲ sir.
ಇದೆಯಲ್ಲ?
No, madam. No, madam. Yes.
ಇದು ಅದನ್ನ madam.
Liberty was granted. No, no.
Interim order ಇದೆ. Interim order subsisting shall continue till the next date of hearing. What sir? ನೋಡೋದೇ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಕೊಡ್ಬೇಕಾದ್ರೆ ನೀವು ಇರಲ್ವಲ್ಲ.
No, madam. I will
Yes.
verify the records. madam.
What very, ಅದು ಡೌಟಾ? ನೋಡಿ.
So list ಆಗಿರೋದು stay
ಅಲ್ಲ, interim
application.
order ಇರೋದೇ doubt
Plus
petitioner.
list ಅಲ್ಲಿ stay application will be filed ಅಂತ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
If the petitioner himself is doubting interim order, what can be done? I am telling interim order is there. Yes. ನೋಡ್ಬಿಡಿ ಒಂದ್ಸರಿ.
96.
Lords, I beg to appear for the petitioner.
For the respondent.
Challenge, my lords, is to a private complaint lodged by the respondent herein, alleging an offence under section 500 IPC read with 120B.
You're for the petitioner, sir?
I'm for the petition.
Yes.
The genesis of this dispute is a notice that, my lords, the petitioners had issued at page 83, alleging, my lords, an act of trespass on the part of the respondent, and the respondent having made, my lords, serious allegations which were casteist and personal in nature. Now, there was a settlement between the parties thereafter, basis which this notice was agreed to be withdrawn.
One clarification, sir. The
Lordships,
private complaint is registered
please.
and the matter is referred to investigation. Is that so? The matter is referred to investigation?
No.
Yes. Not referred?
Lords.
Please see the order, my lords.
Was a
1 minute, sir.
Very good. Page 49.
Cognizance is
summons are
taken.
issued.
Yes, sir.
Now, my lords,
It's not
this
referred.
legal notice
Yes.
at page 83, I had caused to be issued to the respondent. If your lordships come to para 9 of that notice, page 85, your lordships would see that certain allegations were made. I'm troubled to say that petitioners are Kannadigas, etc. Now, these, in any case, this dispute between the parties was resolved by a settlement agreement, which is, my lords, at page 162. As per this settlement of 18/6/2020, parties undertook not to make any disparaging statements against one another, clause 2, not to trespass, clause 4A,
All right.
to withdraw complaints, and importantly, my lords, just mark J at
Clause
16.
J at page 164.
Yes, my lords.
Mm.
Clause J, I'm so grateful.
Yes.
Pursuant to this clause, I have written to the respondent's employer, withdrawing my notice. He makes this notice of mine the basis of a complaint for defamation 3 years later in 2023, suppressing this settlement agreement and suppressing the fact that I have withdrawn the notice, my lords, by having written to his employer, Microsoft. Please come to the PCR. It's a gross case of, my lords, vexatious proceedings. Para 11.
Page.
Complaint begins, my lords, at page 55. Please note, filed in 2023, that is 3 years after the settlement. Please come to para 11 at page 59. The accused, with the intention of causing injury to the reputation of the complainant, issued a legal notice dated 9/6/2020, to the complainant, his wife, and also to the employer based on false allegations, etc. Since the complainant is aggrieved by the legal notice in its entirety, specific contents of the notice are not extracted herein. The allegations made in the said notice are entirely false and were not made in good faith, etc. However, the notice was also issued to the employer with a malified intention of causing disrepute. Now he withholds the settlement. And the other allegation he makes to make good defamation, curiously, my lords, is at page 19. I had also brought a criminal case against him under, my lords, the SC/ST Atrocities Act. That came to be closed. Ultimately, a B report was filed saying there was insufficient evidence. While that complaint was pending, there was an article carried in the Prajavani, my lords, by Prajavani itself that there is such and such case pending. He makes that article. I am not the author of that article. I am not quoted in that article. These are the two allegations, my lords, premised which an offense under 500, my lords, is alleged. And the gentleman is a trigger-happy litigant. He has filed a suit. That suit, my lords, is pending. I must tell your lordships, in that suit, he annexes a photograph of himself with the Honorable Governor.
I saw that, yes.
And and then he receives a ticking off from the secretary to the governor. That document also is on the record saying, please, you have no right to use photographs of the governor, withdraw it. So this, my lords, with great respect, is some settling of scores by somebody who has gone to the extent of making allegations basis my caste, my being Kannadiga, etc. Of course, that water has flowed. But now this PCR comes 3 years after.
Yes, sir.
May I submit a list of dates?
Hmm.
The
No,
events,
you answer one question.
please notes,
The settlement agreement happens on 6/9/2020,
please notes.
correct?
Please notes,
The complaint is registered on 6/7/2023.
please notes.
What happens in the interregnum?
But what happens is, after this settlement agreement, I file one more police complaint because they continue troubling me. I file
Troubling you is a different thing.
But
Defamatory, what
But-
happened?
I file a civil suit. In response to that civil suit, in July of 2021, a complaint is filed against me under the Atrocities Act. FIR is registered against me.
So Atrocities Act, if crime is registered, they will
And
conduct investigation. I think
lots-
B report is filed.
B report is filed, B report is contested, and B report is accepted by the court.
Contested and accepted.
Please note,
Then
that
you're-
is the basis of my defamation action.
Ah.
Lords, under the 8th exception to section 499,
Hmm.
if a complaint is not made in good faith,
Hmm.
it amounts to defamation. That, my lords, is my principal case. If your lordship. will
All
please-
right. Now, what have you made the contents of the complaint on 6/7/2023?
Please.
What is the cause of action for the complaint according to
Principal cause of action, according to me, my lords, is the false FIR lodged against me.
why do you state about the settlement agreement?
Lords, in my respectful submission, my lords, that incident, the FIR is a subsequent incident.
You have registered a complaint on 6/7/2023.
Please, my lords,
You have narrated about the false FIR so registered against you in this.
please, my lords, I have.
Where?
Lords, para 17, your lordship may please see. notes. Para 17 at page 60.
All right. Then why do you say about para 11 that you had sent a notice, etc.?
In the course of narration, it is mentioned, but the thrust of my case is para 17.
So if this was the content of the complaint, now cognizance is taken for 500.
Please, my lords,
500 for what? Registering a false case according to you or para 11?
for registering a false case. My lords, will your lordship please see through the list of dates, what happens, in what circumstances they file a false complaint against me. It is so utterly false. And my lords, the allegation, I first file a complaint before the police saying they are threatening me, that you are outsiders. It is thereafter that as a counter blast, they say in the legal notice that they issue that they are making allegations against Kannadigas. Therefore, my lords, the entire sequence of events is a dispute between two neighbors is, in respect of a fence, my lords, is deliberately taken to such an extent that my lords, an FIR is made against me. In the community, it is mentioned against me, and I have pleaded all of it, that I am a person who does not respect people belonging to different communities, different regions. The same allegations are made in the complaint. Your lordship, I kindly see, my lords, for a moment, the sequence of events.
ಕೊಡಿ.
The first complaint, my lords, on 6/4/2020 is a complaint filed by me. It is in this that I say that I am being discriminated against, saying I am an outsider. It is as a counter blast to this that all these allegations are made in the notice that the learned senior read out, which is in June of 2020, after I have made these allegations. Then, my lords, on 9/6, then your lordship may please see 4. 9/6/2020, that is the legal notice. On 18/6, a settlement agreement is entered into, and that notice comes to be withdrawn subsequently. Thereafter, my lords, on 29/3/2021, serial number 7, I submit a further police complaint. In that I say that they are threatening to file a false case against me, please protect me. Then I file, at serial number 10, I file a civil suit against them. Serial number 11, on 7/8/2021, they enter appearance in the suit. On 2 days thereafter, they file a false complaint against me, saying for the last 1.5 years, I have been saying all sorts of nasty things against them. Ex facie, my lords, if your lordship will please see that complaint, there's nothing in that complaint which even indicates 1 ounce of truth. They say for the last 1.5 years, that is going back to a time prior to the settlement agreement, I have been saying all sorts of things against them.
All right, we'll see. We'll continue on Tuesday.
Please.
Let's heard the learned senior counsel Shri Aditya Sondi appearing for the petitioners and the counsel Manu Kulkarni representing the respondent. That's the matter in the fresh matters list on Tuesday.
Lord, interim order.
Tuesday.
Interim order to kindly continue.
That Tuesday is all right?
Could it be, Lords, the week after next, Lords, if that's convenient to your lordships?
Then we'll take it on 18th.
Please.
List on 18th in the fresh matters list.
Great.
Interim order subsisting shall continue till the next date.
Grateful.
Yes. Sir, pass over. Madhukar Deshpande.
Pastor, still number 80.
Serial number 97.
looks
Linked
good.
with the other case.
ಅಲ್ಲ
Seeking an adjournment, 97.
ಎಲ್ಲ ಅಡ್ಜನ್ ಮಾಡ್ತೀನಿ. ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ. ಏನ್ ಮಾಡ್ಬೇಕು? ಲಿಂಕ್ ಆಯ್ತು, ನಂಬರ್ಸ್ ಕೊಡಿ, ಯಾವ ಕೇಸಿಗೆ ಲಿಂಕ್ ಆಗ್ಬೇಕದು.
ನೋಡ್ಬೇಕಲ್ಲ ನೀವೆಲ್ಲ.
No interim order, will post it next week, Tuesday or Wednesday. Tuesday or Wednesday, in the fresh matters.
A lot of humble submission, madam.
Fresh matters ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ.
A lot of humble submission, madam.
Interim orders ಯಾವುದಿಲ್ಲ, 18th fresh matters ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ.
A lot of humble submission, madam.
Yes,
Lord,
Mayur.
My lord, serial number 114 may be connected with 78 and 79, madam.
All of you just wait one moment, I'll just finish, sir, ನೀವು ಮಾಡಿ.
Oblige.
ಇಲ್ಲ, this will go on till sometime. Yes. ಅಲ್ಲಿವ ಮೇಡಮ್, ಒಂದ್ ನಿಮಿಷ wait, ಮುಗಿಸ್ತೇನೆ.
ಇದರಲ್ಲಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡ್ CBI ಅಂತ ಮಾಡಿದ್ದಾರೆ, ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ED ಸಮನ್ಸ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ therefore I may be permitted to delete second respondent.
Council.
ನಾನು ಈಗ ನೋಡಿದೆ.
The council on record files a memo seeking deletion of the second respondent CBI.
Why they made
from the
CBI as
array
a
of
party means
parties.
predicate offense ಅದರಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಅಷ್ಟೇ.
Array of parties. Now, Madhukar, yes, the senior counsel submits that the wife and the child cannot be asked to come to give evidence at the place that you are.
Yes. My lord, there must be reference to section 160 of the old CRPC. My lord.
Yes.
My lord, 160 is with respect of an investigation as defined under the CRPC, my lord.
All right.
Whereas if section 50, the summons is issued under section 50, para 467.
So CRPC is not
150,
applicable at all?
Para 467, my lord. Para 15 of the Vijay Madan
Lal Chaudhary.
Yes, my lord. Investigation, what is the investigation under CRPC? What is the investigation under PMLA has been explained in that. So that particular investigation, what is contemplated under the CRPC is different. The investigation contemplated as explained.
Why do you want to, ಎಲ್ಲಿ ಬಾಂಬೆ ಕರೆದಿರೋದ ಎಲ್ಲಿ?
Nagpur, my lord. The
Maharashtra.
situs is also the one issue, my lord. The jurisdiction is based only on the situs of the person or the authority, my lord. The ECIR was registered in Maharashtra, my lord.
So nothing has happened here.
Nothing.
Except the residence
Yes,
of the petition.
That is Saka Venkat Subbarao, my lord, 1953.
Yes, sir.
That is squarely settled in a pronouncement of the Honorable Court
What is-
in the Twitter case. Good. In the Manish Maheshwari's case, there is a Twitter, my lord, a crime came to be registered in Uttar Pradesh.
Oh, this is Facebook or Twitter, right?
Notice under 160 and notice under 41A. But what a coordinate bench of this Honorable Court would say, your lordship would get it.
Twitter.
Yes, para 49.
That must be challenged before division bench ಅಲ್ವಾ?
Supreme Court, my lord, they did.
Supreme Court confirmed this?
ಹಾಕಿದ್ರು ಅಷ್ಟು ಬಿಟ್ಬಿಟ್ರು ಅಷ್ಟೇ 3 years ಅಂತ ಹಾಗೆ ಬಿದ್ದಿದೆ ಅಷ್ಟೇ. I have that order passed by the Supreme Court also.
Yes, sir.
With
Probably
respect
this
of
this
ECIR,
covers the issue.
with respect of ECIR, my lord, this honorable court, my lord, regarding
What
the
is it?
situs.
We'll see.
Yes, ma'am. Sir.
We'll decide the issue. Defer the interrogation for some time now.
Well, I'm ready to cooperate. Let them come to me, record my statement or on online or WhatsApp, whatever may be the communication. I am there. I am a woman.
That
I'm in
was
Bangalore.
one of the challenge in the Vijay Madan Lal Chaudhary, my lord.
We'll
And
see.
section 50.
We'll answer that.
Yes, ma'am.
Vijay Madan Lal Chaudhary does not answer
the
160 and
learned senior
65 of the PMLA.
Leonard Senior, Vijay Manlal Chaudhary is on PMLA, sir.
Alala, section 65,
That we'll see.
160.
Yes.
Well, his lordship has
learned,
answered, Justice Narendra has answered this in this very case itself.
The learned,
160, 41A, everything is answered here.
heard the learned senior counsel, C.V. Nagesh, appearing for the petitioner and Madhukar Deshpande representing the respondent. The issue is issuance of a notice under section 50.
Section 50, my lord.
Section 50 of the Prevention of Money Laundering Act 2002. The learned senior counsel would submit that in terms of section 160 of the CRPC, a woman,
Yes,
Woman,
a woman cannot be called for investigation to a place beyond the place of residence. The learned senior counsel places reliance upon the judgment of the coordinate bench in writ petition 11028 of 2021. The 2021, which interprets both section 160 and 41A of the CRPC. The learned counsel Madhukar Deshpande, representing the respondent enforcement directorate, who has now issued a notice directing, who now issued summons directing the presence of the petitioner, relies on a judgment in writ petition 2576 of 2023 and also the judgment of the apex court in the case of Vijay Madan Lal Chaudhary, 2022 SSC Online SC page 929, with particular reference to paragraph 467.
Yes.
The conclusions that are drawn by the apex court. The matter would require consideration. Therefore, till the next date of hearing, the summons shall be deferred.
please.
List on next Thursday, Hakim, madam, 12th. 12th in the fresh matters list.
Yes.
Yes.
Much.
We'll decide it.
Yes.
Yes.
Well, I may be permitted to delete R2.
ಯಾವ್ದು sir?
R2, I may be permitted to delete.
I passed the order already.
Can see.
ಈಗಲೇ delete ಮಾಡಿ.
ಅಲ್ಲ, ಅವಶ್ಯಕತೆ ಇಲ್ದವ್ರು.
My lord, 12th, I have some inconvenience, my lord.
ಯಾವತ್ತು?
Before
13th
Kalburgi.
ಹಾಕಿನಾ?
Yes, ma'am.
13th. Yes. 13th fresh matters list. Yes. ಕರೆದ್ಬಿಡಿ ಬಸ್.
15th.
Kindly have this matter tomorrow, my lord.
Settlement.
No, my lord.
ಮತ್ತೆ?
Arguments. Accounts has to be
Oh.
deep first.
Oh, that might, Nayantara,
Yes, my lord.
ಇಲ್ಲಲ್ಲ. List on next
That
week.
tomorrow, my lord.
20th.
20th.
List on 20th. ನಿಮ್ಮ ಅಕೌಂಟೇ ಫ್ರೀಸ್ ಆಗಿರೋದು. List on 18th.
Because there is some medical emergency in family.
18th,
An
18th.
entire family,
ಸರಿ ಯಾವಾಗ ಬೇಕು ಸರ್?
tomorrow, my lord.
Tomorrow impossible now, list close ಆಗೋಗಿರೋ. Yes.
Or day after tomorrow, my lord.
Day after tomorrow? Holiday. Yes. 18th, next.
Can have this matter tomorrow, my lord.
60,
16, fake guarantee, madam.
60,
16.
16. ಏನ್ ಮೇಡಮ್ ಇದು ಫೇಕ್ ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಇದು?
Yes, my lord.
ಎಲ್ಲಿ ಮೇಡಮ್?
Just left, my lord.
ಆಲ್ ರೈಟ್, ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್, ಯಾವತ್ತು ಬೇಕಂತ ಮೇಡಮ್?
Tuesday, madam.
ಟ್ಯೂಸ್ಡೇ 13 ಅಂತ ಹೇಳಿ. 13th.
Please.
Yes, list on 13th.
I appear for the petition of this
Yes.
matter.
Interim
Case
on
seven.
hearing. Yes, 307, accused number 7, 307, there is nothing.
He is
Judges.
no-
All right, list
he
on
is no
20,
assailant, your lordship. He
list
was
on
not-
20th. In the fresh matters list, a perusal at the investigation papers or the investigation material or the complaint or the summary of the charge sheet would not indicate any overt act by the petitioner which would become an offence under section 307 of the IPC. Therefore, till the next date of hearing, there shall be an interim order of stay of further proceedings where the petitioner accused number 7 only on the score that there are no allegations or overt acts that would become an offence under section 307. Based on 26th September. Yes. Next.
24.
ನಾರಾಯಣ ಸ್ವಾಮಿ, ಎಲ್ಲಿದ್ರಿ ನೀವು ಆವಾಗ್ಲೇ?
ಕೇವೆಟ್ ಫೈಲ್ ಮಾಡೋಣ ಅಂತ ಕೌಂಟರ್
ಕೇವೇಟ್ ಫೈಲ್ ಮಾಡಕ್ ಹೋದ್ರೆ ಪಿಟಿಷನ್ನೇ ಹೋಗ್ಬಿಡುತ್ತೆ.
ಸಾರಿ.
ಹಾ, ಎಸ್. ಏನಾಗ್ಬೇಕು?
ಪೊಲೀಸವರು ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹತ್ರ ಬನ್ನಿ ಅಂತ.
ಹೋಗಿ.
ಎಫ್ ಸ್ವಾಮಿ
ಹೋಗಿ
ಅಲ್ಲ, 2 ರಿಟ್ ಪಿಟಿಷನ್ ಇಲ್ಲೇ ಫೈಲ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ
ಹೇಳಿ ಬನ್ನಿ ಅದನ್ನೇ ಪೊಲೀಸ್ಗೆ. ಭಯನ?
ಅವ್ರು ಆಫೀಸ್ ಹತ್ರನು ಬಂದು ಬಾರೋರ್ ಆಫೀಸ್ ಹತ್ರ ಕೂಡ ಬಂದು ಗಲಾಟೆ ಮಾಡ್ತಿದ್ದಾರೆ.
ಗಲಾಟೆ ಮಾಡಿದ್ರ?
ಹೌದು ಸರ್.
Why you have generated fear? Bank officials.
ಜಾಸ್ತಿ ಫೇರ್ ಮಾಡಿ.
2022 ಅಲ್ಲಿ ಇದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ತಾ ಕೂತಾರೆ. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದಿಲ್ಲ. ಮಾರ್ಚ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ. ಅಗೇನ್ ಸೇಲ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಸೇಲ್ ನೋಟಿಸ್.
ಈಗ ಯಾವ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ನಿಮ್ಗೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದಾರೆ?
ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ, ಏನಿಲ್ಲ ಸ್ವಾಮಿ.
ಸುಮ್ನೆ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ. ಅನೆಕ್ಷರ್ ಎಫ್ ಪೇಜ್ ನಂಬರ್ 35.
ಹೌದು, ನನ್ನ ಆರ್ಡರ್ ಇದೆ ಅಲ್ಲಿ.
ಅದು 36 ಇಂದ ಸ್ವಾಮಿ.
ಹಾ.
ಬೇರೆ ಇನ್ನು ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದು.
ಮಿಸ್ಡ್ ಕಾಲ್ ಇನ್ಕಮಿಂಗ್ ವಾಟ್ಸ್ಆಪ್ ಕಾಲ್ ಮಾಡಿದ್ದೀರಾ? ಹಾ. ವೈ ಸರ್? These days you are all calling only on WhatsApp. Record encrypted ಅಂತನಾ?
ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಳ್ತಾರೆ.
Yes. The learned additional SPP is directed to accept notice for the respondent. All the respondents.
ಹೌದು.
The learned counsel appearing for the petitioner Narayan Swamy submits that without registering a crime, the police are continuously calling the petitioner on WhatsApp and directing him to come to the police station. For what purpose is not indicated. Therefore, the learned additional SPP to secure instructions as to why the officials of the bank are being harassed by repeated calls through WhatsApp. Till the instructions or information is sought, the respondents shall not harass the petitioner or unnecessarily call without registering a crime. Yes. Next.
Tuesday,
ಚಾಲ ಬೇಕಾಗಿದೆಯಾ?
Tuesday, Wednesday.
Wednesday ಬೇಕು. Wednesday at 2:30 PM. ಪೊಲೀಸಿಗೆ ಲೋನ್ ಬೇಕಾದ್ರೆ ಫೋನ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ. ಅದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಯಾಕೆ ಕರಿಬೇಕು? ಎಸ್. ರನ್ ಥ್ರೂ ದ ಲಿಸ್ಟ್ ಮಾಡಿ. ಎಲ್ಲಿವರೆಗೆ ಬಂದಿದೆ?
97.
ಇಂಟರಿಮ್ ಆರ್ಡರ್ಸ್ ಇದ್ರೆ ವಿಲ್ ಎಕ್ಸ್ಟೆಂಡ್ ಇಟ್. 97 Dilraj. Wherever interim orders are there, they will stand extended And the matters will be after 2 weeks, where interim orders are not there, we fix a date. Interim order ಇಲ್ವಾ? ಇಲ್ಲದೆ ಇರೋದು fix a date. ಹ? 98 ಏನದು? ಹ? 420? 98.5 ಎಲ್ಲ ಸರ್ವ್ ಆಗಿದೆ. ಯಾರು ಅಡ್ವೊಕೇಟ್ ಇದಾರ? ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದಾ? 98 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. ಆನ್ ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. 100 ವೈಶಾಲಿ ಹೆಗ್ಡೆ ಮೇಡಮ್. ಇಂಟ್ರಿ ಮಾಡಿದ್ರೆ 2 weeks ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬಿಡಿ.
This matter got it.
ಓ 100 ಆಯ್ತಲ್ಲ.
ಆಯ್ತು, kindly have done next week, my lords. ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ ಈಸ್ ಫೈಲಿಂಗ್ ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್ಸ್.
ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಸರ್, ನಿನ್ನೆ ಮೀಡಿಯೇಷನ್.
ವಾಟ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ?
ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ಸ್ ಮೇಲೆ
ಕೊಡಿ, ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ.
is IAS officer is working in Gulbarga. He is registering false FIRs in Gulbarga. ಇಲ್ಲಿ ಯಾರು?
ಗುಲ್ಬರ್ಗ ಅಲ್ಲ?
ಗುಲ್ಬರ್ಗ.
Why in Gulbarga?
ಅದು second notice, police notice.
27/2/24.
ಅದರಲ್ಲಿ
ಸೆಟಲ್ಮೆಂಟ್
ಸೆಟಲ್ಮೆಂಟ್ false submission made before this honorable court.
ಲಿಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಹಾಕಿ ಮೇಡಮ್.
Please.
ಲಿಸ್ಟ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಬೇಡ 15/10 ಬೇಡ. ಲಿಸ್ಟ್ ಆನ್ 13/9. Yes.
Please. Copies.
Next. Accused number 101. Serial number 101. Wednesday, fresh matters. Interim order illa and.
Serial number 103, madam.
18th fresh matters. Yes.
Serial number
Scene number 103 for respondent, my lords.
ಮೇಡಮ್ ಅದು ಕರೆಯೋದು ಬೇಡ. ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಇದೆ ಅದು 2 weeks ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಇಲ್ಲದೆ ಇರೋದೆಲ್ಲ 18th ಹಾಕಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Submission.
ಫೋರೆನ್ಸಿಕ್ ಸೈಕಾಟ್ರಿ ರಿಪೋರ್ಟ್.
That, my lord, the report is come already is fit to face trial.
What, he can stand trial?
Can stand trial.
ಆ ರಿಪೋರ್ಟ್ ಕೊಡಿ ಹಾಗಾದ್ರೆ. ಇದು ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿ ಮೇಡಮ್.
My lord, serial number 103, my lords.
Keep the report. I'll take it on Tuesday.
Serial number 113, my lord.
ರಿಪೋರ್ಟ್ ಇದೆಯಾ? ಹಂಗಾರೆ ಇಲ್ಲೇ ಇಡಿ. 1 minute. Fit to stand trial. Who appears for the petitioner here? M. Shashidhar. Sir. You can stand trial.
I'm not seeking to stop the trial. Can you direct the jail that they provide treatment if need arises? Earlier to that, I've been taking treatment from last 6
No problem.
years.
Well, then we'll close it on Monday.
Yes.
List on Tuesday in the fresh matters.
Jail that they provide treatment.
Tuesday in the fresh matters. Yes. I wanted a report from Nimans, that's all. Whether you can stand trial or not. Yes, next.
113, my lord.
ಬೇರೆ ಎಲ್ಲ ಏನ್ ಮೇಡಮ್?
Number 112, my lord, here for respondent number 3. There's an interim order that's operating against us. They've also defreezed the bank account behind our back.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
Oh, half it, it's not been put up, my lord. 2nd of August, we filed it.
1 minute.
May I request for it?
2024, list the matter on Thursday, the next, in the caption, interlocutory applications, putting up the application seeking vacation of the interim order said to have been filed by the respondent. Yes.
103, madam.
Vacating stay ಇನ್ಯಾರು ಹಾಕಿದ್ದೀರಾ?
103.
ನೀವಲ್ಲ ಮೇಡಮ್, ಆಯ್ತು. ಎಸ್
103, madam.
ಏನು?
Entry model, any date fix.
ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕಾ?
ಇಲ್ಲ entry model.
ಇಲ್ವಾ? 18th.
Call for LCR.
110, my lord, on submission, my lord. 113, he is going to lose his job opportunity on the passport sigta illa because of pendency of this case. EC Act covered matter, my lord. 113, maybe.
113.
ನಾಳೆ.
ನಾಳೆ ಬೇಡ. ನಾಳೆ ಈಗ ಹಾಕಕ್ಕಾಗಲ್ಲ ಮೇಡಮ್.
Monday, my lord.
Passport.
Monday.
Both
That case Monday, my lord, 113, Monday at least.
11 and 113 list on Monday in the fresh matters list.
Number 107, my lords. I appeal for the respondent number 2 stay. Stay was granted saying the sub-register was not involved in the transaction. Court orders have been forged, persons have impersonated, and despite police notice, my lords.
Page, sorry, serial number?
107. I appeal for the respondent number 2 in this matter.
ನೀವು forgery ನಿಮ್ದೇನಾ?
Court order is there. Police is also notified the sub-register not to register.
ಏನ್
They
interim
forged
order
the
ಇದೆಯಾ?
court.
Interim order ಇದೆಯಾ?
Interim order is there.
ಆಯ್ತು.
I'm ready with for the final arguments.
We'll post it on, what to do is like.
Please.
24th or 25th ಯಾವ್ದೊಂದು ಕೊಡಿ ಮೇಡಮ್.
One more
Vacating
submission.
stay ಹಾಕಿ ನೀವು ಒಂದು.
Please, one more submission. The stay is only against the petitioner, but the police, despite clarifying that the word quay only means with respect to the petitioner, they are not.
ಅದು
they
ಕ್ವೇ
stopped
ಅರ್ಥ
their
ಆಗ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. Yes.
Investigation.
Serial number 99.
Wait. The serial number
Not 7.
107 ಅಲ್ಲಿ. List the matter on 24th. It is made clear that the interim order is operating only against petitioner, accused number? Accused number 4. Investigation or further proceedings against all the other accused shall continue. The police, in the garb of pendency of the subject petition, shall not stop conducting investigation against other accused.
Accused number 3, my lord.
Ah.
Accused number 3, my lord.
Interim order ilva? Yes, next year.
My lord, serial number 99.
Yes. They will grant time.